Good morning and thank you for joining us. I'm Lauren Baker. Today is the second day in the trial of former Grand Rapids police officer Christopher Schurr. He's charged with second-degree murder in the killing of Patrick Lyoya. Today we are continuing our coverage with crews all across downtown Grand Rapids, both inside and outside the courthouse, ready to bring updates as soon as they happen. Our 13 on your sides, Callie Lichter and Riley Mack, are inside the 17th Circuit Courthouse viewing the trial with live updates and updating our live blog on 13onyourside.com. And our 13 on your side political reporter Josh Albertus is outside the courthouse monitoring any demonstrations or public reactions to the trial. Like yesterday, we want to remind you that you are all watching the news that we deliver to you on our live stream on a court-mandated 30-minute delay. So what does that mean? Well, 13 on your side was instructed by the judge to stream the trial on this delay so that any sensitive information that was not supposed to be broadcasted, like personal details, can be redacted before it's put on air. There are no other modifications to how we deliver this trial, and we will remind you about this delay throughout the day. As we mentioned before, we are on a 30-minute delay, but we have got confirmation that Christopher Schurr is in the courtroom right now. He is waiting for trial to begin. But let's talk about the jury. The meaning of the fate of Schurr lies in the hands of people from our community. Jurors were sat after nearly 2 days of interviews and selection last week. 13 on your side's Callie Lichter was in the courtroom for the moment they were sat. She has reactions from both sides of the trial and the makeup of the jury.
After more than 10 hours of questioning, the jury deciding the fate of former Grand Rapids police officer Christopher Schurr is decided. The defense and the prosecution chose 14 jurors out of 45 potential people questioned and 200 initially called in. For privacy purposes, jurors' identities have to remain anonymous, but information about the jurors is available. Out of the 14 chosen, 4 are men and 10 are women. When it comes to racial diversity of the jury, 10 jurors are white, 3 are Hispanic, and 1 is half black, half white. Out of the 3 Hispanic jurors, 1 is a South American immigrant. In the dozens of random potential jurors interviewed, a large majority were white. An observation also made by City Commissioner Robert Womack, who has been supporting the Lyoya family throughout the process.
One of the things gave me pause that after watching these days, I only saw one African American that was interviewed in these last 48 hours. So we still have to do something when it comes to the jury pool to have true representation.
The jury also ranges in age. A few jurors appear to be in their early 20s, with 1 in their 60s or 70s. Matt Borgula, Schurr's attorney, says the demographics of the jury do not matter. It's how they answered questions.
What is a concern is, what's been their experience as a citizen of the United States, and whether, because they're going to bring that in to jury deliberations. And
even though a lot of the jury pool has seen or heard something about the case, Borgula believes they just need to be impartial and fair to the evidence.
Because both sides wanted people that didn't form opinions about the evidence. They wanted them to listen to it fresh, as if they never heard anything before, and draw conclusions based on what they hear in the trial.
Kent County Prosecutor Chris Becker did not comment on the case.
And those jurors were able to actually hear the opening statements and first witnesses of this trial. Joining me now is Emily Scarlett and Tanner Holbrook. You guys have been watching this case since yesterday. What are kind of your first thoughts?
Well, I was really interested to see what was the turnout going to be outside of the courthouse this morning. Of course, I was live outside the courthouse yesterday morning ahead of day 1, and right around 5 a.m. we started to see the first person roll up, and then by 5:30 we were starting to see really groups of people. By 6 a.m. it was pretty crowded outside the Kent County Courthouse. I was wondering if that would happen again this morning. It didn't seem like we saw the same amount of people showing up there ahead of court starting this morning.
Yeah, so this morning the scene when Erin Sullivan was out there reporting live for us this morning, she was talking about how maybe there were 3 or 4 people in line. They were let in around 6:30 as they were yesterday. And then during one of her reports this morning in the 6 o'clock hour, I'd say probably about 6:45, we saw a group of men walk by who she identified as potential Christopher Schurr supporters. And so we did see a showing, according to her reporting, that there were Christopher Schurr supporters out there early this morning. But again, as far as the turnout for court this morning, and many people may have trickled in after the fact, but from what we saw, yeah, I was very shocked that there wasn't more of a showing. And again, it's just over 20 seats that the public can take in that courtroom.
Yeah.
So very interesting on day one versus day two.
Yeah, and I still expect that it will be active outside the Kent County Courthouse. It's just interesting with already us making it to day two that we're not seeing the same amount of maybe enthusiasm, for lack of better words, with people showing up bright and early ahead of court starting at 8:30.
And I wonder if maybe those people are just finding that they can support in different ways. I know that we've posted on social media about this trial, and we have seen a lot of support, especially on Facebook, commenting on what side they're on. So maybe they're saying, okay, we can step back a little bit, support in a different way.
I also think that the purpose of the stream, it kind of helps that along a little bit. You know, people can watch and draw their own conclusions from home, not necessarily having to be lined up early in the morning for the courthouse, or, you know, they can obviously support just outside the courthouse. But again, to your point, social media might play a big role in that as well.
Most definitely. And, you know, we also got the chance to hear both the defense and prosecution with their opening statements. It's in a nice way to say, it came out with a bang. We had 2 objections from the prosecution to the defense in their opening hearing, and we talked to an expert. They said that's typically normal, but still I think kind of shows the passion that's happening within this case.
Yeah, remember those objections being about at least Becker saying, hey, she should not be arguing the case at this point. These are just our opening statements, and there were concerns, at least from the prosecution, that the defense was beginning to go ahead and starting to make their arguments for the case versus just those opening statements.
Yeah, the opening statements really are a time for the prosecution and defense to lay out their case going forward. You know, what is the jury going to hear? What are the facts that they're going to lay out here? And again, to your point, you know, they were arguing that the defense here was trying to kind of argue their case already.
Sort of jump the gun a bit.
Exactly. But you did hear very compelling arguments from both sides, or opening statements, I should say, from both sides. You know, obviously Chris Becker painting his case as the prosecution, but again, the defense coming out right away with, I want to get her name right, Michaela Hamilton, coming out and automatically going into what you would be hearing in some of the videos and some of the dash cam, body camera, and the bystander video that we did hear yesterday. One of the notable things that she said right off the top was, drop the taser, let go of the taser. She shouted that at the jury. And again, this is what we should expect from an opening statement from both sides as they're looking to lay out that case.
Yeah, that taser, a big part of the defense's argument, essentially saying that, you know, that taser played a big role in the threat that they're saying Christopher Schurr was under, while some people are saying, well, a taser does not, you know, pose a life-threatening or a fatal threat per se. The defense was arguing that put in the wrong hands or used in someone's hands that haven't been trained properly on using that device, the defense is arguing it then makes that a deadly weapon, and therefore, you know, adds to Christopher Schurr's argument that he was feeling that imminent danger or that imminent threat. The prosecution, on the other hand, in their opening statements, at least what I took from them, was that they were admitting, you know, hey, we're not saying Patrick Lyoya was perfect. We're not saying that he didn't do anything wrong in this case, but did he deserve to die?
And it was interesting to see how both of them used the taser, actually explaining. You saw Becker pick up the taser in what looked like a bag, evidence bag, to talk about it, but then you saw Ms. Hamilton grabbing and holding the taser, almost kind of bringing life to the situation for the jurors.
Yeah, right there in that opening statement again, she had it and she was like, this is what we're going to be talking about. And again, we don't want to offer speculation as we are the reporters covering this trial, but we can speculate in terms of what we might look forward to seeing in the rest of this trial, as that taser seems to be a central argument going forward for both sides here. We'll just see where it ends up at the end of the trial.
It'll be interesting to also hear from the experts. They both talked about how they'll be bringing experts, a lot of them with police backgrounds. So it'll be interesting to see how those ideas maybe conflict with each other in those questioning.
Yeah, it's something that we see in trials time and time again, right? That essentially both sides are typically able to find experts to go along with whatever their story is or whatever their argument is, to your point, that we might even be hearing experts contradicting one another, because what you're likely going to see is on both sides them bringing people in who say, I'm an expert in this area and it could or should happen this way. way and maybe hearing something completely different on the other side.
I think that's what I'm looking forward to most is the expert testimony here. You know, we did hear from some of the witnesses, some of the most compelling testimony came from that man, I want to get his name right, Wayne Butler. He owned or lives at the house in which one of the lawns where the struggle ensued between Schurr as well as Leoya here. But his testimony was very compelling, but again, the expert evidence or the expert testimony here, I think is going to provide a lot of context to what the situation is, not only on both sides of the, not only for the defense, but also for the prosecution. And of course, I really am curious to see if we're ever going to hear a question from the jury. Again, that is something in this trial that the jury is allowed to do. They're allowed to question the attorneys here. They're also allowed to question the jury here. Something that I don't think we've seen pop up just yet, but again, always keep that in mind that the jury can ask their own questions, an unusual step for the trial at this point.
Yeah, we had talked about that yesterday. I'm sorry.
No,
Lauren,
go ahead.
But you mentioned hearing the judge question the jury
Yeah.
after, you know, the defense or prosecution had spoken with one of the witnesses. We did hear that pop up at one point during the case where the jury was asked, you know, hey, any follow-up questions? But we never heard from them.
Not yet, and I think that's going to be really interesting to hear what questions the jury might have, if anything. Again, they really haven't asked any questions, you know, whether that means that they had all of their questions answered or not, we can't say that, but of course we want the jury, or are looking to hear from the jury today in perhaps what questions they might have for either, again, anyone who's on this witness stand or the prosecution or defense.
It'll be interesting to see how those questions play into how these lawyers actually react to those questions. We
Yeah.
just spoke with a expert yesterday who talked about how cases like these can take a life of its own, because when you have jurors that are able to maybe ask questions and kind of change how lawyers are thinking about the case, it could really change the perspective of things in the courtroom. So it'll be interesting to see how all those things change.
Also the timing, right? You know, if the jury asks questions, that could extend the time of this trial. We're guessing anywhere from 2 to 3 weeks this trial could take. We were talking on here about 12 minutes ago before we got on the live stream, just what we thought and how long the trial might go. You know, it's really hard to say at this point, but again, the jury could really prolong the questioning here if they choose to invoke that rule that Judge Mims has allowed them to.
And Callie spoke to an expert yesterday. She said that the pace of this trial is actually going pretty good, which she was.
I mean, eight witnesses,
yeah,
right?
Right. So, you know, that could also play a factor. Is we have a good pace right now, and then if jurors start asking questions,
Right.
does that derail things?
Well, I was surprised even with opening statements. It seemed like the prosecution went by like in a couple of minutes.
Yeah.
The defense taking a little bit longer, but of course we've been saying since the start of this that we know the defense has about 40 witnesses that they have to potentially call, just about 11 for the prosecution. And as Tanner just said, we got through about 8 of those yesterday. So to that point of this moving along quickly, I think we're all expecting that the prosecution at least could rest its case today.
Yeah, it's very interesting, you know, 2 more witnesses that we have left to call. I want to draw your attention, though, to Wayne Butler. I keep bringing him up because I do think that he added a lot of color to the testimony here. You know, his account of events, I think, really seemed to be central to the prosecution's argument. And then when the defense cross-examined him, they were really honing in on the exact events that were occurring during the time of the video. And they even played back that video and had him recount his story with a laser pointer. So very, very interesting. We actually have a little soundbite from Wayne Butler, if we can take that.
How are they positioned? What exactly did you see?
They're like maybe say 3 to 6 feet apart, and he deploys the taser, and then Patrick kind of gets it in his chest and kind of like pulls it out, and then they re-engage, and then that's where he's trying to like keep the taser down.
Who's trying to keep the taser?
Patrick was trying to keep the taser, like he was trying to like keep the taser away from him. And then I ran upstairs to go get my phone like the other gentleman.
Why
And
did you do that?
because I didn't know that there was anything else that I could do at this point. I felt like I talked to the officer, I talked to Patrick. And maybe I didn't. Maybe there was more I could have done, but
You say you talked to the officer. What do you mean by that?
I just told them both. I just said, hey, stay down, just relax, chill. Hey, get your guy. I was just trying to calm the situation. And I think when I went upstairs, if I didn't go upstairs, I think if somebody had been there to oversee the situation, it might have not. Yes, so I ran upstairs and I actually timed myself like before, just so I'd have like the proper information for the jury. And it's like 7 seconds, like 1, 2, 3, 4, grab my phone off the bed, run back downstairs. And by the time I got to like the third step, I heard the pop, like the third step from the floor. I heard a pop, and then I looked, and then he stepped back and he said, "Officer involved shooting."
And just right there, you can just see the emotion that someone who has seen this. I mean, I think that we sometimes in these cases, stick hard to the facts because that's what's important, right? But when you have someone like that coming on and talking about saying he grabbed his phone because he thought that's what he could do, it shows the reality of this situation for people watching.
Absolutely. And again, I was looking at, of course, some other media outlets and what they were reporting and how they were describing the case for themselves. And they seem to be right in line with what everyone is kind of thinking. He was a key witness for the prosecution here in terms of the descriptors, the colorfulness of his language, and just how he was describing and recounting those events there. So very interesting to see how his testimony will play into the entire jury and the entire role of the court at this point.
Yeah, what I found really interesting about his testimony was obviously the emotion, a lot of emotion from him, but this sense of responsibility from him, even as he was recounting that day, him feeling this pressure on himself. What could I have done? There was nothing else I could do besides grabbing my phone. This battle within himself that he should have done more, which, of course, I don't know that anyone was leaning on him to step in that situation. But watching him rewatch that footage, you could hear his breathing change. He was breathing heavily. I think even the defense asked if he needed water. Right. He was visibly shaken, being in this situation and having to relive that situation.
And you can actually hear the judge at many times, or the prosecution defense, having to actually re-ask the question to him because of just how emotional he got, and just saying, "Hey, can you just answer this question?" Just very straightforward. Again, just showing how complicated the situation can be for a person. Another thing they brought up is how impartial he is. He's just a neighbor. He doesn't know neither Schurr or Loyola, so his input truly is an unbiased viewpoint of this, because he doesn't know either person, and at that point doesn't even know the situation.
Yeah, well, so to your point, how impartial he is, both the prosecution and defense made points to say that, and there's a soundbite that we've pulled that you will hear a little bit later on in the day, that from his testimony, where he is at the end of his description of what was going on, and I do believe it was the defense attorney there, and he was basically saying, "Thank you for answering the questions to how you know them, not what you are speculating." So that goes to show just how impartial he really was trying to be in his testimony there, and of course the appreciation on both sides of the benches there.
I also think his testimony spoke to the reaction that some people in the community have, right? This happened shortly after the George Floyd protests and other situations happening. And at one point he said, "I'm a black man in America. I know how this could end." And it's not to say that he's on one side or the other because of that, but just that thought process kind of shows how people in this community may feel about this trial.
That was such a powerful moment, Lauren. I remember that because he said, watching that struggle between the two, he knew someone would end up dead. He even feared for his own life, worried about his position and where he was in that fight, worried that a gun would eventually come out and that someone was going to lose a life in that situation.
But he's not the only person we heard from, right? The first two people were actually people that knew Loyola. And while they weren't as emotional, they kind of painted the scene of the day before that he was shot and the person who was actually in the car with him. I thought it was interesting to hear from their perspectives because they know Patrick Loyola.
Yeah.
They were maybe not talking about him directly as a person in their questions, but it was interesting to hear what they remembered. Even one of the people saying that it was 3 years ago, I can't remember certain things.
Yeah. So we heard from his two friends, David Bakuru, who's one of the last people to see him alive. That was how he was painted on the bench there when the prosecution brought him up for testimony. And then we heard from Amy Turishmi, another friend who had been involved with them the entire weekend leading up to that Monday morning. And Amy was actually the one who took that cell phone video as well. But I understand that we also do have some soundbite testimony from David Bakuru, who is that one friend, not the one who with the cell phone, but again, the one who saw him earlier that weekend. Let's listen.
David, did you know Patrick Lioya?
Yes.
Could you tell the jury how you knew him?
Well, I knew Patrick, pretty sure I met him around 2008, anywhere from 2017, maybe 2017. He was at the party.
Sorry, he was at what?
We was at the party when I first met him.
Okay, what party is that?
I think it was just a community get-together party, and then that's when I met him, and then after that, we went to a friend of one of friend of ours, and then he was a really good kid, and then we started to communicate. We exchanged number, and then time to time he would come to my house. I would go to his house. We were pretty good friends.
When you talk about a community party, was he a neighbor of yours then? What community are you talking about?
Well, I'm from Africa, sir. So time to time we have like events, so we will meet and then have a good time.
All right, so you're talking about community. Was the African community have events and you met him at one of those African community events, not in a neighborhood?
No, it was an African event.
So I'd like to take you back to the last time you saw him. When was the last time you saw him? Do you recall that day?
The last time I saw him was when he got shot. I mean, when about 30 to 45 minutes before he got shot.
Okay. How did you see him 30, 40 to 45 minutes before he got shot? What was going on?
Well, he was in my house. He slept over at my house. Slept over at my house that day. So on that Saturday, we had a party. There was I usually host a party. A friend of mine, he do host a party on Saturdays, and then he was at the party. He came after the party. He came to my house. So he was on Saturday. That Sunday, we were just home, listening to music, and then in the morning of that Monday, he had told me that he had to do something early in the morning. So, I woke him up around 8, if I remember correctly.
Again, this wasn't a testimony that was very emotional. We didn't see any pain or gestures, but what we did see is someone kind of setting the scene for people who don't know what happened the hours before, in this case, 30 minutes before Patrick Lioya was killed, to set the scene.
And one small bit of emotion that did come out of his testimony, I think it would have been shortly after we stopped the tape there, was him too, taking on his own sense of responsibility and what role he played in that day. He actually mentioned that he regrets waking him up that morning because he says that Patrick Lioya asked him to wake him up that morning for something he needed to get done, and that friend, Patrick, was staying over at his house, that night and the morning leading up to the incident. That friend saying, I wish I had never woke him up that morning.
When it comes to one of the main points that they spent a lot of time on, and I'm saying they, but I'm talking about the defense and the prosecution, they spent a lot of time on the events of that weekend and if and what they had been drinking that weekend and what was their level of intoxication during this entire incident that played out. Again, in the Chris Becker opening statement here, the prosecution saying, he even acknowledged, you're going to find out that they had been drinking. They had a blood alcohol of almost 0.30. Defense attorney Michaela Hamilton also expressing that same sentiment, saying that you're also going to find out that evidence. And they spent a lot of time re-asking the same questions over and over to both Mr. Bakuru and Mr. Turishmi about what those events actually were, how close to the actual incident were they drinking, and what their state of minds were at the time of the situation. And again, that was just a point that was hammered over and over and over on both sides.
And something that we talked to Andrew Rodenhouse, an expert that spoke with us yesterday, is that those testimonies didn't really damage or help either case. What it really did is just kind of set the tone for the whole entire trial so that people could understand. And I thought that was an interesting take because I think a lot of times when we watch these cases, we expect that every witness is going to come with some explosive testimony and that it's going to sway the trial one way or another. But in this case, it didn't really do that.
Yeah, I could definitely relate to
Yeah,
that.
we were talking about that yesterday.
After, you know, both the prosecution and defense would finish with these witnesses, at least the first 3 or 4, you know, at least from my perspective, you're left wondering, okay, what were we supposed to gain from that? What is the information we were supposed to get from that? And again, especially considering that the prosecution could rest its case today, you're wondering, will they, you know, tie up all those loose ends?
You also wonder what their arguments could be in the cross-examination period of this. You know, when Chris Becker has his chance to examine the defense's witnesses here, and again, there are some 40 of them that they could call. Not all of them have to testify here. But again, when Chris Becker has his opportunity to ask them questions, what is he going to ask? How is he going to play that into his case here as a prosecutor against Christopher Schurr?
You also wonder what role these witnesses play. You know, I think the one witness that everyone is waiting to take the stand is Christopher Schurr.
Right. And is it a question that he could or couldn't at
I
this
think
point?
at this point, it's still a question. I think there's been some indication from some people that they expect him to take. We've spoken to an expert who says in cases like these, it's not uncommon for, especially self-defense cases, for the person to take the stand to self-defense, to say, this is why I did this. So it's interesting to see how these witnesses could either set up or create a trap, or who knows if and when Schurr takes a stand.
Well, self-defense is kind of what the defense attorneys have been kind of angling their entire case at this point. In the opening statement there, Michaela Hamilton, the defense attorney, this is a direct quote, "He didn't choose to take a life, he chose to save his own," marking there that this was self-defense. And again, that is kind of their entire angle to this entire process at this point.
Most definitely. And I think that one of the people that we're going to toss to Ben Johnson now, who is actually the family attorney. Now, just for clarification for people who are watching, Ben Johnson does represent Patrick Loya's family, but this is for the civil trial. Right now, we're in the criminal trial. He was able to be in the courtroom with the family on day one. Let's hear his reaction from the first day.
What I think is really important is the jury, of course, see all of the evidence, and that's what Prosecutor Becker did a phenomenal job. I've showed the entire video of each, the doorbell, the body-worn camera, the on-dash camera of the officer, and then, of course, the cell phone video of the front seat passenger. And what you see is them, when you also synchronize all those videos, it makes it abundantly clear that Officer Schurr at the time was in control and on top at all times. And therefore, we believe it supports the only conclusion of the evidence, and that is that it was unnecessary for him to shoot and kill Patrick in that second that he had to do. But more importantly than what the video showed to me, or just as important, not more important, or what the factual witnesses who were there and what they said, right? And you could hear the gentleman who was in it was his front yard, and you could hear that he was believing that the whole situation was going to result in Patrick's death. And why would someone say that, folks? Of course it was going to end up someone dead, because it was a white officer with a black man who was on the ground. And so he was mortified. You could see how he was quite upset by the whole thing and didn't think it needed to be materialized the way it did from either side. That's what he said. And then you have the front seat passenger, and you can hear the front seat passenger saying some really important things that I hope you all include in your news reports tonight. And that is, he said to the officer, when the officer said, "Stop touching the taser," the front seat passenger said, "He's not touching the taser." And they stop fighting him. He goes, "Oh, you kicking him. I hate that, SH," is what he said. You can hear it on the video. So I think it's really important that we keep that into context when we're talking about this. You guys have heard from Dr. Cole, the forensic pathologist. Patrick had no significant injuries on his face or on the back of his hands, showing that he was aggressor whatsoever, and you all could see the injuries to Schurr were minimal at most. So to suggest that this was some major fight and that this was something that Patrick was trying to hurt Schurr is, as you all can see from the evidence now, it's wrong, it's made up, and it's not true.
When it comes to police officers, we have to at least first push that there is any due process. So it was a major victory just to see this go to trial. One of the things I noticed today was his training. as he said, Patrick Lyoya was killed because he feared for his life from the taser. But you can see in the training for Officer Schurr, he shot with a taser from his own partners. So he didn't fear for his life in training. And many of us who's going through any of that training and have ever been tased, after you've been tased, you don't totally fear for your life to the level that you think you have to shoot somebody in the back of the head. But that's for the public to judge. But I would point to some of the training where you actually get to see Officer Schurr being a taser used upon him.
One thing I want to make sure everybody's clear on, Schurr pulled the trigger of the taser twice. So there were no probes left. The only thing that was left was the potential for drive stun. We've talked about that, but you all saw it today. And drive stun means someone would know how to do a drive stun. Patrick Lyoya wasn't trained on a taser. He had no way of knowing about a drive stun. That means this taser was virtually useless to him in his hands, since all the probes were gone, and how would he know about a drive stun?
And some of the things that you just heard as they talk about the video, and we were able to see multiple views of the video yesterday. Starting off with the passenger, we saw his video from his angle, and you hear Ben Johnson talking about the things that he was saying in that video. And it's interesting to see how we're able to see from different aspects of this trial.
Yeah, I think you point out such a good point to remind us of the role of Ben Johnson, because as he's standing there, he was sounding a lot like he was on the team for the prosecution. So I think it is so important to point out he's not working with them. You know, maybe in a different capacity, he is representing the Lyoya family, as you mentioned, in that civil suit. But to hear him making the case there as he was, you have to remember he is not on the prosecution
Right,
team.
and he's arguably going to say, you guys saw this is how it's happening.
Yeah.
It's good to remember that that's just his point of view. It's the jury that has to decide that.
Yeah, it might also be the Lyoya's family point of view as well at this point. And he is obviously speaking a little bit on behalf of them, but also on behalf of his own account of what's going on. Again, very important clarification. Another thing that got brought up again, and again, it's that taser that we keep hearing about. Again, something that we expect to be central to the arguments on both sides here. And so I'm, again, interested to see how that plays out.
And I think that for a lot of people, there wasn't a focus on the taser, right? When you hear a shooting, you just focus on the shooting. So it's interesting to see how this trial is kind of opening up your eyes to all aspects of this case to help you understand, you know, why the defense is saying this and why the prosecution is saying that.
Yeah, this case also relying so heavily on these videos, right? From a couple of different angles. You've got the dash cam video, the body cam video, and then the passenger's video, some of which isn't the greatest quality, and yet so much of this is relying on what you're seeing in that video, what happened at this moment, where were bodies positioned at this moment. And even some of the audio quality, you know, Ben Johnson referencing what you're hearing the passenger saying, I didn't always catch all of that. So I do wonder how the prosecution and defense will use that and make clear what it is we're supposed to be seeing or hearing.
Because if you're asking that question, you know someone on the jury is as
Absolutely.
well. Also, I want to point out, so our live blog has just started on 13onyourside.com. You at home can follow along with it as it goes. So the live blog is live events on what's happening in court. Again, you are watching a stream that's on a 30-minute court delay that's mandated by the court. So you won't actually start to see the events inside the court chambers until 9:30. But I do want to point out something that Riley Mack just wrote on the blog that says, court begins Tuesday morning. The judge comments on a question that was passed to her from a juror during session Monday. Basically, she just says they asked for a break. So they must have passed that question to her during the session yesterday. And then as they asked for a break, she just didn't acknowledge it until this morning. But again, we should expect that's how, if jurors have any questions, that is how they will be getting that across to the rest of the court.
And I wonder if, because it was day one, they were all just soaking it in and just trying to get as much information. And now maybe on day two, we'll start to see those questions because they've had time to kind of process and understand, okay, this is what the prosecution is arguing, this is what the defense is arguing. Now I can start to think about some important questions to help me make my decision.
I can imagine that there's maybe even some pressure too, because this is such an unusual part of the court proceedings. It's not, you know, typical that we get to see the jurors play such a role in the proceeding. So I can only imagine how they're feeling. Do I want to stop things and pass this question along? Maybe they're feeling a little intimidated.
You also don't want to sound terrible in court, right? You want to
right.
know what
Is
you're
this a
talking
dumb question?
about. Yeah, exactly.
Yeah. It'll be interesting to see. And some of the other things that we were just talking about was the different point of views of the video. I think that for a lot of people, when they thought about this trial, we released the body cam footage when this first happened. So you only see the body cam view. But to see the passenger's view,
Right.
it's almost like you forget that there were people around when this were
Right.
happening.
Yeah, such a great point.
Yeah, the bystander video, which we saw referenced many, many times, and as I understand it, that was the video that circulated nationwide, where we were able to see, exactly what that David Bakura, or I'm sorry, not David Bakura, but Mr. Turashimi, what his point of view was there. It was interesting to be able to see that and see the live reaction from both Schurr, because we did see his face as that was playing out, but also the witnesses as they were playing that testimony for them as well.
Most definitely. And right now we have Andrew Rodenhouse from Rodenhouse Law Group. He is a trial attorney and graduate of Hope College. Andrew received his Juris Doctorate degree from Cooley Law School. We actually got to talk to him yesterday. Andrew, I wanted to ask you, now that you've seen the whole entire first day, what are your thoughts and reaction?
Well, good morning. Thanks for having me on. I am not surprised by anything that has transpired so far. It seems to be a very standard, what we would call a trial in a homicide case. We had the foundation set with the lay witnesses appearing first, the ones who are on scene, who took the original cell phone video. We then heard from the Michigan State Police lead detective on the case. And then we also heard from the Grand Rapids Police Detective. Interestingly, we also heard from the evidence tech, which the evidence tech is normal, but what was abnormal was that she actually knew Mr. Schurr, knew him personally, and during cross-examination revealed how he had changed, how his personality had changed since that day, and how he was normally very kind of a happy-go-lucky kind of guy, but when she was collecting the evidence from him and taking pictures of him, that she had noticed that his demeanor had completely changed. So I found that interesting, that little bit of personal information interesting. And then we heard from Dr. Cole. Dr. Cole has been around for years and years, decades actually, in Kent County, and he's kind of a legend among the homicide trial people, those of us who try a lot of homicide cases, and we deal with him quite a bit. He's a real straight shooter. He's a real professional, and so it was interesting it's always interesting to hear from him. He didn't really provide, in my opinion, a whole lot of extra context, just simply because there's no dispute about how Patrick died, a single gunshot wound to the back of the head from close distance. The only interesting thing was how close was the pistol to the base of his skull, and he was testifying about some stippling. And stippling is the discharge out of the firearm of the gunpowder and residue that goes along with it. And if it's from more than a few feet away, the stippling doesn't appear. If you're closer than that, you'll get a stippling pattern. And what was interesting that I found was that his testimony appeared to be that he thought that the firearm was pressed up against the base of the skull. There was a little bit of dispute on cross-exam, but there's not a whole lot that he provides other than that the prosecution has to have this person come in and testify because they have to establish every element of the offense. And that includes they have to establish that it was a homicide. And that's the only person who can really testify to that, professionally speaking, is Dr. Cole. And so I think we're on track. My understanding is they've got 2 experts they're calling today, and we should be hearing from them first thing this morning. I don't know what order. The one is going to be a person from Axon who manufactures the taser and stun gun, and to testify to its qualifications and kind of quantify for the jury what is involved in a taser / stun gun. I think the interesting part about I'm anticipating the interesting thing about this testimony to be the cross-examination. And I expect that the real fight is about to begin as far as establishing whether or not Chris Schurr was or was not justified when he killed Mr. Loyola. So that's my take on it so far.
And I do want to let people who are watching this know that the expert on the taser manufacturer is testifying right now. So it'll be interesting to see what he says. But I want to go back to the crime scene tech. You had said that it was interesting to hear kind of her say that she knew Schurr and kind of knew his personality. Does that hurt or help either the prosecution or defense at this point?
I think it helped the defense because, you know, one of the things that they have to establish is Chris Schurr's state of mind when he killed Patrick. And she's basically, by saying that, she's saying that he didn't want to. That's the demeanor, and that he if he didn't want to, but he had to. That's how justification works. He didn't want to kill this person. He had to kill this person because he feared for his own life. And so I thought that little tiny tidbit was incredibly helpful to the defense. And I found it interesting from the standpoint that it came out on cross, and that you know, I think she had a heartfelt moment there, and I would expect that landed with the jury.
And I also want to reiterate yesterday that we saw the lawyers before this actually it might have been at the end of this, they got not into a dispute, but kind of went back and forth about entering some information that could paint a picture about Loyola. I believe it was a warrant for a domestic violence arrest. But I want to ask, when you hear them go back and forth about entering information, but then you hear that, does that contradict what they were talking about before, or is this kind of like a loophole to bring in some reality to it?
So yeah, there's specific rules of evidence that govern, and this is what and I thought it was smart for Chris Becker to raise this at that point in time and to address it, because I think the very first witness said he was a nice guy. Okay, well, you say that about your friends, right? And what the defense team was going to try to do is use that as, hey, they opened the door to this to the decedent's character. And I thought Judge Mims handled it very well also, from the standpoint that this is about what Chris Schurr knew. If he knew that the person had a violent past, then it would be relevant. But if he doesn't know about it, and he doesn't know about if he had open warrants, but I also found it very interesting from the defense team is that initially this motion had been argued outside, or had been argued in open court, but nobody covered it. There wasn't any media present. And so from the standpoint that this case is also being tried in the court of public opinion, I thought that it was a good strategic move by the defense to raise and to state what exactly they believe to be the facts regarding Patrick's background. The fact that he was on bond at the time of the offense for an OWI third out of Allegan County is what I heard them say. And I heard them say that he had was on probation for an OWI out of state, and that there was an active warrant for aggravated domestic violence, where that requires medical treatment. And normally, what I heard was that alleged victim had to go to the hospital. And so from the standpoint that the defense team was able to get some of this information out into the court of public opinion, where the people sitting at home who are wondering, you know, what is the truth. But then again, the prosecutor, I thought, did a great job of keeping the jury protected, because it's the jury that can't hear this evidence. And so that's why, and that's, if you go back to the beginning, the judge in standard instructions told the jury, don't go on media, because you could hear things that that you shouldn't hear, and they are not being screened through the filter of the rules of evidence. And the rules of evidence are what is designed to give a fair trial, not just to the defense, but also to the people. The people have a right to a fair trial. And so from that standpoint, I thought that everybody handled it right. I thought the judge handled it properly. If and she said this, if, you know, we find out that Mr. Schurr did have knowledge of this, then potentially we could revisit the issue. So if Chris Schurr took the stand and said, yeah, I saw that he had active warrants. The other interesting thing is that, and maybe it's for a different time, but police officers in general, if they're involved in an incident, they don't have the right to remain silent like a citizen does, and they're forced to make a statement or give a statement, and it's what's known as a Garrity statement. Those statements can't necessarily be used against an officer unless the officer were to take a stand and testify differently than what his Garrity statement was. They could use it for impeachment, but Chris Schurr has given a statement on this already to somebody. He would have been required to. What that statement is, I have no idea. Those are held to be confidential and privileged, and can only be used if he takes a stand and testifies differently. So it'd be interesting to know what exactly Mr. Schurr knew when he effectuated the traffic stop. He knew that there was a wrong plate on the vehicle. Undoubtedly, I mean, somebody that has an OW or somebody has a blood alcohol of over as high as he did, I forget what it was. I think it was really high, like almost a 0.3. That he would smell of alcohol. It would be obvious to a police officer making a traffic stop, and he probably was going to just go and initiate an OWI investigation. And it's possible that he knew that he had an open case out of Allegan or an open case out of state, because that would potentially be in the law enforcement information network. But then again, he didn't necessarily know who this individual was that he was dealing with either, and so all he knew was that there was a bad plate and that the driver of the vehicle. So I don't know when he was able to identify who exactly, if he knew whether this was this specific individual or if he was just conducting a traffic stop and was going to find it out later. And that's why the judge made that ruling the way she did. So I hope that clarifies it.
It definitely did.
Well, Andrew, I'm so curious to get your take on jurors being able to take part in this trial and ask questions as needed. You know, how unique is that to a trial, and how do you think that could potentially change things?
Well, so first of all, it's not unique in the state of Michigan. Michigan actually has a court rule that allows it. Michigan is unique in the country, as in we're what we would say a minority jurisdiction as it pertains to having the jurors ask questions. Not every judge allows the jury to ask questions, and Judge Mims does. And I go back and forth between whether or not I like it personally, but it's not what I like personally that matters. The judge allows it, and that's fine, I guess. But the questions that the jurors ask are still subject to the same limitations as any question a lawyer might ask. So a jury couldn't ask a question that would elicit, say, hearsay testimony, or would ask a question that would get into evidence that otherwise wouldn't be allowed if an attorney did it. And so the questions are reviewed by the judge and the attorneys. The judge calls the attorneys up to the bench. We discuss the question. Sometimes we rephrase the question, like we know what they're getting at, but we got to ask it in a certain way that conforms to the rules of evidence. And so that's how that's handled. It's unique to Michigan. It's not unique inside the state of Michigan. All the courts are allowed to do it if they choose to, and the judges have that discretion.
Interesting. I have a question for you, Andrew. We've heard 8 witnesses take the stand from yesterday, 2 of which were Leoya's friends, and then we also had 2 of the residents in nearby homes. I'm curious, and of course, obviously, we had the experts that took the stand as well. I'm curious to get your thoughts on whether you think that the prosecution has so far gotten their point across with those witnesses, or do you think they still have work to do when the defense starts to call their witnesses?
Oh, they've definitely got a lot of work to do. So yesterday was just laying the foundation for everything that's going to take place today. And I was watching a little bit on your show this morning, and yeah, there's a lot of loose ends out there that still need to be tied up. And Chris Becker is a very experienced prosecutor. He knows that. And that is going to be what he's going to attempt to do with these next witnesses. But he has to get the evidence in first, because the expert witnesses are not allowed to opine on evidence that hasn't been admitted yet. And so they have to get the evidence admitted so that the experts can opine on what they think the evidence means. And so you just got to start at the beginning, and Mr. Becker's following a very standard prosecutorial playbook. It's very formulaic. They all go to the same prosecutor schools that are where they learn to prosecute cases, and it's just a standard timeline of events. We had this thing happen. We got collected evidence. We, got body cam footage, dash cam footage, and we got all this stuff. And now the experts are allowed to come in and opine, give their formal opinion. They're the only people that can really give opinion testimony as somebody that's been qualified as an expert. So they can give their opinion as to what they think the evidence means.
And Andrew, I want to ask about winning and losing the day. I know that a lot of people who watch court cases, at the end of the day, they always wonder who won the day, who lost the day. I know it was only day one, but is there any side that really stuck out, or is it pretty even still?
I know that that's a common thing for people to talk about who won the day, but it's not. Who cares? You can win all the days except for the jury verdict, and then you lost the whole trial. And so you have to win at the end, not on a daily basis. And so when I'm watching this isn't a win or lose. It's just getting the evidence into in front of the jury so that later on we can argue what we think it means. And again, it's the experts and then what the lawyers are going to argue what the evidence means. And that's what the jury's going to have to do, is take the evidence that they've heard and apply it to the laws given to them by the judge.
Well, Andrew, we really appreciate you coming on again and kind of breaking down some questions that we had.
You're welcome.
A lot of great information right there, guys.
And I think this is a good time to, again, explain to the viewers why it is you aren't seeing the trial right at this moment. We've been explaining this over the last few days, but we're under a court-ordered mandate of a 30-minute delay, but that also is based off of when trial actually begins. It's supposed to start each day at 8:30. We've seen some delays here the last couple of days. I know we were able to start streaming around 9:10 yesterday morning in accordance with that 30-minute delay. A little bit more of a delay today, and we're hoping to start bringing that trial to you in less than 10 minutes.
Yeah, so again, if you can't watch that live stream there, like how you're watching us, it is on that delay. You can get the most up-to-date information on 13onyourside.com. Riley Mack is in the courtroom. She's doing a great job of keeping up with what's going on. And so that first witness took the stand at 9:01. So about 22 minutes ago. That means at about 9:31, you will see the testimony that this Mr. Brian Childs of Axon, which is the Taser company that we've been hearing about, will be taking the stand. So you're going to hear that testimony here in a little under, I'd say, 7 or 8 minutes.
It's interesting because, like Andrew just said, I think that's the one that people are waiting for, at least those type of experts that kind of really break down. Because like you said, day one was just kind of setting the scene. Now it's really when this trial gets going.
Yeah, that made me sort of anxious to see, what will we see today? The way Andrew phrased it, they were just setting the tone. It maybe seemed kind of like boring information. This was just by the book of getting that information to the jurors so that the experts could then give their opinion on what's being presented. So it's sort of like a step-by-step thing they have to follow in order to get that information to the jurors. He says today is when we really should sort of see the meat of that case.
Yeah, the other thing too, I'm really glad that he made the clarification on the question rule, right? Because we were reporting it on our blog as this is unusual, and he did clarify it's unusual across the country, but not for Michigan. And again, he made that other clarification about the judge really has discretion over that in the state of Michigan. And in this case, Judge Mims has allowed the jury to participate in that way. Again, this is not something that she had to do. She allowed them to do it. But again, it's a really important clarification. Still, I think for many people, this is an unusual move, though. This is something that we really don't see. If we do see it, I don't think it's really made public many times.
And I'm glad he also clarified winning and losing the day. I know I'm one of those people where I'm like
who
okay,
won?
Who won? Who made
exactly.
the great wins?
Yes.
But it's good to remember that this is a long trial. You can't win every single day. It's about everything at the end. So I think that would maybe help people who are watching this trial to maybe not get worked up so quickly or feel, either way because they know that they have to wait.
Well, I know during testimony yesterday, you and me were listening to it in the newsroom, and we're like, all right, so we're laying the groundwork. We're both asking the question, where are we going with this? I even talked to my mom later in the day. We were talking about the trial and just saying, okay, so where do we think we were going with this on either side? And to Andrew's point, they're just laying the groundwork at this point.
It feels very much like a slow crawl to get to the information. But again, he's saying this is part of the playbook. They've got to lay out those steps in this way so that everyone understands in the right way. I think many of us are used to the true crime shows that we watch, or even the drama series where
very quickly.
you get the highlights, you get the smoking gun in the case. But no, this is more of that slow crawl where we're going to get all the details before they get to the meat.
Well, when you hear, there are more than 40 witnesses just for the defense alone, you start to think, oh my gosh, that's a lot of testimony. Again, not everybody is going to take the stand, or we don't expect everyone to take the stand.
And we got through 8 yesterday.
And we got through 8 yesterday. But you think about that and think about how the jury has to digest all that information as well. So that part in and of itself will be very interesting to see how it plays out.
And I think this streaming is also going to help people because, like you said, when we watch Netflix, crime, documentary, we don't see the whole thing.
Right.
But people are able to watch the whole thing so that way they can better understand the outcome. Because I know there are some people who watch documentaries are like, how could they miss this? Or why didn't they say that? But they now have the opportunity to answer those questions for themselves.
And see the full process.
Yeah, the transparency I think is really key. You know, I don't think that we are getting that transparent process a lot of the time. Well, I mean, we see it because we read the court documents in many trials and cases that we cover, but this allows everybody to kind of see all of the cards played, laid out on the table in one easy way.
Yeah, now we're just under almost a minute to go. Any final thoughts from you all or recollection from yesterday?
I'm just curious to hear today's testimony. Will we feel like they're getting closer to piecing together this puzzle after yesterday's slow crawl of just sort of laying out the details?
And I think you are right. I think we are going to start to learn more of the pieces to the puzzle here. Just based off of what I'm reading from our live blog right now, we're getting into that Taser testimony from the company Axon that makes the Taser. And so, of course, we're going to hear from that witness here in just a few minutes. Of course, they started about 26 minutes ago. So, we're going to hear that testimony, and I think that is one of the big things that the prosecution and defense will be honing in on.
It'll be interesting to see because obviously this person was put up by the prosecution. We're getting word now that the judge is walking in, again, on this 3-minute delay, that they are walking in, but proceedings, you see right there, Judge Mins is getting ready to start.
Yeah, this happened 30 minutes ago. Again, because of that court-ordered mandate for us to stream 30 minutes after, we're now showing you what has been happening with court starting really about 30 minutes ago.
And that is that one of the jurors had a question when Dr. Cole was testifying, but the question was that they needed a break. So it said they needed a 5 to 10 minute break. So obviously it wasn't a question for the witness. That's what I stated on the record, but more specifically, they requested a break, and because we were ending for the day, I just didn't address that question yesterday. So with that, is there anything we need to address on the record before the jurors come in for the people?
None to me, Your Honor.
For defense?
No, Your Honor, thank you.
All right, so we'll have the jurors come back in.
Brian Child.
Sir, before you take your seat, raise your right hand or circle swear you to. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated. Interview ready.
Thank you, Your Honor. Sir, could you state your name and spell it for the record, please?
Yes, my name is Brian Childs, BryanChiles.
And what do you do for a living?
I am the senior manager of Axon Forensics at Axon Enterprise.
And what is Axon Enterprise?
Axon Enterprise is a technology company for law enforcement. We're mainly known for providing taser energy weapons and body-worn cameras.
And what are some of your responsibilities in the position you hold?
My responsibilities are running my department, which conducts forensic investigations regarding taser energy weapons or body-worn cameras, pretty much anything in the Axon ecosystem regarding the logs or physical evidence, putting the story together from the device's perspective, and then producing a report.
Could you give the jury a little bit of your educational background on how you got to be a senior taser Axon administrator?
Yeah, so my education is in electronics. I have my associate's degree in electronics technology. Most of my experience is work experience. I'm a test engineer at heart, so pretty much went into electronics, but mainly focused on test engineering. And then throughout my career at Axon, I shifted over to forensics and doing forensic investigations.
Can you tell the jury a little bit, what is test engineering? What exactly is that?
Test engineering is designing tests for a certain product or widget, anything. It's designing how to test it properly to test the device's limits, make sure it's doing what it's supposed to do, making sure it's durable, weatherproof, et cetera, et cetera.
Now, is that kind of how you started at Axon?
I actually started in research and development as an electrical technician, and then within a year, I started the validation team, which is validation testing is basically what I described. It's taking product or designs and put them through the ringer, electrically, mechanically, environmentally, to make sure the product does what it's supposed to do and will survive the elements that it's going to be in.
And describe your career path. What have you done after that? So you went into test engineering. What did you move up after doing the test engineering type
Yeah, I ran the validation team for about 10 years, and I shifted into compliance, and also in 2013 I started doing the forensic investigations. Pretty much wearing two hats. I was in charge of compliance and in investigations. In 2020, I took full responsibility over investigations. That became my full-time position.
So when you talk about investigations, you're investigating tasers and body cams and just about anything that Axon produces, right?
Correct.
I guess maybe focusing specifically on the taser, do you have an idea how many taser type investigations you would have done in your career with Axon?
I don't know an exact number, but it's over 500.
And those are from across the country?
Global.
Global, okay. So
Yes.
Anything across the world, they may send it to you in terms of looking into what happened with a taser or a body cam.
Correct.
And in terms of those, you've done it globally. Have you ever testified as an expert in the taser and body cam area in court at any point in time?
Yes.
How many times have you done that?
Approximately 70.
Okay. And that, once again, is that global or is that just the United States?
That's US, Canada, and the UK.
Okay. At this time, I move to have his testimony introduced as an expert in the field of taser and body cams from Axon. No objection.
All right, you shall be considered an expert in those fields.
I guess maybe we'll start off and get a little idea. I'm going to show you what has been kind of marked into evidence as Exhibit 23. Can you tell the jury what this is?
This is a Taser 7 energy weapon.
And tell it what Taser 7. Why is it Taser 7? Is there different versions of Taser then?
Yeah, there's several models over time, and Taser 7 was our 7th iteration of the design.
So what Taser are you at now?
Right now we're on Taser 10.
Okay. So this is an older version. When did this version kind of go into use, if you will?
This one was released in 2018.
Can you, maybe if you can show the jury in terms of what describes some of the things on, it kind of looks like a gun. Is it a gun?
It is not a gun. It is not a firearm. It is a handheld device, the shape of a gun for the look and feel of it. It has a grip. This part is where the battery pack will go in. It has rechargeable batteries. Has a safety switch, which is ambidextrous, so it can be used left-handed or right-handed. And then a trigger switch here. And then also on each side, there's a button on the side that is called the arc switch. I'll get into more technical what each one does. We also have cartridges that install in here. There's 2 cartridges. Each cartridge has 2 probes. So there's 4 probes total. What else? We have cartridge release. That's essentially it. There's a high voltage section, and then pretty much the microprocessor and the smart section of it.
Maybe talk a little bit more. You talk about a safety switch. The safety switch, it's on there. What is that designed to do?
So the safety switch arms the weapon. So it turns it on, powers it up, but it does not activate the high voltage yet. So it just puts it at a ready. If the trigger is pulled or the arc switch is pressed, then it will activate. Also with the safety switch, laser aiming will turn on and a flashlight if it's configured.
Now, what is a Taser designed for? What was the purpose of a Taser?
The overall purpose of a Taser weapon is to inject electrical signal into the human body or animal and override the central nervous system and tell the muscles to contract. So when activated, it produces high voltage pulsing, and that pulsing, if delivered to the body, will be received by the muscles, and all of your muscles, all movement that you make is done by electrical signals from your brain. And so what this does is it puts an electrical signal on the muscles, and the muscles say, oh, I need to contract. So they contract and then release. But the weapon does it 22 times per second, so it causes a rigid muscle lockup if you have enough muscle receiving that signal.
Okay. I'm going to go and maybe help a little visual in terms of how this works. The play what's been stipulated to is Exhibit 22 of the people, Your Honor. Okay. Dim lights. And you've seen this your promotional video for the Taser 7?
Yes.
And you recognize it?
Yes.
All right. I'll go through it and I'll ask some questions. That was a promotional video, that's why you got that kind of cool music and everything, right?
Yes.
Now going back a little bit, I think there's some things that the jury maybe should. Can you describe, when you talk about these cartridges, you got the probes, if you will, can you tell the jury what they're looking at here?
So what we're looking at here is the probes coming out of the cartridge. How that works is inside the cartridge there's a nitrogen gas capsule, excuse me, about 2,500 psi of nitrogen gas. When triggered, there is an electrical signal sent to a primer, which that explodes internally, and that creates pressure and pushes the gas capsule into a puncture pin. That ejects the air, the nitrogen gas, out of the capsule, going down these channels, and pushes those probes out. So it's not gunpowder as a typical firearm. The probes are launched via compressed air. The wire in the probe, the wire is actually wound inside the probes. So the metal pieces there, the wire's coming out of them, spooled inside them. And it's tethered to the cartridge, which is electrically connected to the weapon. And then the wire is attached to the probe tip.
So in terms of these probe tips, that's what's got to go into the person, if you will. Is that a fair statement?
The design is for it to go in, but the whole point of the high voltage of a taser weapon is to be able to arc to the skin, to jump through the air to the skin if the probe is close enough. So even if it doesn't penetrate the skin, it can still make a connection.
I just want to say for the record that he was testifying from the 19-second mark on Exhibit 22.
We can go here a little bit, and we'll go for the record 34 seconds on the exhibit. I think right around here they talk about cross connect. Can you describe what this cross connect is? And it looks like a probe is missed, but another was hit. Can you describe what cross connect is and what this video kind of part of the video shows?
Yes, so adaptive cross connect is a technology. Previous versions of the weapon, the X2 mainly, had 2 cartridges, but it had a chance to cross connect, but it was pretty much due to the laws of physics. It could happen or couldn't happen depending on what's going on, where the wires are, how far the probes are from the skin, stuff like that. With the Taser 7, we designed adaptive cross connect that forced that cross connect to happen. So if a probe misses, like in the image here at 34 seconds, one of those probes missed, but we're able to cross connect from one cartridge. Well, let me back up. Each cartridge, say you deploy one cartridge, the top probe is the plus of the circuit, and the bottom probe is the minus of the circuit. You always have to have a connection between plus and minus in order for electric current to flow. With this, we allowed, say for instance, if you missed with the bottom probe of the second cartridge, the top probe of the second cartridge would connect to the bottom probe of the first cartridge. So that's cross connect.
Now here, the Taser 7, and once again, correct me if I'm wrong, the Taser 7 had something about a close range cartridge versus a longer range cartridge. Could you tell the jury what you mean by that?
Yeah.
We're at point 53 now, and you're talking about the close range cartridge.
So with Taser 7, one thing new that we added was 2 different types of cartridge. On each Taser cartridge, the top probe comes out straight. The bottom probe comes out at a downward angle. The reason for that is, I mentioned before with the Taser technology, in order to cause a reaction from the muscles, you need enough muscle to receive that signal. So you need enough muscle mass between those 2 probes. So you need distance on the body. And so with the bottom probe coming out, or top probe coming out straight, and the bottom probe coming out at a downward angle, the further back you are, the more spread you have between those probes. That can cause a problem because if you are too far away, then the bottom probe might hit the ground before it reaches the target. So we designed 2 different cartridges, one with a 3.5 degree angle, and that is for long range. And then we have a close quarter cartridge that has a 12 degree angle on the bottom probe, and that is pretty much at 4 feet. In general, your general rule is you need about 12 inches of spread between the probes. There are caveats there on the location on the body because it's really about muscle mass, how much. But in general, you want 12 inches. So effective at 4 feet means at 4 feet, you'll get about the 12 inches of spread between those probes.
So that's kind of the minimum distance for the close range cartridge that's ideal for appropriate NMI.
Yeah, to create that ideal situation for NMI, you'd need to be at 4 feet.
And then so it can go this side. I think there's 111. We're talking about 111 now. It can go up to 12 feet. Is that the maximum distance, if you will, for the Taser 7?
For Taser 7, actually, the maximum range is 25 feet.
Okay, so this is even a little bit closer than 25 feet. It can go further back.
Correct.
The weapon, is it weapon designed to be with this distance then? In terms of that's the ideal way you should use it?
Ideally, we create it so that an officer can create distance between him and the subject. But we made the close quarter, so if you can't make distance, then you have those 2 options.
I'm trying lights. I'm going to get away from this for now. Now, in terms of what you talk about high voltage. That sounds like you're putting a bunch of electricity into a person. Can you go into that and describe that? What do you mean by that?
Yeah, so the weapon's designed with high voltage, but really the only point of that is to be able to jump a gap, jump an air gap, and you have to do that with high voltage. If you've seen in science class in high school, they have the Van de Graaff generator or small Tesla coils, and people put their hand on it and their hair raises up. That's millions of volts or tens of thousands of volts. Voltage is not dangerous. You see danger high voltage everywhere, but it's really the electric current that is dangerous. Now, high voltage on your utility lines, providing power, that's dangerous because there's potential for a lot of current. But on some electronics that limit the current, high voltage is not dangerous at all. It just allows the electricity to jump from one point to the other through the air, and that's called an electric arc.
So in terms of jumping through the air, what is going? I guess can you give an idea to the jury of what's going into a person, though? If it's successful going into a person, what is it? Voltage going in, or is it something different going in? And what kind of level is it?
It's actually electric current that is going in. It's actually electrons that are flowing, and the flow of electrons is electric current. Voltage is just the potential for current to flow. If you picture it this way, picture a water analogy. If you're at your hose outside, the water pressure is like voltage. So if you turn on your hose but you don't have water pressure from the city, water's not going to flow. It's the water pressure that allows the current to flow. And then when you open the spigot, you get the water flow, and that's like the electric current flowing.
So is somebody going to get electrocuted from a taser?
No.
When you talk about the impacts, in terms of are there long-term impacts? You're putting electricity into a person. What are the kind of long-term impacts of it?
There are no long-term impacts. The impact, the physical impact of the weapon is your muscles contract and then release. So I mentioned we do it 22 times per second, so it's a rigid lockup, but the cycle lasts for 5 seconds automatically. It can be turned off early. But as soon as it turns off, your body completely recovers. And so every pulse goes in one probe and out the other. So that's the lasting effect on the body. It's in the microseconds. I think the Taser 7 is around 45 microseconds, 45 millionths of a second for each pulse. So it goes in and comes out, and it doesn't build up in the body like poison or anything like that. It's just, it goes in, it goes out, your muscle reacts, and then releases.
Now, when you say when it goes in, the 5 seconds, you say it's automatically, so if somebody holds the trigger down, it's going to shut off at 5 seconds even though you're holding the trigger down?
That depends on the settings. So you have agency settings. So by design, if the trigger is held in, it will go beyond 5 seconds until you release. However, some agencies have settings that limit it to 5 seconds only.
Now, when you talk about the contractions, you're not electrocuted. Does it like knock you out completely? Is it you're knocked out when this happens?
No, you're fully aware of what's going on. You can hear everything and feel it.
You talk about, there's certain things, in terms of if you don't get it, you talk about the 12-inch spread. If you don't get the full 12-inch spread, can you describe what happens then?
So if you don't get 12-inch spread, we call that a short spread, then the muscles don't respond. You don't have muscles responding, but you do have sensory nerves that are reacting, and that causes, it's the potential for pain. If someone's on mind-altering drugs or numbing drugs and they can't feel, or really drunk and they can't feel pain, it's not going to be effective on them. That's why we created the technology to lock up muscles. But if you can't get the spread, can't get enough muscle between those probes, you're limited to a pain response.
Now, part of that, when when a Taser new version sent out, part of it is training people how to use it and so forth, correct?
Yes.
And one of the things you do is a PowerPoint presentation, correct?
Correct.
I'm going to pull it up now. Exhibit 24. This is one of the exhibits that's been admitted. Actually, part of the training documents that were admitted. I'm not going to go through the whole thing. We have it put on the screen, please. So you recognize this?
Yes, I do.
And this is one of the PowerPoints that are put out with the training when the Taser 7 went out, correct?
Correct.
Now, in terms of, can you explain here when you say Taser CEWs, that's controlled, what is it, controlled energy weapon?
Conducted energy weapon.
Are not a substitute for authorized deadly force. What is that there for? What does that mean?
So the Taser weapon has limitations, like I said, if you can't get probe spread, or if you don't get enough muscle mass between those probes, it's limited. So we put that in there to say that we're not saying don't put your gun out. If there's a deadly situation, don't rely on the Taser. Like if there's close range and person has a knife, they're typically going to go to their firearm rather than a Taser, because there's limitations. If you don't get the probe spread and it's a deadly situation, your life might be in danger. So we're just saying it's not replacing the gun yet.
Okay. Now, replacing it, is the Taser designed to kill people?
No.
What's it? It's not designed to kill people. What exactly is it kind of designed for then?
It's designed to temporarily incapacitate.
Move down. Try to do a little quicker, but it's hard to move. I'll go to slide 37 now. So this is part of the PowerPoint as well, correct?
Yes.
And you have this warning here. You just said it's not designed to kill people, but then you have this warning here. Can you explain that?
So the first point can incapacitate. That's what it's designed for. Can cause death or serious injury. Serious injury, you can get a probe in the eye. You can, using force, you can cause injury. As far as death, most of the deaths that have happened from falls. when a person walks up and they're incapacitated, they typically fall down, and if they're at elevated height, they fall straight to the ground. Or head injuries can happen as well. So it can, anything can cause, almost anything can cause death. But taser energy weapon, it's not designed to, but if used improperly, it can.
Now, in terms of with this, along with the slide, you just don't send out the slides, you send out instructions for the person giving the presentation, if you will. I mean, is there a script, if you will, that goes along with this slide?
Not necessarily script, but a guide. There's notes for the instructor on, notes on about the safety of the, or about that slide. On this one, it's on warning, so there would be notes, additional information for the instructor.
What kind of notes are you talking about here? What are those notes that you talk about here?
Well, they're mostly notes for the speaker to talk on. So on this, there would be additional notes. I don't know exactly the word for word what it says on here, but there will be like can cause death or serious injury. There's notes that talk about falls or head injuries, stuff like that.
Does it talk about the safety studies that go into the taser?
Yes, it does talk about, well, there's been many safety studies done on tasers, independently and from Axon. The National Institute of Justice, NIJ, did studies, Wake Forest. There's several universities who have done safety studies on the technology.
And what do those safety studies find in terms of this technology?
As far as electrical safety, it's a safe weapon. It does not affect the heart. It doesn't cause damage to the body. There's certain things in the use of force that can, but the taser weapon itself, it causes the muscles to lock up and release them. It's really a muscle stimulator. That's really what it is.
Staying on that point, I'm going to go now to slide 50. This talks about voluntary exposure. It's voluntary exposure that sometimes that police agencies use in their training.
Yes.
Now, in terms of looking at this, when you talk about risk of injury from stress, that first paragraph, talking about muscle exertion, can you describe what does that mean?
So the taser exposure causes your muscles to contract, and so it can, repeated exposure can cause fatigue in the muscles, just like working out really hard. And so that is warning that, stress, physical exertion, falling, especially like voluntary exposures, you don't just have someone stand there and hit them because they're going to fall and hit their head. And so always use spotters. So there's several instructions that are given on doing voluntary exposures.
When you talk about those total exposures, about strong muscle contact, you talk about repeated. Is like one contraction going to cause this type of strenuous exercise, or is that repeated?
It'd be repeated.
Okay, so that repeating, jury ballpark, how many? Is that 5, 6, 2? Yeah, is there any kind of idea?
Don't really have a number. There's been studies that the taser exposure is a whole lot less exertion on the body than, like, say, punching a heavy bag or sprinting or running. So this warning, specifically for voluntary exposures, is just warning the user taking the exposure that they might feel soreness. It might feel like they worked out or something like that. But it's not going to cause damage to the muscles or anything like that.
Now I'm going to slide 61 now, key safety guidelines. You've talked about this a little bit, but why is this list? What is this list here for in the PowerPoint?
This is to warn users to pay attention to the surroundings before a taser is deployed. If a person is up on a ladder or up on a roof or on scaffolding at some type of height, if you deploy the taser and they get the muscle effect, they're going to fall off of that. So pay attention to that. Flammables and explosives, there have been a few out there where a person was seriously injured or killed due to fire, because a taser was deployed in a explosive environment or a flammable environment, and the high voltage arc can ignite flammable fumes.
Are those kind of the top reasons people have been killed in the history of the taser?
Yes, falls is the number one, and then also fire injuries is up there.
Now, in terms of number 4, the restrain fast, avoid prolonged exposures, you kind of testified saying, well, prolonged exposures don't build up, but now you're saying avoid prolonged exposure. Can you explain why that's in there?
It's just for the situation. The device is painful, and it's a strong use of force. And so it's not causing long-term damage. I mean, eventually, a very long exposure, we had a volunteer do 45 seconds. So one activation is 5 seconds. We've had a volunteer do 45 with no damage. But eventually, at some point, you're going to cause muscle damage. If you keep lifting weights beyond you're tired, but you keep on going, you're eventually going to damage your muscles. So that's why the warning's there. Prolonged exposures, you want to limit. All in all, we teach officers to use the minimum amount of force to effect the arrest. So get them under control, get them cuffed, and turn the taser off.
So you had a volunteer do it for 45 seconds, you didn't have to pay him?
I believe he got a free taser.
Oh, okay. All right, so you got something.
Right.
Go to now. This is now 64. If I get a little bit better here, let me shrink it a little bit. You're talking this in terms of, once again, this is a training. Can you give the jury an idea why these preferred target zones? What is this for?
So preferred target zones, one, we're thinking safety, and two, we're thinking effectiveness. And so the preferred target zones are deemed safe, won't cause serious injury, and also have the larger muscle groups to give a better chance of getting effective NMI.
So when you tell you hit a muscle, so if it just goes like, I mean, I guess maybe your hand is kind of bony, so if it hits the hand and gets a bone, that's not going to have the same impact, if you will, or the same NMI?
Right, you have a lack of muscle there. Another example, I mentioned 12 inches. You want 12 inches between the probes. If you put a probe from my fingers to my arm, you have over 12 inches, but that's not going to be effective because there's not a lot of muscle mass there.
Now here's this is slide number 70 on the PowerPoint. Can you talk about this? You mentioned it a little bit, but you actually put this in there. What do you, the fighting or fleeing, how did Taser put this in there? What did they rely on here?
So there's a medical condition, and I can't go to, I'm not a doctor, but I know it from the doctors. But there's a medical condition called acidosis, and that's where your body is shutting down due to exertion. And it has to do with the pH levels in your blood. And they did a study comparing taser exposure versus fighting, punching a heavy bag, sprinting. There was even a dog attack in there, and pepper spray. And the taser energy weapon was very low on that scale of causing that amount of stress. The number one was fighting, and number two was sprinting, fleeing.
This is exhibit 71. Why is there, you got,
I'm sorry, you said exhibit.
slide 71. Sorry. You talk about sensitive populations. Why is there a danger with these individuals?
Well, like children and children, it's not a physical, well, their bodies are developing and all that, so like small children, besides being wrong, it's developing body, you might not have the strong bones and everything. So you don't tell a little kid to go work out really hard and start, lifting weights. They're developing. Elderly, they can be frail, frail bones and frail muscle structure. Pregnant, we have falls, so you can cause them to fall down. Sickly, low body mass. So this is a weapon that causes muscles to contract. And if you wouldn't have someone go and lift weights, it's ideal. You wouldn't want to do them, if you have an elderly person, you're not going to, have them go work their muscles in the gym because you could cause issues. So.
I'm going to go to slide 96 here. You've talked about some of these, you repeatedly talked about elevated platform and so forth. But in terms of these other increased deployment risk examples, water, mud, muck, how is it a drowning risk? Can you explain that a little bit?
Well, if you're in a swimming pool and your muscles contract and you can't swim. And so if someone's in water, you have to be aware of that risk. Now, if it's a situation that you have to do that, there is a video, I believe, from Lake Havasu, where a person had a weapon. They were by a pool, so they deployed a taser. They locked up and fell into a pool, and the officers jumped in and grabbed him. So life was saved there. But if the officers didn't go in and grab him in time, he could have taken a breath and drowned. Stuff like that, the elevated position, operating machinery. If it's something where you are going to lose control, you won't be able to voluntarily move your muscles. So if you are in a situation where you need to break a fall or defend yourself, you won't be able to. So we're just warning users to be aware of the situation. And if someone might be injured due to it, serious injured, think about it.
It seems to be like almost secondary impacts of, you hit them with a taser, it's something that happens because of the NMI, not because of the taser. It seems to be that's the main danger.
Right, it's all secondary. The weapon itself is designed to be safe.
Get in here, you see that? Talking about the drive stuff. Okay. I think you mentioned a little bit. Can you go a little bit more into with the jury? What is the drive stun? What does that mean?
I'm sorry, could you identify that particular slide?
This would be slide number 124.
Thank you.
Yes, so drive stun. And first, I believe I've talked about NMI. I think it says NMI in there. That's neuromuscular incapacitation. That is when your muscles lock up and you no longer have control of your muscles. So I mentioned the point of the weapon is to incapacitate, but that is done via the probes or delivering energy to enough muscle mass. A drive stun, a lot of people call it a mode of the weapon, but it's actually a tactic from the officer. And drive stun is when the weapon is activated and driven into the body of the person to make contact. It's also called contact stun. There's tactics they teach to hit pressure points and nerves to cause more of a pain response. And that's really what it is. The drive stun without probes causes pain, but it does not cause the muscles to contract.
Maybe I'll try and go out of this exhibit, a little different one. Take an example. You go to exhibit 12, graduation video, Your Honor. Okay. Pause right here. You got an opportunity. This is about 103 and graduation did exhibit 12. Back it up a little bit. When we talk about this drive stone, is this what you're talking about here?
Yes, this one is actually drive stone with a probe deployment too. So this one has potential to cause NMI. If you don't deploy the probes, then it's purely pain response.
Why would you, in a circumstance like this, the probe deployment with a drive stun, why would you do this? What's the purpose of this?
Well, we had talked about like there's minimum distance, like the 4 feet with the cartridge, that's what causes the 12 inches. If you're closer than that and you cannot get distance, then you can do a tactic like this where you deploy close and then drive stun on another part of the body to complete the circuit and get more muscle between those electrodes.
So if you had just done this without the probe deployment, that would just be the drive stun you've been talking about.
Yeah, that would, and it's very similar. This was a probe deployment really close. That would be the same body response as a drive stun without probes, just because it's close. There's little spread between those probes versus on a drive stun, it's just the energy coming from one electrode to the other.
Now, in terms of the drive stun, you have these, once again, you have kind of a sensitive areas. What are the sensitive areas and why is that here?
We have the groin, very sensitive area, and also we say to avoid the neck because you can't. It's a weapon putting pressure, so and you can crush the trachea.
But that's not necessarily the drive stun. That's just enough pressure because of pushing the weapon.
Right. It's just because you're applying the force. It's not really the weapon. And, you know, you want to avoid the face. You don't want, I mean, an electric arc across an eyeball probably cause blindness. And so, you know, you avoid the face, the neck, and the groin.
And maybe talk about a little bit just to give a jury a better idea. I think you talked about a little bit, maybe a more better visual in terms of the degree, the cartridges, the angles. What angle are we looking at here? Which cartridge would this be? Excuse me. That would be slide number 154. Thank you.
This is the 3.5 degree cartridge, also called our standoff cartridge.
So this is the longer cartridge, if you will?
Longer distance rated, yes.
Once again, can you go into this that you've talked a little bit about, but this is a visual demonstration that the spread you're talking about that you're looking for in a closed cartridge spread? 160, right?
Yeah, so this is showing the 12 degree close quarter cartridge, which has more spread on the bottom probe. So you can be closer to the subject and get more muscle mass between the probes than if you had the standoff cartridge that only has 3.5 degree, and you would end up, if at only 4 feet, you would only have a few inches of spread.
Now, part of what you did here, we'll probably turn that off right now. I'm going to show. We've been entering the evidence in Exhibit 25. I think it's already in. Yeah. No objection. Now you've got 23 there. I'm going to show you 25. What is 25?
This is also a Taser 7 energy weapon.
Okay. But Exhibit 25, would that be the actual weapon that you performed a forensic exam on after this incident?
It looks like it, yes.
In terms of what do you do when you get a weapon for a case like this? What do you do?
So any agency or law firm or anyone can request a forensic analysis. We'll arrange with them to ship the evidence to my headquarters in Scottsdale, Arizona. I usually ask them to ship it either FedEx or UPS, one of the carriers that does tracking and on critical evidence to keep it sealed evidence. So when I receive it, I will photograph the packaging and show that all the tape is intact, it hasn't been opened. Unpack the evidence, show how it was packed, unpack it if the evidence is sealed, take pictures of the seals and show that it was still sealed. Then I open it and photograph the weapon and any other evidence that I'm going to need to use. The reason I say that, sometimes something is sent to me that I don't need, so I typically don't even open that piece of evidence. But the pieces I'm going to use, I photograph close-up photos of all 6 sides, the weapon, the battery, the cartridges, probes, wires, anything relevant to what I'm investigating. Take close-up photos, do an inspection, and then I go and do an initial download. Talking about download, the weapon has a memory chip inside and it's recording information in it. So you can download that information to the battery pack, plug in the battery pack into a docking station and upload that evidence to our servers, which then produce logs that we can look at and tell part of the story.
Now, in terms of that, when you got this, you talked about taking pictures. I've shown you 2 pictures earlier today.
Yes.
And you recognize those pictures as pictures you took of the taser that was used in this incident.
Yes.
I would move the admission exhibits 23 or 28, 29, Your Honor.
No objection. All right, 28 and 29 are now admitted.
28 up there. Could you tell the jury what we're looking at here in Exhibit 28?
That is the front of the weapon, so this is after I've unpacked it and taken photos of everything, and now I'm taking the close-up photos of the front. So that is as if the weapon's pointing towards you like this.
Now, obviously, there's apparently a lot of mud and dirt in that.
Yes, and grass.
Now, in terms of which, and I don't know if you can see it real well, what would be the close cartridge and which would be the longer cartridge, if you will?
The one on our left is the 3.5 degree close quarter, and the one on the right is the 12 degree standoff.
That's why it's dropping down a little bit at the bottom there.
Right, and so looking at it from this angle, the cartridge 1 is on the right, cartridge 2, I'm sorry, I messed that up. Yeah, cartridge 1 is on the right, I was correct, and cartridge 2 is on the left.
Going to exhibit 29, what are we looking at here?
This is 2 probes and the wires unspooled from them.
So this is when, after it's been shot and how the taser's kind of left after they're discharged.
Yeah, they've been deployed from the weapon, and also the barbed end tip of the probe has been pulled from the body of the probe.
Now, in terms of you took these pictures, then you talk about getting a download or trying to tell you what the taser tells you about the incident. Could you tell the jury what you found out about the deployment of the taser in this specific incident?
In this incident, the deployment, there was 2 trigger pulls that deployed both of the cartridges. The first deployment, there was no connection between the probes. I believe it arced in air for a short period of time and then lost connection completely, and the weapon couldn't discharge.
Okay. Now, we can stop right there. Part of it, you did a report on this.
Yes.
And you kind of included photos of when you find the taser was deployed in that report, is that true?
That's correct.
And you had it after you take a look at those pages, and those are an accurate depiction of what the taser looked like, reflecting when the taser was deployed, is that true?
Yes.
Don't know if I remember, just to make sure, I'll move the admission of exhibits 26 and 27. I wasn't sure, so that's all as long as we got them in. So this is exhibit 26. You're just talking about it a little bit. Can you tell what we're looking at here?
Yes, so this is page 19 of my report, and I include screenshots from the body-worn camera from Officer Schurr. And this shows the reason to screenshots is to kind of show the movement. But you can see this is right when the weapon is being deployed the first time, so cartridge 1 is being deployed. And the subject, you can see his hand pushing, so he pushed the weapon away right before it was deployed. So the probes did not hit his body.
So you can tell it didn't hit anything. How can you tell that? How does it register?
There's a few different ways. One is looking at the probes. The spears were bent. Typically, if they hit flesh, they don't bend. So they hit a hard surface. We don't know what that surface was, but they hit something hard. And the second way is the weapon records in a pulse log. Every pulse, I mentioned the 22 pulses per second, every single pulse that it tries to generate, it records the output charge that it delivered and the voltage across the capacitors when it was discharging. And those tell a story of what the weapon discharged into. On this first one, the pulse graph showed that it was arcing in open air for the first second, I believe. Arcing open air, that would be it's arcing across either the wires in front or just across the electrodes in the front. And then it lost connection completely and it was unable to discharge. So it's charged up, it's trying to discharge, but it can't because there's no electrical path.
Going to 27. Okay, tell the jury what we're looking at here.
Yes, so this is page 20 of my report. In figure 4.5, that's an image from a civilian cell phone recording. And this is a little bit later, and while they were struggling in the grass, the wires were being pulled, and I have the 2 red circles shown in the grass there. You can see 2 shiny things moving as they are moving. And those, I am very sure, are the probes being pulled from the wires as the 2 subjects wrestle in the grass.
Would that be from the first one, the first deployment?
Correct.
Okay. Was there a second deployment then?
There was.
When was that?
That was, I believe, shortly after this screenshot was taken. And it was done pretty much with the muzzle of the weapon in the grass. And so the probes just went directly into the wet grass.
How can you, is that, once again, can you tell that just because of the video, or is there anything that registered on the pulses that you were talking about? Was that something on the pulses that we were talking about?
Well, the pulses were a little bit different because typically you don't fire into wet grass. Wet grass can look like human flesh, but wet grass is, it depends on the grass. I'm sure the grass in Arizona is a lot different than the grass here in Michigan.
You have grass
different
in Arizona?
minerals. We have a little bit of grass, mostly cactus, but the resistance or the impedance of the material. So you have different minerals, the different resistivity of the water. So there's a lot of differences. In that activation, it showed it discharging into what would look like flesh, but it was also short circuiting, which means it was probably, it was raining at the time. So the grass was very wet and the ground was very wet. And so the water was probably short circuiting. It didn't cause any damage, but it's the logs were recording discharging some pulses into resistive material and some pulses into a dead short. And that activation actually stopped early because the weapon sensed the short circuit multiple times, and so it stopped.
Now, part of your analysis also, when you talked about this photo wasn't, but the one before was from the body cam, you did an analysis of the body cam in this instance as well.
Correct.
Could you tell the jury what happened with that? Because at some point in time, it turned off. Is that when we stopped seeing anything? Could you tell the jury what happened with the body cam?
So the body camera, well, I won't say turn off because it's powered on, but it can be put in recording mode, or it goes into buffering mode where it's buffering video into a temporary memory. It started recording automatically due to, I believe it was the light bar in the vehicle, started the body camera recording. And during their struggle, well, let me back up. You can start a video by double tapping the event button. If you press the event button, which is a big button in the center, if you press that twice within a second, that starts recording. It can also start via a Bluetooth signal. So this one started via the Bluetooth signal. To end a recording, you press the event button and hold it for 3 seconds. During the struggle, I gave a detailed, there was like 16 times it was pressed within a 3 second period, but none of those were 3 seconds. But when the camera turned off, the button was held for 3 seconds and it turned off. Analyzing the video at those points in time, it was always when the video was blocked because there was a body right in front of it. So it makes sense that as they were struggling, the button was being pressed, but the last time it was pressed for 3 seconds and by design, it stopped recording.
So is that more of an unintentional, because there's the bodies pressing against one another, than somebody intentionally trying to turn it off?
Correct.
One other thing I kind of was finishing up with, in terms of the drive stun, can you show, where is the drive stun, what on the taser, if you use either one, what are the probes, what comes out for the drive stun? If both probes are deployed, how does the drive stun work? What is that on the?
Yeah, so if probes are deployed, picture we have 4 wires coming out here and probes over there. If you were to do a drive stun, there's electrodes, one electrode here and one here, one on the bottom over here and one on the top over here. And so if you do a drive stun, it will discharge that electricity into the skin and the sensory nerves.
Okay, so it's just those 4 little points.
Yeah, it's just these 4 points.
Okay. I have nothing for you, Your Honor.
Good morning, Mr. Childs.
Good morning.
Sure, you did a great job of explaining that as in basic of terms as can be, but it's not necessarily intuitive to everyone, so I just have a few clarification questions here.
Sure.
Sir, for the most part, everything you testified to as far as the taser, how it's designed, the PowerPoint, is it fair to say that's in the hands of a trained person?
Yes.
And Axon's classification of a taser as a less lethal weapon, is that in the hands of a trained person?
Yes, there's a lot of caveats and warnings that need to be gone through and thought about during a deployment or even before a deployment. So yeah, I would classify it, it's really built for a professional or for a person who's gone through training on that platform of weapon.
Okay, and I want to get to that training in just a moment here, but in the hands of an untrained person, would Axon market this as a less lethal weapon?
It's designed to be less lethal, but in the hands of a person who's not trained on it or someone who has ill intent, it could be dangerous.
Now, as far as training goes, can you just give us a snapshot as far as how is Axon do they start the training that an officer ultimately gets, within their department? Can you just, if you're aware?
Yeah, so overall, how it works is Axon develops the training program, but each agency is responsible for their own training. Typically, an agency, depending on the size, they'll have one or a certain number of instructors. So they are responsible for teaching the users, the ones who are going to be carrying the weapon. Those instructors, they are taught by master instructors who are taught by Axon. So Axon trains the trainers who will eventually train the users.
And does a department designate someone to go meet Axon for training to become what's deemed a master taser instructor?
Yeah, a master instructor goes through a week-long course, and it includes PowerPoints, but also practical drills as well.
And then that master taser instructor goes back to their department and trains their officers on what they learned.
Correct.
Now, Axon, as we've seen here, they developed their own materials, PowerPoints and whatnot that explain the device and how it's designed and intended to be used.
Correct.
And that includes warnings, is that right, about the device?
Yes.
Mr. McFarland, could you please put that PowerPoint back up there? And you're familiar with these materials, is that fair to say that you just went over with the prosecutor?
Yes.
I don't plan to go into the whole PowerPoint, but just on a few topics here. And I think it was already pulled up. Axon, the manufacturer of this Taser 7 device, warns that it's a serious weapon and should be treated as such at all times. Is that correct?
That's correct.
Do the Axon materials and warnings tell officers that the Taser is no longer dangerous after both cartridges are deployed?
No.
Could you please go to slide 13?
This is exhibit.
That was People's Exhibit 22.
I don't know, is this ours?
All right, this would be, it's also Defense Exhibit G6.
Is it the same documents? We don't need two.
So it appears to be, so I just want to know, they could use mine or they could use theirs.
But which exhibit was it, 24?
Under the people.
Ours is 24, correct?
24 or defendants.
Well, that hasn't been admitted, so G6 hasn't been admitted.
Are you familiar with this PowerPoint?
Yes, I am.
Then it'd be duplicative, so like we don't need two exhibits that are the exact same thing.
Well, theirs is included as part of the larger jeopardy training. This is just our DMS training. So they're I guess a little different in that regard.
So this is part of their exhibit.
Yeah, we don't have, yes, it is.
So then it will still be duplicative, just because it's extra, but you can refer to the slide that's within the PowerPoint, because I think it would be the same slide.
I don't know. I'm sorry, we get three attorneys on this. I don't think the numbers might not be the same. We recognize it's duplicative, Your Honor, but because it's a larger package and a smaller package, if he's referring to something on the record as slide 12, it might not be the same slide as in the
Or
larger
you can
package.
check that out. Which slide is this for you?
It's gonna be different because our exhibit does start with the GRP, some of the training stuff, so they're later on, so it will be different.
This is technically a separate, would then be a separate piece of material here.
So it's still not admitted.
And I would move for the admission based on this expert's knowledge of this.
And that's a
G6.
Okay. Is there any objection to G6?
No objection.
Okay. Then exhibit G6 is now admitted.
Thank you. slide number 13. Now, I think you've already discussed this on direct examination, but the Taser 7 is warned can cause serious injury or death, correct?
Yes.
And the device as a whole has the ability to incapacitate human beings, correct?
Correct.
The device has the ability to immobilize a person. Is that fair to say?
Yes, it causes their muscles to contract and they cannot control them.
Now, you mentioned studies. Is that often discussed that for a police officer in particular, if they're immobilized, if they're incapacitated, that gives the subject an opportunity to take their firearm? Is that often discussed?
Yes, if a person's incapacitated, they can't defend themselves or their equipment.
Now, besides incapacitation or immobilization capabilities, it's also capable of causing serious injury, or I think you even mentioned death, if just by directly targeting it on certain areas of the body. Is that what's warned?
Yes.
And are those, I think it may have been mentioned in one of the slides, those areas are often are referred to as sensitive areas to avoid?
Yes.
Now, risk of serious injury or death with these targeted areas, targeting areas that are sensitive, can that occur in both probe mode or in the drive stun, the contact mode?
It could happen in either mode. Even if the weapon's just armed, there could be danger due to the laser. So that can cause eye injury without even activating the weapon.
All right, thank you. So proper training's critical to try to avoid these potential serious injuries or perhaps even death. Is that fair to say?
Yes.
And the device, as we discussed, is less lethal if used in the hands of a trained person as designed and intended. Is that fair to say?
Yes.
Now, a trained person is obviously notified about these potential risks of the device.
Yes,
Correct?
they go through not only the PowerPoint classroom, but they also go through practical drills where they're put through scenarios to think about these things.
And I just want to, for a moment here, go over to the sensitive location topic that I know was brought up somewhat on direct examination. Could you please go to page 41? Does that train the user on the preferred target areas frontally?
Yes, we looked earlier at the rear view, the rear of the body, which was mostly most of the body except for the head. And then on the front, we include the groin area, the chest, and the face and head.
And there's mention of increases dart to heart safety margin. What's that?
So the dart to heart is there was a study previously where the heart could be temporarily affected by the taser, but the dart had to be a certain distance from the heart, and it was like millimeters or a centimeter. I forget the exact number. And so to remove that risk, we removed the chest as a preferred target zone. There's typically some muscle there, but not a lot. So we didn't lose much from just removing that from there. But to get the probe that close to the heart, it would have to be a very skinny person, very small chest, and the probe would have to penetrate right over the heart and discharge right to it.
Okay. And it's clear to the user, do not intentionally target head, eyes, throat, chest, or genitals. Is that right?
Correct.
And I believe you mentioned use of the taser probes to the eyes could cause blindness.
Yes.
And You just brought up the heart. Now, is the neck and the throat also put as an area to avoid?
Yes.
And also the genitals?
Yes.
And would an untrained person intuitively know to avoid these areas to potentially cause serious injury or death?
They would not. And I want to clarify, you said something about probe to the eye, but I believe even discharging electricity into the eye without the probe, like for a drive stun, or even I mentioned the laser to the eye. So it's not probe to the eye, the only thing that could cause blindness. There's several other factors.
Okay, and I was going to get to another one of those that I think you brought up on direct examination already, but let's just take the cartridge, the probes, the wires out of the equation. You brought up that the device still has the ability to administer a drive stun.
Correct.
And that also delivers an electrical charge onto a subject, has that ability, correct?
Yes, that would discharge into their body.
Could you just hold up the exhibit there? What is that exhibit marked?
23.
How do you ignite the drive stun function on the device?
First, the weapon has to be armed, so the safety switch has to go up, which is just move it with your thumb or finger. And then press it for pure drive stun without probes. You press the arc switch either on the left side or the right side.
That's all it takes to have the drive stun ignite is pressing that switch.
Correct.
And if used by a trained person as designed, is the drive stun meant to cause localized pain?
Yes.
How far from the subject do you have to be then to use the drive stun? It's contact, correct?
Yeah, it's arm's length.
Okay. And if I use the drive stun, press the drive stun against somebody, how long does that last? That the drive stun's working?
The activation? Or,
yes.
If, that's depends. If no cartridges have been deployed, the activation will go for 5 seconds. But if probes have been deployed, I'm sorry, I have that backwards. If probes have been deployed, pressing the arc switch will activate for 5-second cycle.
Okay. And the drive stun alone, I believe you mentioned, all by itself, drive stun, that does not cause this NMI, this neuromuscular incapacitation by itself?
By itself, without probes, no, there's no NMI.
But the drive stun is very painful. Is that fair to say?
Yes.
And does the drive stun run risk that it has the ability to immobilize someone?
Without probes deployed, there's no chance of NMI to immobilize through muscle, but it can temporarily jar someone because of the pain.
Sure. And depending on the person's condition, could that immobilize the individual?
It could temporarily.
Okay. Now, I think you already had mentioned the drive stun itself to sensitive areas. Have you ever been drive stunned before?
Yes, many times.
Has anybody ever deployed it against you?
Yes, once.
Okay. Would you let somebody drive stun you in the eye?
No.
How about the throat?
Throat? No.
How about the genitals?
Yeah, absolutely not.
Could it cause serious injury?
Yes.
And just to clarify, that's cartridges out of the equation, just this drive stun contact, correct?
Correct.
And you mentioned drive stun to the throat. The pressure could collapse here. I'm sorry, what was it?
Trachea.
Trachea. So that could be even worse than a serious injury, correct?
Yes, I mean, the electricity itself is not going to do anything except for the pain, but pressing on a sensitive area like the trachea, a person typically doesn't sit still when a drive stun is applied to them. They're trying to move, so it's easy to crush the trachea in that situation.
And just on this prolonged or repeated use, I think you had talked about that. Axon warns to avoid prolonged or repeated uses, is that right?
Yes.
And would an untrained person have that knowledge?
No.
If you were deploying cartridges on me, or deploying a cartridge, fires the probes on me, makes proper connection, is that sometimes referred to that I then take the ride?
Yes, it's been called that. Typically in volunteer exposures, yes.
How long does the ride last?
5 seconds.
Now, I think you've explained as far as when you deploy the cartridge, how do you deploy the cartridge?
Cartridge deployment is done via the trigger switch, so that's this one.
Take much pressure to pull that trigger?
A little pressure, but not much. It's easy to do.
Okay. And if you deployed and there was a live cartridge in there, it would then essentially send the probes through the air towards me, correct?
Correct.
And the probes would stay connected back to the device by the wires, correct?
That's correct.
Now, as far as the wires go, are officers often trained to avoid making contact with the wires and probes when possible?
Yes, we train them to cuff under power, which means the weapon is active, and so they're under the power of the neuromuscular incapacitation, but we warn them to avoid the wires and the probes because they could receive some of that shock.
Now, the probes, and I think we see them right in the exhibit there, it has a sharp end to it, correct?
Yes.
And does that have some type of barb on it?
Yes, on the Taser 7, there's 2 barbs on it.
Similar to like a fish hook, is that fair to
Similar.
say? Now, and you had mentioned that in order for the probe to have an effect on an individual, it does not necessarily have to penetrate their skin, is that right?
That's correct. Due to the high voltage, we design it to be able to arc to the skin if it doesn't penetrate through.
You had talked about this Taser 7 device has the capability of holding 2 cartridges, correct?
Correct.
And one of the cartridges is what's referred to as a close probe cartridge. Is that what it's referred to?
We call it close quarter or
close
CQ.
quarter. I'm sorry. Close quarter. Okay. And that cartridge gives the officer, the trained person, more of an ability to use and have that device be to be more optimal when they within close ranges. Is that fair to say?
That's correct.
And as we watch that video there, it says 4 feet. Is that an optimal range?
That's the optimal to create 12 inches of spread between the probes.
Now, this optimal range, is that a distance that's created in the laboratory?
It was more, I don't know if it was a laboratory, but yeah, it's in a test setting. There's been several studies that were done on effectiveness, and we call it motivation, where you get someone really motivated, they're going to try to ignore the pain and get to a task. And we see the difference areas on the body and the spreads between the probes, how effective it is in stopping them from going to that task.
And the reality out in the field, though, officers can deploy probes at closer ranges than 4 feet. They're allowed to do. That's reasonable, correct?
Oh yeah, and there's situations where you, even at a close range, say if someone's hunched over, you could still hit a probe and an arm and get a lot of spread even though you're at a close range. So it's all depends on the situation.
So 4 feet may be optimal, but you could still cause NMI even at closer ranges than that.
Yeah, that 4 feet was just saying the probes will be at 12 inches at that point.
And let's say the probes do hit very close to each other, maybe not optimal. Is there another third point of contact that the officer can use to create NMI?
Yes, actually, we watched a video of a graduation video, and that was called a 3-point. So probes were deployed close range and then brought over to the leg. The weapon was brought over to the leg, and that completes the circuit and causes more muscles to contract, giving NMI in that short spread situation.
And when the officer initially fired the probes into the back of that dummy, was he approximately 1 foot away from the dummy?
Yeah, he was close.
Yeah, or closer perhaps?
Yeah, possibly closer.
But then he followed up with the drive stun to a different area of the body, correct?
Correct.
And that's an effective means of delivering NMI.
Yeah, we train tactics to deliver NMI even in a close range, if you're closer than 4 feet or just hand to hand.
Now, I just want to talk a little bit about re-energizing the probes. We're not able to do a live demonstration in the courtroom here, but let's just say that you have the device there. Okay? You fire both cartridges. So now on the floor here, if they were to land on the floor, we would have 4 probes and the wires connecting those probes back to the device, correct?
Correct.
And officers are trained to avoid contact with the wires and probes, right?
Yes.
And let's say the 5 seconds goes by from the initial deployments. Can the probes and the wires be re-energized?
Yes, they can.
And can you just explain that a little bit, please?
Assuming the weapon's still armed, they would either press the arc switch or pull the trigger, would reactivate all 4 probes.
And ignite the probes for how long?
5 seconds.
And what if I am in contact with some of the probes and the wires? Am I at risk that I could experience the effects of the taser?
Yes.
Now, do I need to be in contact with 2 probes necessarily to feel the effects, or could contact with the wire as well create a circuit upon me?
Contact with the wire could create that circuit. They're insulated. They're designed to be insulated to the 50,000 volts. However, if there's any flaw in the insulation, a nick in the wire, someone stepped on it, or even the wire as it's coming out of the probe is scraped, that could allow the high voltage to jump through it. So if you're close enough to that wire, you don't have to be on it. If you're close enough to the wire, it can jump to you and deliver the effect to you.
And let's say I'm close to the wire, and then you come up and drive stun, and I'm just in contact with one wire, one probe, one exposed wire or one probe. Could that create NMI upon me?
If you point to your knee, so you're like kneeling on the wire and you're drive stun to the head?
Or anywhere else?
Anywhere in the upper body, yes, I believe that would cause NMI, because that would be the same as if a probe is in your knee and a probe is wherever that drive stun. So you would have pretty much most of your muscle mass affected.
Okay. And sir, you've seen the videos here, correct, from the prosecutor as far as this incident here?
Yes.
And the 2 men are struggling for control of the taser, is that fair to say?
Yes.
And it appears the wire and probes are all around the men during the struggle?
Yes.
And you later analyzed the wires and the probes from this incident, correct? At least some of them?
Yes.
And did you actually observe what appears to be blood on one of the probes?
I believe it was on 2 other probes.
Okay. Now, going back, the prosecutor showed you or talked about in your report the second deployment. And were you later able to find from the computer data and watching the cell cam video that there was a second deployment that had taken place?
Yes.
And you mentioned that it appears the taser was pressed into the ground when the second cartridge deployed?
Yes.
but that this second deployment was short-circuited?
Some pulses sensed a short circuit, some sensed a resistance. So it wasn't short circuit the entire time, it was delivering charge into the ground as well.
Okay. And the sound, if I ignite a cartridge, that's not as loud as a gunshot, correct?
Correct.
And so by the device being shot into the wet ground, it did not carry out its normal 5-second sequence? Is that fair to say?
Due to the short circuit that I saw multiple times, it stopped before the 5-second cycle was over.
Now, from watching that video, you can't tell whether or not the officer noted there was a second cartridge deployment, can you?
We have a check that goes kind of beyond his expertise here, Your Honor.
He's just testifying to his observations of the video, but I
I think he would have to speculate, so I'll sustain that objection.
watching the video after the second cartridge deployment, does the officer continue to fight to attempt to get the weapon? Is that your observation?
Yes, they continue fighting over the weapon.
And does the officer seem to continue to treat the weapon seriously?
It appears so, yes.
And does he continue to tell the other person to let go of and drop the taser?
Yes, I believe that's the words that he was using.
But now we know, based on the benefit of a video and data, that there was a second cartridge deployment, correct?
Correct.
But even after both cartridges were deployed, 5 seconds goes by. Based on the proximity of Officer Schurr in that video to the probes and wires, and what you explained as far as this ability to re-energize the probes or wires, the drive stun, could Officer Schurr still have been at risk of suffering the effects of NMI?
Yes, he could.
And could that have been by contact with probes or wires?
Yeah, contact with probes, wires, or drive stun. All the above could have caused NMI.
Do you think that even with both cartridges deployed, 5 seconds passes, that the taser still deserved its classification as a serious weapon?
Yes.
Now, as far as the fact that the grass was wet, okay, and we've got the wires and probes amongst the parties, if the device was activated again, what could the wet grass have any effect as far as somebody perhaps feeling the effects of the device?
There's a misconception that water increases electricity strength. It does not. However, it does create more chance of a path to you. So that's why you don't go near power lines when it's wet, because you could cross that path where electricity will travel through the water. So in this case, the water helped increase the risk of the electricity traveling to either of them, laying in the wet grass and activating a taser. Both of them were at risk of feeling the effects.
Okay. And just taking the wires, the probes back out of it once again, and talking about just the drive stun, just the contact ability of that device. After the cartridge is deployed, the device still maintains its ability to administer a drive stun, correct?
Yes, I mean, drive stun is a use tactic. It's not really a mode of the weapon, so it's so anyone holding it can do a drive stun. If it powers up and turns on, if they can press a button, they can do a drive stun.
And with these men in the close proximity that they were, does Officer Schurr appear to be in close enough proximity where the drive stun could have been used upon him?
Oh, yes.
I'm going to conclude here, but just to clarify a few points. If the taser probes are deployed on a subject, they are at risk of suffering NMI for a minimum of 5 seconds. Fair to say?
Suffering, experiencing, yes.
Okay. And if a subject disarms a police officer or taser and deploys the probes at the officer, then that officer is vulnerable to perhaps have other weapons accessed or be assaulted. Is that fair to say?
That's fair to say. If they were under the effects of NMI, they can't defend themselves or their equipment.
The taser can still cause NMI at a distance less than 4 feet, particularly with a follow-up from the drive stun, correct?
Correct. Not limited to that, but yes, definitely.
If the probes are deployed at certain sensitive areas of the body, this may result in serious injury or death itself, correct?
Yes, they're sharps with barbs, so like an injury to an eyeball. Not only is a puncture to the eyeball, but also it has to come out as well with a barb, so it can cause serious injury.
An untrained person would be unaware of this sensitive area training. Is that fair to say?
Yeah, I wouldn't expect them to be aware of it.
Therefore, Axon would not necessarily consider a taser a less lethal weapon in the hands of an untrained person.
That's correct.
Just recapping, even after both cartridges deployed, as we now know is the case here, the Taser 7 maintains the ability to re-energize all 4 probes and wire by simply touching the arc switch or pulling the trigger, correct?
Pressing the arc switch, yes.
I'm sorry, pressing the arc switch. And if an officer is in contact with certain probes and or wires and the arc switch is pressed, then the officer is at risk of suffering the effects of the taser's electricity. Is that fair to say?
That's correct.
I think I've said it enough, but even after all cartridges deployed, the contact drive stun can work together with the already probes, wires on the ground to close a circuit and cause NMI.
Yes, that's true.
And it's as simple as just pressing the device upon somebody and pushing the button, correct?
Or pulling the trigger, correct.
And Axon warns, do not press the drive stun on certain sensitive areas of the body, correct?
That's correct.
So even after both cartridges deployed, 5 seconds passed, the Taser 7 weapon still maintains the ability to deliver incapacitation, immobilization, or its contact drive stun can still be used on sensitive areas to cause serious injury or death.
Yes, if it's activated again, yes.
Okay. Just one moment, please. Does the drive stun make noise? When you ignite the drive stun, does it make some type of noise?
Activating the weapon does make noise, yes.
Okay. Like what? What noise does the drive stun make?
I hate describing this. It's difficult to describe. So when the weapon is arcing in open air, arcing across the electrodes, it's like a loud clacking type of sound at 22 times per second. So it's a fast clacking.
Okay. Fairly intimidating?
Yes. We even train, there's called an arc warning. So without deploying, you can press the button and show the arc and they hear it, and that sometimes is a deterrent to get compliance without even deploying the weapon.
Okay. And just one other topic, deploying the probes at less than 4 feet, the optimal range, there's still an ability for the device to cause NMI at less than 4 feet, correct?
Yes.
And if we watched a voluntary tasing video and the individual was shot from a foot or two, it still has the ability to lock somebody up pretty good. Is that fair to say?
Yes, the potential's there, yes.
Okay. That's all I have. Thank you.
Is your having some follow-up? Mr. Hunt? Gonna do a VR screen. Gonna go to Exhibit 1. You've seen this, obviously, you talked about it in your testimony. The cell phone video?
Yes.
Okay. This is more for noise, but you can also watch it too. Talk about it. Turn on that sound.
Like the lights dim? Then are you starting from the beginning or?
No, it's gonna be 45 seconds, Your Honor.
Thank you.
There's more of the sound there. What was that pop?
The initial pop was the cartridge being deployed.
So that's the shot, if you will, the air, the gaseous air, the nitrogen gas.
Correct.
That tinkling after that, what is that?
That's the loud clacking I was describing.
Okay, that's what you hear for a drive stun.
So drive stun is a tactic. So whether you're using a drive stun or not doing drive stun, the activating the weapon and it's arcing in open air, it's going to make that sound. So that can happen on a probe deployment or drive stun.
Okay, that's what I was trying to get at. That's what
Right.
you're talking about in terms of that clacking noise.
Yes.
So I'm going to go a little bit further here. Let me go to 52 seconds.
Good, man. Let go of the taser. Let go of the taser. No, like he good, like you.
Okay, you heard that, the pop there. What was that?
That was the deployment of cartridge 2.
You didn't hear the crackling there as you described it. Can you, but why not? Was there any particular reason?
The difference there is that the probes were going into the wet ground and conducting through. So the sound is made by the high voltage arc jumping through the air. In that case, there's some arcing going on, but most of the energy is conducting through the ground, which is quieter.
Now, they asked you some questions about this clackling noise. Did you ever hear any other other than those two? Did you ever hear any sort of clackling at all through the rest of the video?
No.
When you talk about going to an untrained person, okay, first of all, my understanding first, an untrained person wouldn't have to know there's a safety switch, right? To be able to operate it.
Correct.
And if you pull the trigger for a drive stun, that's not necessarily going to work, is my understanding. Is that what you said?
No, the trigger will activate the weapon.
But the drive stun, if both cartridges, I guess, maybe if both cartridges are gone, is it simply pull the trigger? You said the side one had to be used, I thought.
No, so, and that's what I'm trying to explain. The drive stun is a tactic. That is you driving it forward. So that's your action. You activate the weapon and then do the drive stun. So you activate the weapon via the switch on the side or pull the trigger.
Okay, so the pulling the trigger does all of those?
Yes.
Okay, so they'd have to know the sides are something different then.
Well, either activates the weapon. I don't know what a person would know. I mean, being a gun shape, I think the trigger would be the most optimal, but that would activate all 4 probes as well.
But that have to be after the safety was engaged or disengaged, if you will.
Correct.
Now, in terms of a lot of the questions you had, they asked about the wires. Did you ever see any evidence of anybody impacted by the wires lying on the ground?
No.
There's nothing that showed somebody was suffering from, they was being shocked. The wires had any impact on anything that happened here.
Not during those 2 activations, no.
It's always possible, but nothing showed through this entire incident that there was any wires that were impacting anything here.
Yeah, there was no view of effect during those activations, but the potential was there, yes.
There was potential, that's it.
Right.
All right. Thank you. Anything further?
So there's potential, there's still risk, correct?
Yes.
It's something that should still be potentially feared, correct?
Yes.
Now, you mentioned the second deployment was quieter than the first deployment. Is that fair to say?
Yes.
That's all. Thank you, sir.
Anything further, Your Honor?
I have a couple of questions. One, turning off the safety, do you have to do that each time you use the taser? Or once it's off, it's off?
No, so when you arm it and say deploy 2 cartridges, if you do not place the safety in the safe position, it still can be activated by the press of a button.
Okay. And then do you have to hold the trigger down in using it as a drive stun, or do you have to hold the trigger or push the trigger and then hold it while you're using it?
No, pull and release, it'll automatically go 5 seconds.
In the drive stun?
Drive stun or pro mode, it doesn't matter, it'll automatically go 5 seconds.
Okay. Thank you. Any questions based on that?
No, Your Honor.
Mr. Dodge,
And I guess, but just to clarify, to activate the drive stun, both cartridges are already deployed. You can simply press the trigger to activate the lightning bolt at the end of the device. Is that correct?
To activate the high voltage, yes, it's trigger pull or arc button switch. Either one does the same thing.
Okay. All right. Thank you.
None, Your Honor.
and I do see a juror has a question. I'll have that clerk come and grab that from you. You can approach, please, Mr. Becker and Mr. Dodge.
I need to get to Randy. And you just heard from the testimony of expert Brian Childs. Now, he works for Axon, which is a company that provides tasers and body cameras to police officers across the country. We're going to be bringing in 13 on your sides, Riley Mack and Kelly Lichter, who have been listening to this testimony. This is a testimony that a lot of people have been waiting for because a taser has become a very key focus in this case. We're going to be hearing not only how the taser was made, but also some of the things that go into actually using the taser. We may hear, you are going to hear more insight on the impacts of the taser, whether or not it is lethal or how much it can really hurt somebody. We're also going to hear about serious injuries, what areas that they advise people to not be hit with the taser. We're also going to be hearing about the actual length of which you're supposed to use a taser at, meaning should you be 12 feet away, should you be 2 feet away? He talks that in detail. And both the defense and prosecution also talk about this greatly. They're trying to get as much clarification as possible to understand how this taser should be used, what are the warnings of using this taser, and they also focus on how effective it can be from a trained person versus an untrained person. Now, there are obviously a lot of questions into what goes into using a taser, and he goes into detail about the training for it as well, how people within the company are trained to use a taser, but then also how people who don't work with the company, like your local police department, is using the taser as well and is trained properly. We also got to hear the first question from a juror. Now, we didn't physically hear that question because, of course, we have to keep their identity away from everyone, but we're able to hear a judge, the judge, ask if the jurors had any questions, and there was a question asked, and we were able to hear that question. So we'll be talking about that as soon as Riley and Kelly are able to talk to us. I'm getting word that Kelly Lichter, who's been in the courthouse all day long, she joins us now. Kelly, kind of break down, what did we just hear from Brian?
Yeah, Lauren, so this testimony, I think, is at the crux of this trial. We're talking about the taser that was involved in the situation. So we were hearing questions from both the prosecution and the defense around the use of the taser and what could have been the use of the taser had it, fallen into the hands of someone who is untrained. When the taser is in the hands of an officer like former Officer Schurr, he is a trained professional. They are trained at GRPD on how to use this taser, but the defense was trying to argue that if the taser were to get into the hands of Leoya, he is an untrained person who does not have familiarity with the type of Axon taser, at least, that was used in this case. So it was really trying to prove, the difference between someone who is trained using this taser and someone who is untrained using this taser. And then the prosecution was also trying to question, if the untrained person gets the use of the taser, would they know how to use it improperly? So they were being questioned for 2 hours in there, which is the longest testimony that we've seen at this point in the trial, Lauren.
To ask about that questioning. We heard both the defense and prosecution asking what seemed like similar questions to this person, and we saw similar answers. Is there any way you can help us kind of understand what their question was for each separate case?
Yeah, so the prosecution was trying to gear their question towards, what we've been saying since the beginning of this trial. They want to try to prove that this was an intentional death and that, it was unjustified. So they were trying to prove that even if this taser, fell into the hands of Leoya, that he could not cause great bodily harm or death with it. And that's the whole entire point. They were saying, even if the taser was fully deployed, could there be a chance of great bodily harm or death if the taser, before it's deployed, just in a regular scenario, if the taser was being used, could someone die from it? And then also in training manuals, in warnings, there is warnings that the taser could cause death. And Kent County Prosecutor Chris Becker was really narrowing in on that it's not necessarily that death can be caused from the taser directly. It's someone being tased, fallen, if, let's say they're being tased and they're on top of a roof of a house, or even if they're just standing and they're tased and they fall in the cement. So it's trying to prove that the taser cannot cause great bodily harm, so it was not justification for the shooting that occurred. Now, on the flip side, on the defense, kind of like I was saying earlier, they're trying to prove that if this taser fell into the hands of an untrained person, such as Leoya, that, it could have been caused improperly. There are warnings, in the Axon training services that if the taser is launched into parts like the eyes, the groin, the chest in some cases, that it could cause great bodily harm. I know that the expert, Brian Childs, also brought up blindness if it is launched to the eye. So they were trying to prove that in theory, if the taser fell into the wrong hands, that it could cause great bodily harm, and Schurr was fearing for his life, and that was justification for the shooting. And, that's what we've been saying all along. I said this yesterday in the morning. I've been saying it, all day. This is what they're trying to prove. It's around this taser. Did Schurr fear for his life, or was it unjustified for the shooting, Lauren?
I want to ask about the NMI. We kept hearing that over and over again, and it seemed like it revolved around those injuries or areas that could cause some injuries. Can you talk about what exactly that is?
Yeah, so NMI is neuromuscular incapacitation, and that is, when someone is tased, it affects their muscles. So when you're getting tased, it's not getting launched at your bones. If it hits a muscle, something meaty, then you are incapacitated for a certain number of seconds. I believe it was 5 seconds. I don't know off the top of my head without my notes. But it's just, for a few short seconds, you're incapacitated. Then when, the taser is released, then it goes back to normal. There are no long-term effects of this taser, which is something that Becker was questioning about. If someone was tased, like in this situation, I think he was, getting at if Schurr was tased, would he have, just gone back to normal? But on the flip side, on the defense's side, they were arguing that if Schurr was tased under NMI, someone could have reached for his weapon, such as his gun or other things that he had on his person. He would have been incapacitated for those few seconds. So it really revolved around how much could an individual do, if they were under this NMI. And there was also questioning around, was the taser deployed twice, which the taser was deployed twice, then what, are the ramifications, and what could you do with a taser if it's already been deployed twice? And so again, it just really revolved around if someone's incapacitated, what could happen during that time.
And we also got clarification that no one was hit by the taser in this situation. Is that right, Callie?
That is correct. No one was directly hit by the taser. It did not latch onto any skin parts. However, it was launched into the ground, and there was also questioning around, if a taser is deployed, what can happen? Can someone still get, shocked? I'm going to use that word, shocked by the taser, get tased. If it's deployed by the strings, by the little, I believe they're capsules at the end, of the taser. What can happen after it's already deployed? Can it still be used? Are there still harmful effects? I believe I'm getting word that they are probes. They're called probes. And so that's what really was the question about. No one was directly hit, but the question then becomes, what could happen after it's already been deployed? Can someone still get tased?
Sounds like we got our first question from the jury. One of the jurors asked a question. Can you talk about what question they asked and what the response was?
Yes, so the juror asked about what we saw earlier when there was the close-up of the taser that was used. In this incident, there was some mud and dirt on the end, and they were asking, does that impact the tasing at all, the tasing ability? And I believe that Childs did say that it could impact the tasing ability, because it is a piece of matter that can obstruct where the shock comes out. And that was due to the taser being shoved into the ground essentially, and during I believe the second deployment of the taser, Lauren.
Is there anything else that was a big takeaway for you in this testimony? We heard a lot from this expert. Is there anything that really stands out?
Just going back to, what is the capability of this taser if it's already deployed? We talked about the drive stun, which is when even if the taser is deployed, like what we think about when the things shoot out of the taser, can it still tase? And it still can. There are 4 prongs on each corner of the taser. It kind of is like a rectangle there on all 4 corners. And if you drive that directly into the skin, it could still tase, or it could still harm someone, not necessarily tase, sorry. It could cause, a lot of pain, not necessarily great bodily harm, if it's just latched into like a meaty part of the body, but it can cause pain. It also talked about, a closed circuit, because you can also, drive stun someone while they're also being tased with the actual shooting parts of the taser. And again, the defense really latched onto if someone's drive stunned in an area that they're told not to aim for, such as the eyes, the chest, or the sensitive areas of the body. Will it still hurt or cause great bodily harm? And I think the conclusion that was come up with is yes. If someone is drive stunned, if those 4 corners, those 4 prongs, hit the eyes, it could cause great bodily harm, Lauren.
Callie, we appreciate all of your reporting. We're going to let you get back into proceedings because we've heard that they've started again. So again, thank you for all of your knowledge on this. As Callie mentioned, there were a lot of questions surrounding around this taser. Like we've talked about before, this is one of the main points that both the defense and prosecution are going to be hitting on in this case. The prosecution showing that, if there was no threat with Lyoya had he gotten that taser, but then obviously on the other side of the defense saying that, yeah, there was a threat. We heard from Brian Childs, if you're just joining us. He's the senior manager at Axion, and he explains the type of model that he uses, and I'm trying to get word. What was that, Eric? Okay, so this is just video from what we're talking about. You can see Childs, he's testifying right now. But again, there was a lot of questions on the impact of actually being tased. When the prosecution asked about, are there long-term effects? He said, no, there's not typically long-term effects. He also says that a person does not black out when they are shot by a taser. They also talked about the proximity. If the taser is too close to a person, it might not be as effective. There's kind of a sweet spot that they have to shoot from. They also talked about serious injuries. One of the things that he said that what they see, what could be the worst injury when getting tased is actually falling. If someone were to be tased at a high elevation and their muscles are constricted and not able to move, falling from a high elevation could really impact somebody and seriously hurt them. One of the biggest things during the prosecution is saying that there was no memory on the taser showing that anyone was hurt, meaning no one was shot or impacted by the taser when it was shot. Let's take a listen to what he else had to say.
When you find the taser was deployed in that report, is that true?
That's correct.
And you had an opportunity to take a look at those pages, and those are an accurate depiction of what the taser looked like, reflecting when the taser was deployed. Is that true?
Yes.
Don't know if I remember, just to make sure, Your Honor, I moved the admission of exhibits 26 and 27.
Those have been admitted.
I wasn't sure, so as long as we got them in. So this is exhibit 26. You're just talking about it a little bit. Can you tell what we're looking at here?
Yes, so this is page 19 of my report, and I include screenshots from the body-worn camera from Officer Schurr. And this shows the reason 2 screenshots is to kind of show the movement. But you can see this is right when the weapon is being deployed the first time, so cartridge 1 is being deployed. And the subject, you can see his hand pushing, so he pushed the weapon away right before it was deployed. So the probes did not hit his body.
So you can tell it didn't hit anything. How can you tell that? How does it register?
There's a few different ways. One is looking at the probes. The spears were bent. Typically, if they hit flesh, they don't bend. So they hit a hard surface. We don't know what that surface was, but they hit something hard. And the second way is the weapon records in a pulse log. Every pulse, I mentioned the 22 pulses per second, every single pulse that it tries to generate, it records the output charge that it delivered and the voltage across the capacitors when it was discharging. And those tell a story of what the weapon discharged into.
And you hear him answering some questions from the prosecution. One thing that also did happen is during this testimony, when the defense is asking him a couple of questions, the prosecution tries to object to one of the Schurr's attorney's questions, saying that he's asking for Child's opinion on a video that is shown during this trial, which is out of his expertise. And then Schurr's attorney rephrases his question. They go on just to kind of ask more questions about seeing the struggle and what could have happened if the NMI were to impact somebody, and could someone lose muscle function. A lot of questions just surrounding what could happen if someone who is not trained to use a taser could do if they did shoot that taser, and also what happens if they shoot it once, if they shoot it twice. We also heard the judge ask some clarifying questions about the lock, the safety lock that's on the taser. And now we're hearing that the judge is back in proceedings. Let's take a look in as a next set of, I believe this is still with this current this is actually a different witness. I believe we have the name of that witness. His name is Stoughton, and he is a professor of law and criminal justice at the University of South Carolina. He has taken, it looks like, he hasn't taken the stand yet because it looks like the defense is objecting to some of the things that he could be talking about. I'm looking at my notes to make sure I have the correct thing. I believe what happened in this situation is that, okay, let's send it to the audio now.
I'm going to limit my questions to that.
Okay. Okay, but you don't object to him, because are you putting him forth as an expert, or do you intend to ask him to be accepted as an expert in the field of
Police practices and use of force, Your Honor.
Okay. And the police practices is the framework under which officer created jeopardy would ostensibly be placed. So I'm asking, do you object also to the use of force testimony that Mr. Stoughton may provide? And I'm asking because obviously that would be included in the questioning at this juncture.
So you're asking whether or not we believe he's qualified to be an expert in the use of force We do not, we believe he is qualified given his academic credentials and issues of use of force. We believe he's qualified to act as an expert on principles espoused by the Supreme Court, Graham v. Connor, and subsequent cases. He's written books about use of force. As far as tactics goes, and what a police officer should do, and training, we do not think he's a taser expert. We do not think he's a tactical expert. Police practices, what's generally accepted in conforming with Graham v. Connor. We believe he is knowledgeable enough on that to provide his opinion. We just think his opinion about officer-created jeopardy is not relevant.
Okay. And so I think we have the kind of the ground rules, so to speak, for this portion of the questioning of Mr. Stoughton. So are you ready to?
Thank you, Your Honor. And Ms. Blodge will be taking the questioning for this portion, Your Honor.
So, Your Honor, the people call Professor Seth Stoughton.
Good morning.
Good morning.
And sir, before you take your seat, if you please raise your right hand, my clerk will swear you in.
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Thank you.
Good morning, Professor Stoughton.
Good morning.
As you heard the judge's opening, we are here for a bit of a focused inquiry, so this will be a bit different than a general expert voir dire, but we will focus in as necessary.
Sure.
Are you present in court today to potentially offer testimony as an expert in police use of force tactics?
Yes.
And did you prepare a CV in anticipation of testifying in this trial?
Not specifically for this trial, but yes, I
Provided to counsel.
keep the CV on hand, yes.
Your Honor, just for purposes of expediting today's hearing and jumping over qualifications, his resume updated version has been provided to defense counsel previously. Would you like to have a copy?
We don't need a copy, and we understand we have a copy of it.
Great. May I approach the witness? Does this appear to be the most updated version of your CV?
Yes, it does.
Your Honor, the people would provide the court, just for purposes of this limited evidentiary hearing, with a copy of the expert CV. It's not marked as an exhibit. We don't plan to disclosure it to the jury.
We'll probably do a Roman numeral 1 for it.
For the evidentiary hearing.
And is there any objection to being admitted for that purpose as exhibit Roman numeral 1?
No objection.
Here's an exhibit number from the court. And just briefly, Professor Stoughton, where do you currently work?
At the University of South Carolina Joseph F. Rice School of Law, which I'm contractually required to say the full thing.
And what is your title there?
I am a professor of law, and I'm the faculty director of the Excellence in Policing and Public Safety program there.
And how long have you served in this position?
As a professor since June of 2014 with EPS, the Excellence in Policing program, about 2 years now.
As a professor, is it safe to assume you teach classes to law students as part of your duties?
I do. As a professor of law, I teach in the JD program, our law student classes, yes.
And in general, in your position as a professor, do you do any research?
Yes.
Do you do any writing for publication?
Yes.
And I assume you research and write on a variety of topics, but does your work specifically include research on the topic of officer-created jeopardy?
I wouldn't call that a specific topic. I research in the area of police tactics, and officer-created jeopardy is a concept within the field of police tactics, yes.
So your research on police tactics involves the theory of officer-created jeopardy?
Yes. Even calling it a theory might be a little grand, but yes, certainly that concept.
how would you define the concept of officer-created jeopardy?
Officer-created jeopardy is really just a term of art that's used to describe unjustified risk-taking. When officers use tactics that they should not use, and as a result of that, the poor tactic increases the danger to the officer, we could call it bad tactics or unsound tactics. The phrase that is used is just officer-created jeopardy.
And when you are performing this research and discussing the concept or term of art of officer-created jeopardy, what methodology do you use in your research?
So it depends on exactly what I'm researching. For researching the history of police tactics, it is essentially going back to the early days of formalized police training in the 19-teens under August Vollmer and identifying what police training consisted of. There's a good article from 1929 that identifies that police tactics was among the list of things taught at the early police training schools, as they were called. Going through sort of history of policing and looking at tactics, the real emergence of police tactics as a field and what's sometimes referred to as the tactical revolution of the 1970s, with police practitioners and scholars like Jim Fife, Peter Scharf, Arnold Binder, a number of other folks working in that area to identify the framework for examining use of force incidents, which includes a tactical component, and looking at more modern practices, it's identifying tactical guidance provided in police training at the 650 odd academies or at some of the larger agencies that develop their own tactical training, seeing how those concepts are reflected in guidance by, among others, the Police Executive Research Forum or the International Association of Chiefs of Police, to get an understanding of how tactical concepts bubble up from the field and become generally accepted.
So your methodology includes examining how these police tactics have evolved over the course of history.
Oh, sure. Yeah, absolutely. There have been some very notable changes in police tactics. And one of the things that's important in examining any particular incident is identifying what the tactical guidance was at the time. If you looked at active shooter situations prior to 1999, the tactics were different than active shooter response today, for example.
And at what point does your research reveal that the concept or term of art officer-created jeopardy entered this police tactics discussion?
Yeah, again, it's just a term of convenience. It's a term of art. That started in the 1990s, mid-1990s with the Savannah Police Department. They're the ones who first introduced that concept. Or I should specify, termed that concept officer-created jeopardy. There were discussions of the concept well prior to that, but that wasn't the term until the Savannah Police Department introduced it.
So the concept has existed historically, but the term originated approximately 30 years ago. Is that what?
Yeah, that's about right.
And when you're researching in the area of police tactics, what are the sources from which you draw your conclusions?
So again, it depends on exactly what I'm researching. For historical practices, it's historical training documentation. I don't really do qualitative work in this area, so I'm not interviewing people about what tactics used to be like 30 years ago. I'm usually looking for tactical training manuals. Most of those resources are not academic in nature. Most of them are practical or practitioner resources. So some of the early publications by Caliber Press, like Street Survival or the like, that sort of channeled popular understandings of tactics in the 70s and 80s. More modern research looking at police agency policies, looking at organizations, again, like the International Association of Chiefs of Police or the National Police Foundation or the Police Executive Research Forum, to see how they are writing and describing practices that have bubbled up from the field. Along with looking at training documentation, agency policies, there's some use of, say, popular police media, so tactical articles on websites like Police Magazine or the like, not to identify any of them as a definitive source. They are not, no one article is a definitive source, but when you see the same sort of baseline message of this is the scope of professional practices at this point in time, that's how you identify a generally accepted practice.
So do you survey all of these different publications to source your eventual research conclusions and opinions?
Yes, both the academic literature, the professional organization literature, and the practitioner literature, yes.
Are these sources nationally recognized among the expert community?
Yes, yeah. I mean, the International Association of Chiefs of Police, for example, which publishes a lot of model policies and discussion papers, as well as a national consensus policy and discussion paper on the use of force. They are the largest and oldest police organization in the world. Police Executive Research Forum and National Police Foundation are both extremely well known in the police practitioner as well as the research community. When you talk about individual articles, academic articles, they may not have the same degree of penetration into police practice. There can be a pretty hard line between where police agencies get guidance and what academics are working on. But within the academic communities that look at this, yeah, I'm looking at well-published articles by well-known scholars.
And as we've covered, you're a professor, correct?
Yes.
Are you also an attorney?
I am. I'm a non-practicing attorney in the Virginia bar.
And does your experience also include experience as a law enforcement officer?
Yes, it does.
And with your educational and professional background, does that give you a unique perspective, as you've said, on all of these resources, be it academic, legal, law enforcement based?
I wouldn't want to say it's a unique perspective. It's not particularly typical. There are a number of law professors who focus on policing. I'm hosting a conference for them in June, as a matter of fact. There are a number of criminologists who focus on policing. Some number of them are former officers. Relatively few are former officers turned law professors who focus on policing, but there might be a couple others.
So you've mentioned how you collect your research and your methodology. Beyond researching, do you write and publish yourself?
I do, yes.
Does this writing and publication include discussion of this concept, officer-created jeopardy?
Yes, it does.
Have you published books that cover this topic?
The book, very creatively titled Evaluating Police Use of Force, talks about it in chapter 5, the tactical considerations chapter, yes. I've also written book chapters in other books, consolidated books that have talked about it.
How about any law review articles?
Yes.
Any other articles or publications that come to mind where you've discussed officer-created jeopardy? Those are the main categories. Amicus briefs, perhaps?
Amicus briefs, yes. I've done amicus briefs that have talked about officer-created jeopardy, not from the perspective of an expert applying tactics in a case, obviously, but in the context of an amicus. I'm trying to remember if I write in both law and criminology, and I don't remember offhand if any of my criminology articles get into officer-created jeopardy.
Do you recall in what courts you have filed amicus briefs on this topic?
The United States Supreme Court, I think the Fifth Circuit Court of Appeals. I think those are the only courts I've done amicus briefs in on this issue.
And those are both federal courts?
Yes.
Yes. When you publish these articles and books, have you ever seen them cited by courts or other experts in your field?
Yes.
Do you recall any specific citations?
Kind of breaking it up broadly, there are a number of academic citations, that is citations to my work by other academics in an academic context. That's true most obviously in law and criminology, but also in some other disciplines, psychology and geography and a couple of others that I don't entirely understand why they're citing me, but they do. Outside of academics, in police practices, my work is cited or used fairly heavily in training on reviewing police uses of force in front of state organizations. The one speaker sent me a slide about some of my work from the Pennsylvania Organization of Municipalities or something like that, the sort of blanket body for cities that have police departments. My part of the book on tactics was just cited by the 11th Circuit Court of Appeals, the Federal Circuit, focusing on a couple of tactical principles from that same chapter, Chapter 5.
And Chapter 5 was the chapter that discussed the officer-created jeopardy that you mentioned?
Yes, as part of the discussion of tactical considerations, yes.
Are there other experts in the use of force community who also research officer-created jeopardy, or is it just you?
No, there are a number of us who either research it or use that description of unjustified risk-taking in various aspects of our work.
And have you ever testified as an expert in court before?
Yes.
Do you recall any of the courts, state, federal, state courts specifically that you've testified in?
Oh, yes. I testified in state courts in Minnesota, Ohio, Georgia, Nevada. I'm sure there are some other ones. Federal courts, South Carolina. I've testified in federal courts in South Carolina, North Carolina. I would have to look at my CV to remember.
I think that's a sufficient list, and the court has your CV for its review as well. Could you ballpark about how many times you've testified as an expert witness in use of force tactics?
Probably upwards of 24 at this point. If you include depositions, it would be more than that, but with actual trial testimony, 24, maybe a little more.
And has your expert testimony ever covered the concept of officer-created jeopardy in court?
Yes, frequently.
Have you ever testified or provided this officer-created jeopardy discussion in police use of force cases specifically?
Yes.
About how many out of your 24 times would you estimate it was a police use of force case?
Oh, that involved some aspect of tactics or potentially unsound tactics. This is very ballpark, but maybe half or so.
Have you ever been excluded from testifying as an expert witness in court?
No.
Do you ever teach or train others regarding this concept of officer-created jeopardy?
Yes.
And in what context is that?
So I teach use of force review and evaluation in the program that I run at the law school. We have a week-long course on critical incident and sentinel event review that covers aspects of reviewing use of force. So we talk about the role of tactics in use of force. I think we mention by name officer-created jeopardy, but only relatively briefly. Again, that's just a term of convenience more than it is an actual self-defining separate thing. I have twice taught at the Washington, D.C. Metropolitan Police Department's Police Leadership Academy on reviewing use of force. They have between 70 and 80 officers from all over the country, and actually all over the world. They have 6 or 8 officers in every cohort from other countries. And in that discussion, similarly, I talk about considerations in use of force review. That includes tactics, including this concept of officer-created jeopardy. I've done, I don't know how many speaking presentations to shorter audiences instead of a full-blown course or something like that for judicial audiences, legal audiences, police, executive, or officer audiences. A lot, many of which touch on this concept of tactics as it relates to use of force.
Does that dovetail at all with your experience providing subject matter expertise or consulting services?
In some sense, yes. They cover some of the same topics. There is a distinction. There is a difference when I'm teaching a course, especially one of the courses for police executives. The focus is not on identifying generally accepted practices. The focus is on sort of building up best practices, and there's a noticeable difference between best practices and what is generally accepted. My role as an expert is not to identify what the best practices are and hold officers or agencies to that standard. My role as an expert is to identify what's generally accepted and at the time of the incident or decision. Same topic, different standard, different role, if that makes sense.
So you mentioned generally accepted police practices. Could you provide a bit more of a definition of what that means? Not best practices, as you said.
Sure, yeah. So generally accepted practices is really the sort of common elements of professionalism. It's the standard of care in policing. We just happen to not use that particular phrase. It's the idea with generally accepted principles or practices, and I can separately define those. These are concepts or protocols that have, again, typically bubbled up from the practice of policing and become so commonly accepted that more or less, to put it very colloquially, if you went to any reasonably trained officer anywhere in the country and said, is this more or less the way you do things, they would say, yeah, that's more or less the way we do things. Not everything in policing has a generally accepted practice, and even within generally accepted practices, there's often a fair amount of room for variation, but there are still both sort of floor and ceiling, or maybe a better way to put that is there is a minimum level of professional expectation. To meet the expectations of the professional community in policing, an agency or officer should be doing this thing or not doing that thing.
Would you classify officer-created jeopardy, I guess put it this way, is the concept of officer-created jeopardy incorporated into generally accepted police practices?
Properly defined, yes, absolutely. Understanding officer-created jeopardy as unjustified risk-taking, yes, completely. Again, police agencies have been teaching officers about tactics since at least the 1920s, 19-teens. There's been both academic and popular focus on it in the 70s with that concept of tactical revolution that I mentioned. Yes, understanding tactics as a tool to keep officers safe and as a result to keep communities safer. Officer-created jeopardy is certainly generally accepted. It's not always understood in that term, right? But again, that's why I'm defining it here, or specifying that it is a term of art. An agency might not have anything in their policy manual or training that says officer-created jeopardy, But they certainly have things in their policy manual and training that talks about tactics, the need for good tactics, the need to avoid bad tactics, the result of what bad tactics can be, making a use of force more likely or exposing an officer to danger. So yes, all of that is generally accepted.
Could you give us a quick example of a tactic that incorporates an officer-created jeopardy concept?
Yeah, so the easy one and the one that we use in the book is stepping into a vehicle's path of travel. Stepping immediately in front of or immediately behind a vehicle, especially a moving vehicle, but even leaving that aside. The tactical analysis here is relatively straightforward. You ask what are the potential benefits and what are the potential risks. The tactical benefits of stepping in front of a moving vehicle are minimal. You're not going to stop that vehicle, right? Just as a simple matter of physics, vehicle beats person all the time. Maybe there are some slight tactical benefits, potentially a benefit to visibility or something like that, but the tactical benefits of stepping into a vehicle's path of travel are relatively minimal. On the other hand, the tactical risks are substantial. Again, vehicle beats person. So an officer is far more likely to be struck, dragged, seriously injured, or killed by stepping into a vehicle's path of travel. For that reason, it is generally accepted as a matter of police practices that outside of extraordinary circumstances, officers should not step into and certainly should not stay in a vehicle's path of travel.
Prior to your experience as a professor or attorney, did you serve as a law enforcement officer?
I did.
And what department was that with?
With the Tallahassee Police Department.
How long were you an officer with Tallahassee?
I was full-time with them for just under 5 years and stayed on as a reservist, a part-time officer for another 6 months or so.
And in that capacity, as a law enforcement officer, were you exposed to officer-created jeopardy concepts during your training?
Sure, yeah, tactical training, again, very common both at academies generally, definitely part of my academy experience, as well as in-house training and field training, yes.
And specific to the case that you're here for today, did you review any evidence to prepare for your anticipated testimony?
Yes.
Do you recall any of the specific evidence that you did have a chance to review?
There were 3 different videos, as I recall, a dash cam, a body cam, and a bystander's cell phone camera. There were some statements and investigation. There were policies and procedures and training records. I'm sure there was more. I could look at my report and give you the list of materials that I reviewed, but I don't remember the rest offhand.
Nope, that's a good list. So after your review of all of this evidence, did that adequately prepare you to apply your research and writing to the facts of this case?
Yes.
One minute, Your Honor. No further questions at this time.
Professor Stoughton.
Good morning. I like your tie.
Thank you. I like yours.
Thank you.
So, I want to get something very important out first. Is it Stoughton or Staunton? Because I think I screwed that up several times.
I've always pronounced it Stoughton,
Stoughton,
but I'll
well.
take anything at this point.
I'm either Borgula or Borgula, and I answer to both. Because I think when my grandparents came over here, it was changed completely anyway.
Yeah,
All right, so.
I feel your pain there.
I want to talk about officer-created jeopardy.
Sure.
And I'm going to start because I want to get a definition that you state in your report specific to this case.
Sure.
Is that fair? So officer-created jeopardy is, in essence, a manner of describing unjustified risk-taking that can increase the likelihood of injury to officers and can, correspondingly, increase the likelihood that officers will use force to protect themselves from a threat of physical harm that they were in part responsible for creating.
Yes.
So you agree with that? And I think you kind of compared it to like a standard of care.
Generally accepted practices I would describe as sort of a professional standard of care or common norms of professionalism. Officer-created jeopardy is one of the concepts that is generally accepted, but sort of generally accepted principles and practices broadly are what I would describe as more like a standard of care.
Okay, and so I want to, officer-created jeopardy, you say is generally accepted. And that's a term that gets thrown out a lot, especially by experts as yourself in the use of force category, right?
Yeah, either the term or the concept underlying it, yes.
And it's kind of the lens through which you're going to view whether or not an officer acted reasonably or unreasonably. Is that fair?
When assessing the tactical decisions, yes.
Yes, because you have to compare it to something. You can't just look at it and say, well, I think that's unreasonable for any good reason. It has to be, I think that's unreasonable because he didn't follow generally accepted police practices or tactics.
Correct.
Fair? Okay. All right, and so you define generally accepted principles as referred to those concepts and theories that are widely known, acknowledged, and relied upon in the field. Is that fair?
Yes.
And generally accepted practices refer to protocols, techniques, and procedures that are widely known, acknowledged, and relied upon in the field.
Yes.
Okay. I'm getting all this out of your report, so I just want to get to where we're going with officer-created jeopardy.
Sure.
And so they become generally accepted when well-educated, well-trained, and experienced professionals would agree that it is conventional, customary, and reasonably standard. Correct?
Yes.
And you indicate that there are various organizations that believe officer-created jeopardy, the consideration of whether or not an officer put himself at risk is generally accepted.
Every police organization that I'm aware of pays attention to an officer's tactics. So yeah, an
Sure.
officer who uses poor tactics may be subject to at least counseling or retraining, if not discipline, on the grounds of officer safety. Yes.
Okay, and so there are certainly sort of post-action reviews of whether or not an officer acted reasonably.
Yes.
Yes, it happens all the time. Training.
Sure.
That's how we get good police officers, right?
And how you continue to improve practices of your current officers. Yes.
Okay, and so you say that officer-created jeopardy is generally accepted because I think you mentioned some DOJ consent decrees.
That can be one area where generally accepted practices are reflected, yes.
And you talk about a civil settlement, U.S. versus City of Albuquerque?
In the description of vehicles, I think, yes.
Okay, it's one of the things that you relied upon in your report and that the prosecutor put in her motion. So you're familiar with that particular settlement agreement?
I would have to go back and look at it offhand, or excuse me, I would have to go back and look at it. I don't remember the details offhand, but yes.
Okay.
At least in broad terms.
So in the civil context, DOJ in that consent decree discussed officer-created jeopardy. Is that fair?
Again, I don't remember if they use that particular term, but certainly police tactics, yes.
Okay, well, there's a difference between police tactics because everything is police tactics, right?
No, not everything.
Well, everything related to what the police officers are doing when they're making an arrest, for example.
No, tactics have a very particular definition here, right? We're talking about how officers navigate or mitigate potentially risky situations. So there's a lot within police tactics, but not everything that police do is tactics.
And when we're talking about generally accepted, I just want to understand here. You're saying, with regard to officer-created jeopardy, certain tactics put them in an unjustified risk, right?
Use of poor tactics can, yes, absolutely.
And certainly, all experts would agree that there are situations where certain tactics would create a risk, right?
Yes.
Okay, and that's what you're saying.
Yes.
And you're talking about, when you're talking about how it's generally accepted, you're just talking about organizations that are discussing best practices when using police tactics.
No, it could be an agency that's implemented that generally accepted practice through policy or training. It might be an organization like IACP that's not presenting it as a best practice, but is instead just reflecting, for example, this is part of a national consensus, right? That's certainly what I would describe as generally accepted.
So you talked about the International Association of Chiefs of Police, and they have a discussion paper.
Yes.
Okay, Police Executive Research Forum.
Yes.
Moving Beyond Speculation and Towards Empiricism, that's a 2007 publication.
Yes.
In-agency policies, and you referred to a 2008 evaluation of the New York City Police Department firearm training.
Yes.
And firearm discharge review process.
Yeah, that was by the Rand Corporation, if I recall.
So New York has discussed officer-created jeopardy as, with regard to their practices, right? I assume it's related to the New York City Police Department?
Yes, it was, that particular one is relevant to officers drawing a weapon.
Okay, and the Department of Justice does not train its agents on officer-created jeopardy theory itself. They don't use that term, correct?
I don't know if they use the term. They certainly train on tactics and
Sure.
using good tactics and avoiding bad tactics. But I don't know if they use that term specifically.
And it's your opinion that there are certain circumstances where tactics caused the officer, in this case, to be in a situation where he had to use deadly force, right?
Sorry, can I ask for the context in which you are asking me that? In my role as an expert, I don't get into causal claims, right? In my research as a scholar, yes, absolutely. But as an expert, when you get into things like but-for or proximate causation and what is responsible, right? Who is responsible? That is beyond my scope. What I'm analyzing is an officer's tactics at the time. And regardless of what happens after, an officer can use a poor tactic that is officer-created jeopardy, that creates an unavoidable and unjustified risk, kind of regardless of what happens after that.
Well, I'll give you some context, because you wrote a report. You and Nicholas Bloomfield wrote a joint report.
Yes.
For this case.
Yes.
And you have 7 opinions with subparts, right?
Yes.
Okay. Can you tell us which opinions you're going to be providing as part of your testimony?
I guess that depends on which opinions I'm asked about. I would assume potentially all of them, but I don't know which opinions I'm going to be asked about specifically.
It's my understanding that you're going to separate the joint report into different opinions. Is that not your understanding?
I try not to get into issues of advocacy. I'm happy to talk about whatever is within the scope of my opinion and report, but I don't know specifically. I can tell you sort of in a broad sense, I don't know if that gets into issues of discussions that I've had with the prosecutor or not.
Okay, well, and I don't want you to get into those. I thought you might have an understanding of what you're going to testify about, in particular to your report. Can you tell us how officer-created jeopardy influenced your opinions or became the opinion in your report? Which opinions are related to officer-created jeopardy?
Sure. There's the opinion about the brief foot pursuit after the initial sort of hands-on and pulling away, where officer-created jeopardy is a component of that opinion. There's an opinion relating to the deployment, of the taser, where officer-created jeopardy plays a relevant role.
Those happen to be 3 and 5. Does that sound right?
Yes.
Okay. And then there's a 7th opinion regards to whether a reasonable officer could be in fear of the taser. Does officer-created jeopardy influence your opinion in that circumstance?
I'm not entirely sure what you're asking.
Well, I'm trying to figure out whether there's any relevance to your other 2 opinions. If it doesn't affect your opinion and the ultimate opinion that he wasn't in fear, or a reasonable officer wouldn't be in fear.
Okay. Yeah, sure. So my Opinions on officer-created jeopardy are a way of describing or identifying when there is a problem with an officer's tactical decision. That is, an officer's tactical decision is problematic or inconsistent with generally accepted practices, sometimes because it constitutes officer-created jeopardy, right? That is part of the standard, part of why I am coming to the conclusion about an officer's tactics. When it comes to an officer's use of force, I will often note, as I believe I did in this case, this use of force came after some tactical decision that an officer made. But it's the use of force, in my view, like I am not analyzing the use of force as more or less reasonable because it was the result or not the result of officer-created jeopardy, if that makes sense, right? I'm looking at a use of force and saying, is it a proportional response to the imminent threat that existed at the time? And we can sort of segregate out the why did that threat exist at the time? Was it a result of officer-created jeopardy or not? That might be legally relevant. But that's in a case where I'm retained as an expert. That particular question is above my pay grade, right? It is not my job to figure out what is legally relevant. I'm just analyzing an officer's actions at different points and comparing them to this generally accepted principles and practices.
Okay, and you were asked whether or not the foot pursuit was reasonable, and you gave an opinion.
Yes.
In the report.
Yes.
And you anticipate you could testify about that. And you also were asked to give an opinion about whether or not using a taser in close range was reasonable, and you gave an opinion.
Yes.
Okay. Do those opinions have any relevance to the ultimate question for this court, whether or not Officer Schurr was reasonably in fear?
I'm not trying to be squirrely on this. Again, I think that's a legal question. The question of relevance is a legal question and not one that I'm in a good position to answer, right?
Okay.
Whether it's legally relevant, I don't know enough about Michigan law to say. I'm not here to apply Michigan law. Could it be? Sure, there are definitely jurisdictions that apply an officer's actions prior as relevant using sort of standard but-for and proximate cause concepts, but that's not my role as an expert to do.
Okay, so you don't know whether or not it has any relevance?
Yes.
Okay. And you say you're not following Michigan law when you form those opinions?
I am not an expert in Michigan law. I'm not holding myself out as an expert or applying Michigan law to the point of saying this is criminal, this is not criminal. That would not be appropriate, or even, right, this is consistent with Graham v. Connor, or this is a Fourth Amendment violation. This isn't a Fourth Amendment violation. That would be inappropriate for an expert.
Okay. And so you talked a lot about scholarly articles, making it generally accepted. You talked about two amici briefs. I never know, is it amicus plural, or is it amici plural?
I think amici is the plural.
It just sounds right, but I don't know if it is. So you filed two.
Two of them just in the Supreme Court that touch on issues of tactics. One of them in the Fifth Circuit that touched on tactics to some extent, yes.
Well, the Fifth Circuit case was Barnes v. Felix?
The Fifth Circuit case, but I filed that, so that's a Supreme Court case. The amicus was in the Supreme Court case.
Did you file an amicus in the Court of Appeals as well?
No, the Fifth Circuit case there I think was TIMPA, T-I-M-P-A.
Okay, and that was a civil case, Barnes v. Felix?
Yes.
And there, I mean, the issue was the moment of the threat doctrine. Would you agree?
Yes.
Okay, and what you're looking at as to whether or not the totality of circumstances includes, in this case, the officer jumped in front of a car.
Yeah,
So
jumped onto a car, yes.
Jumped onto a car. The person that had been pulled over, or at least called the police, I believe started moving forward just a little bit, and the officers like jumped on the car.
Correct.
And then the guy took off, and the officer was like, I gotta shoot him now, because I'm gonna die, right?
Yes, more or less.
And it goes all the way up to the Supreme Court, and you would agree that a lot of people were interested in that case, right?
Oh, sure.
And the reason it goes to the Supreme Court is because it's an unsettled issue of law.
Yes, there is a circuit split on particularly this moment of threat doctrine, yes.
And the Supreme Court, as they often do, they hear all this argument, they give amicus briefs, they got DOJ, everybody seems to be involved. And did you listen to the oral arguments?
I did, yes.
Okay, and the Supreme Court's like, we're just gonna define this very narrow issue because they don't really want to decide officer-created jeopardy right now. Is that fair?
Until the opinion comes out, I don't know what they're going to do.
Would you agree with my assessment?
So Justice Kavanaugh seemed to be looking pretty broadly and wanted to talk about whether the officer's actions were reasonable. There were other justices who just wanted to, or at least were asking questions that I would indicate they are more interested in. Could we just say moment of threat doctrine is not a thing without getting into any broader questions? As always, the court is not an it, it's a they. So different perspectives, and I have no idea where that case is going to go.
Neither do I. I can't predict the Supreme Court. I just listened to the oral argument as well. And, to the extent officer-created jeopardy came up, you had both sides saying, well, this isn't about officer-created jeopardy, at least because they wanted the case to go forward if you're the plaintiff, and it's a civil case.
Yes.
And the defense, they were like, we don't want this to become the standard justices because that is not where we think the law is. And so both sides were arguing that. So would you agree with me that at least the Supreme Court has not decided whether officer-created jeopardy is settled law?
As a matter of Fourth Amendment law, the Supreme Court has not clarified whether, for purposes of establishing the reasonableness of an officer's use of force under the Fourth Amendment, whether you include an officer's pre-seizure actions, that is, actions before the use of force, or not. Okay. Yes, I think that's fair. There's a roughly 8-4 split on that. This Barnes v. Felix may give us an answer. We'll find out.
I don't think so, but we'll see, right? So, and I did read your brief. There's a lot in there about officer-created jeopardy and, considering the actions of the officer in a Fourth Amendment context. All right, but we don't know whether or not how that's going to come out just yet. Now, you've mentioned some scholarly articles. I noted one by Professor Cynthia Lee.
She wrote an article just 2 years ago or so on the issue. Yes,
that was the most recent one. I think it was 2021.
Time flies. Yes.
Yeah. So, but in there, she's asking for courts and to be generally accepted this reform effort, as she put it, because it's not an articulation of the current constitutional or law enforcement standards. She's urging the U.S. Supreme Court to, quote, go above the constitutional floor and consider the officer's pre-seizure conduct to assess the reasonableness of deadly force.
Yeah, I read her article to be arguing, particularly in cases of criminal liability, but liability more broadly, that applying these concepts of but-for and proximate causation, an officer's culpable conduct prior to a use of force should be part of the evaluation for a use of force.
Okay.
Yes, that's what I read her argument to be.
And you brought up criminal cases. There has been applications in other contexts where you sort of balance the negligence or recklessness of the officer versus what the suspect was doing to sort of determine whether or not, in the totality of circumstances, the officer's actions were reasonable, right? Like qualified immunity cases.
With Fourth Amendment qualified immunity, we're looking at an officer's actions as objective reasonableness. So we don't actually look at individual culpability in the sense of like mens rea, right? With specific mindset. We're just looking to determine whether their actions are objectively reasonable. In some states, under their civil or criminal standard, they might apply that particularly with reckless behavior that results in a homicide or use of force or something like that. Sure.
And then, so an officer's reckless behavior could be considered in 1983 actions. That's another context.
So that it maybe it can be, at least sometimes. It depends on whether let's say that there isn't a use of force and we just have reckless behavior. It depends on whether that reckless behavior is an independent Fourth Amendment violation or a violation of the ADA or something like that the 1983 provides a cause of action to. It may not, right? It may not establish an officer's reckless behavior without, say, harm to a civil plaintiff might not amount to a Fourth Amendment violation where there is a plausible 1983 claim.
Okay. And even in those contexts, there's a lot of learned discussion on whether or not that should actually apply in civil context. Is that fair?
Sorry, whether
you should consider the unjustified risk of the officer.
Sure, exactly how that fits in or should fit into the legal framework is something that, scholars and policymakers discuss.
Have you seen it in criminal cases where you're testifying about something that preceded the moment of the threat, that doesn't seem to have any direct bearing on it, but we're asking the jury to consider the negligence or recklessness of the officer and deciding whether or not he was honestly and reasonably in fear of great bodily harm?
Sure. So not, I like take cases that I've had some role in away for a second, like California's standard, for example, for recklessness or negligence includes not just the moment at which force is used, but the actions by whomever, including an officer, right, that foreseeably create those conditions. And if someone's actions, I forget what case that is in California, but if someone's actions foreseeably create the conditions in which they shoot someone, right, then we say, okay, well, were those actions reasonable? Because if someone acted recklessly at point A and that led directly to them taking a life at point B, then again, this is just a fairly straightforward application of but-for and proximate causation.
Right, and there in the California case, I don't know the name of it, what you're talking about either, but you're talking about whether the actions at the time deadly force was used were negligent, because it could be negligent homicide or something like that, right?
Sure, yeah.
Okay. How many cases, any cases in Michigan that you're aware of?
No.
All right.
None. I'm neither aware nor not aware of any. Again, I did not research Michigan case law for this at all.
Any second-degree murder cases of which you're aware?
In Michigan?
Anywhere in the world?
Yeah, Colorado just convicted an officer on what would be. The idea was tactical errors early, and this is the conviction of Buen, B-U-E-N. That is a case that I worked on, and the verdict certainly suggested that the theory was tactical errors that led to the use of force created that and were culpable.
So they had a verdict form that said that?
No, it's the. I forget what it's called in Colorado law, but it was it was not like the intentional. It wasn't the murder statute or the voluntary manslaughter statute. It was whatever Colorado has as their other version of that.
Negligent homicide?
I think it might have been whatever that something like that.
In a self-defense case to murder, have you seen that anywhere?
Sorry?
Well, this is a murder case, and Officer Schurr is charged with second-degree murder.
Right. I'm sorry.
Intentional killing.
I just didn't understand the question.
Okay, and the defense is self-defense.
Okay, I see.
Okay, that he was justified in using self-defense because he honestly and reasonably believed he was in fear.
Okay.
Okay. Have you seen an examination of the conduct that you might have believed or some other expert might have believed was unjustified and put himself in risk, therefore he could no longer argue self-defense?
Yes, so that's like the aggressor component of self-defense. And again, I'm not speaking of any one case specifically, and sorry.
In a murder context.
Yes, yeah, so I don't testify, I don't take cases as an expert in like civilian self-defense where we see more of these self-defense cases. But in criminal law, I have taught self-defense, and one of the aspects of self-defense is unlawful conduct prior to the moment where self-defense is used can render someone an aggressor. That's not in the policing context, right? But it's certainly conduct prior to the use of deadly force that then affects the culpability of that use of deadly force.
Well, and not, if you're not in the policing context, we don't have private citizens effectuating an arrest, for example, right? You can't pull someone over if you're a private citizen.
I certainly hope that's the case.
Well,
they do sometimes, but yeah, it's not great.
And you're not familiar with Michigan law.
No.
Okay. Are you aware whether or not there's even a statute about when a police officer can use deadly force in the state of Michigan?
I'd have to, actually I have to go back to the appendix of my book because we pulled all of the state statutes and cases. I think there's a statute, but I have no idea what it is offhand.
Okay. All right, so I want to talk about sort of the consequences of and relevance of these opinions that an officer might have been put himself taken unjustified risks to put himself in a situation. So let's say in this case you have an opinion that Officer Schurr should not engage in a foot pursuit.
Okay.
Okay. And time goes by, about another minute or two. He's in the position where he has to decide whether or not to use deadly force.
Sure.
If it's your opinion that he was unjustified in doing the foot pursuit, does that foreclose him from maintaining the defense of justification?
Are you asking how my opinions as an expert would relate those two, or are you asking like as a legal matter? Because the answer to the latter is I don't know. That depends on whatever the law of the jurisdiction happens to be. I'm no idea.
Okay. And I think you said before, well, we could talk about causation because I promised you we'd bring it up. But I mean, courts have generally considered whether the officer's actions leading up to the use of force were reckless and whether those actions were immediately connected to the need to use deadly force. That's something that you said.
Yes.
Okay. So they considered whether there's basically proximate cause, right?
Yes.
Okay. So if you're finding that he shouldn't engage in a foot pursuit has no proximate cause, is there a cause between the foot pursuit and the fact that he had to use deadly force later on?
Again, sorry, can I clarify? If you're asking about sort of the scope of my opinions, I don't get into proximate cause at all, right? I'm just analyzing separate points, separate decisions, separate actions separately. If you're asking legally, again, with the giant caveat that I am not an expert in Michigan law and would not want to testify about law, even when I did know what the law is, I think you're applying sort of normal principles of superseding intervening cause there. That is, you have an event that is culpable in some way that is a but-for cause of the ultimate result. Is it the proximate cause? I don't think there's anything sort of special about applying superseding intervening causes.
Okay, so
that's that's like academic law professor answer. I apologize, but in terms of as an expert, I'm analyzing what happened, what the officer did at point A, what the officer did at point B, and I'm not saying anything about point B. Sorry, let me rephrase that. I'm not saying anything about point A when I'm talking about point B.
Okay, so you're segregating these opinions.
I am.
You're looking at kind of like sort of with blinders on. Okay, I'm going to look at the foot pursuit. Was that done properly?
Yes.
All right, and you actually broke it down into 7 opinions, 4 of which, or 3 of which, you thought the officer did act reasonably.
Yes.
The stop.
Yes.
The initial grabbing and pulling to arrest.
Yes.
Right? And then things went south, in your opinion, when he chased him.
Yes.
Right. And I'm summarizing here.
Yes.
Because we're not going to get into the opinions now.
Okay.
The question is, for the court, and what the court's trying to decide is whether or not your opinions matter to the jury.
Sure.
Okay. But you're segregating these particular findings of unreasonable behavior.
Yes. So I mentioned in, sorry, I forget which opinion number it is. I think it's 4 offhand, about the sort of use of the empty hand strikes and knees, right? I mentioned in that opinion that occurred because of the foot pursuit, but that's not what my opinion rests on, right? Like, you could take the foot pursuit out of the picture entirely and still have that opinion.
The ultimate opinion.
Onto those use of force, yes.
Okay. Okay, and the ultimate opinion, or the final opinion, is that no objectively reasonable officer, presuming they knew that the second cartridge of the taser had been discharged, would have been in fear of incapacitation and therefore could not have been in fear of losing their weapon and therefore could not be in fear of great bodily harm or death.
I might say it a little bit differently, but yes.
Probably better than I just said. Right?
I don't know about that, but yes.
Okay. And you view those separately in and of themselves. Okay, so I want to talk about the standard or the burden for officer-created jeopardy because it seems to me that the opinions, opinion 3, opinion 5, suggest a negligence standard. He should have known not to chase. He should have known not to use the taser at close range. Therefore, his actions were unreasonable. Is that fair?
No, I am not imbuing any mens rea at all. I'm just looking at what he did and comparing that to generally accepted police practices, and it was either consistent or inconsistent. The degree of culpability for that is not something, like, culpability is ultimately a legal determination, not I think an expert determination. So I can say this did not match or this did match generally accepted principles. This was or was not in alignment with generally accepted principles. This is or is not what a reasonable officer applying generally accepted principles or practices would do. But I'm not saying therefore there was negligence, recklessness, knowledge, intention.
Now you're saying unreasonable. Maybe, I'm not a civil practitioner. I used to be many years ago. But that says to be a sort of standard of care that he violated. A reasonable officer wouldn't have pursued him.
Your Honor, I'd like to lodge an objection at this point. I think we veered away from the reliability and his foundation of his opinions, and we're getting into a second bite of the apple at cross-examination at this point.
I'm not sure if you have any other.
The officer-created jeopardy theory is based on a standard. That's all. Everything I'm talking about is the officer-created jeopardy theory, Your Honor.
Okay, I think some of that stuff kind of exceeded the scope of that, like asking him further along. But if you can, I don't know how many more questions you have with respect to the officer-created jeopardy issue.
I'll try to wrap it up, Your Honor.
Because I'm only trying to figure out if his opinions would be reliable.
Okay.
Reliably applied.
You're not going to consider whether it's relevant to the jury's consideration?
I've already determined that previously. Matter of fact, you mentioned that before we had him come on, that I've already determined that his testimony would be relevant.
So you've already decided that the officer-created jeopardy theory is relevant?
I'm trying to find out if it's reliable or not.
Okay. Well, I'll ask more questions on that, Your Honor. All right. Well, and to go back to whether or not it's generally accepted, you've heard of Force Science, the agency?
Yes.
Okay, and you're aware that, Von Klein, have you heard that name before?
Yes.
Okay, and you're aware that he does not believe that the officer-created jeopardy theory should be something to consider in the, when considering out whether the use of deadly force was reasonable?
So whether officer-created jeopardy is legally relevant to the determination of whether a use of force is reasonable, yes, I understand he has an opinion about that. He's also talked about, including on podcasts, the importance of police tactics and how they can affect ultimate outcomes. I think he and I agree on that point.
All right. You would agree with me that there are people that disagree with your opinion that officer-created jeopardy is not reliable, or is reliable?
I'm not sure I understand.
Well, you turned to a lot of scholarly articles. Can you, and obviously Mr. Bloomfield probably agrees with the theory. I don't even know.
I would hope, I can't speak for him, but I would hope he agrees with what's in the report.
Well, right? You guys wrote it together?
Yes.
Okay. Did you consider, when determining your opinions, did you consider GRPD trainings?
In assessing what may be reflected in GRPD or RPD trainings may reflect the generally accepted practices, yes. It's not my role as an expert here to identify whether the officer acted consistently or inconsistently with the agency's standard, right? I assume the agency is an expert in its own standard. So I'm not going to talk about whether the officer violated agency policy or did not violate agency policy. But it was in the scope of things that I reviewed.
Right. You're just deciding whether or not, in your universe of generally accepted police practices, whether or not his actions were unreasonable in specific contexts.
Right. Whether they were consistent or inconsistent with those generally accepted practices, yes.
Okay. And so you have no idea whether or not Officer Schurr is aware of any of these officer-created jeopardy or any of these other generally accepted police practices that you are going to talk about today?
No, I can't talk about his knowledge or lack of knowledge about any of them.
Okay. Thank you, Your Honor.
No other questions from the people, Your Honor. I do have a brief legal summation if the court's interested, but no other questions.
Yes, go ahead.
I know that people have filed a brief legal memo with the court summarizing the law that we're operating under. And I would just want to emphasize that when considering reliability, the court is just making sure that the expert's opinion is resting on a solid foundation. It doesn't need to be a universally accepted opinion. All experts don't have to agree, or his opinion need not be proven 100% correct. Just that it's based on sufficient facts, data, a reliable methodology, and comes from sufficient personal knowledge, training, or experience. And I would represent to the court that Professor Stoughton's testimony today shows his wide source material, his expert publications, his citation by case law, courts, other experts, being hired to provide expert consulting, filing amicus briefs, and then not only that professional experience, but also his personal experience as a trained law enforcement officer who has received training on the topic of officer-created jeopardy, all go toward establishing a solid foundation for his expert opinions that would then allow the people to argue how that fits under Michigan law and supports the facts of this case. Thank you. And he's also hot seat.
Thank you.
I was doing that.
Thank you.
And Mr. Procedural, the same.
Thank you, Your Honor. The prosecutor, Your Honor, is asking you to create a use of force law unknown to Officer Schurr. There's not a single Michigan court that has accepted this theory in a murder case. The U.S. Supreme Court in Barnington v. Felix declined to consider that it's not a theory. It's still yet to be litigated. Professor Stoughton acknowledged that it's an unsettled area of law. This court should not be the first in Michigan to accept Professor Stoughton's theory. There are citations to law review articles and civil cases. This is not the context in which this applies. It's not reliable because it has no application, especially in the case alleging self-defense. It doesn't account for intervening cause. It doesn't account for the standard negligence, which is recklessness. And the opinions here are based on negligence. He acted unreasonable with a foot pursuit. He acted unreasonable because he stood too close to him with a taser. Therefore, he can't argue self-defense. That's the suggestion by putting that information in front of the jury, that he's created this unjustified risk that is foreclosed from defending himself, no matter what happens. That's the problem, and you're going to confuse the jury completely by letting Professor Stoughton give opinions about things that based on this theory. Your Honor, it's absolutely dangerous if we're going to ask Officer Schurr that once you do a foot pursuit and you're negligent, that you can no longer defend yourself or others. That is what this theory says. That is what we're going to be asking the jury to consider, whether or not this has any relevance whatsoever. This is a murder case. The issue is whether or not he intended to kill somebody, and the issue is also whether he was justified in doing so. We ask this court not to accept this theory. It has no bearing whatsoever on this matter. There are other areas, as in the expert's report, that they can opine upon that actually might matter. But the theories of the foot pursuit and standing too close are not reliable in the context of this case. Thank you, Your Honor.
Well, as I previously stated, I wanted to hear from the witness regarding his opinion because under 702, MRE 702, a witness qualified, who's qualified as an expert by knowledge, skill, experience, training, etc., may testify in the form of an opinion if the proponent, which would be the people, demonstrates to the court that it's more likely than not that his opinion would help the trier of fact to understand the evidence or determine the fact of the issue, that testimony is based on sufficient facts or data, and it is a product of reliable principles and methods, and that the opinion reflects a reliable application of the principles and methods to the facts of the case. Here, there's no dispute that the witness, Mr. Stoughton, is qualified to be an expert as he has the requisite knowledge, skill, experience, and education. Again, the issue is whether or not his testimony would be the product of reliable principles and whether his opinion reflects a reliable application of the principles to the facts of this case. As he testified to, well, first I'll say here, part of what the jury has to determine, they have to take into account all of the circumstances in the case, not simply the moment of the shooting, but all of the circumstances. And there's been a lot of evidence and testimony surrounding what the circumstances were at the time that this incident occurred. In considering that, after hearing from Mr. Stoughton, he clearly testified that officer created jeopardy, that particular theory is a term of art, and that term of art, which was coined in the 90s, not by him, but by someone else, that particular term of art, officer created jeopardy, is regarding tactical decisions made by an officer which is subsumed within generally accepted police practices. So because I believe that he has testified sufficiently that he has applied the facts in this case to the generally accepted principles and practices which apparently are nationally recognized and nationally accepted, I believe that because officer created jeopardy in and of itself is not a particular method, rather a theory, again, subsumed within those accepted police practices. For those reasons, I am going to allow him to testify as an expert in use of force and generally accepted police principles and practices, because I believe that he's testified that he does, again, possess the requisite knowledge and training and education, and that his testimony would be relevant and could help the jurors understand the evidence in the case. So with that, what I'm going to do is we're going to break for lunch and come back at 1 o'clock. I've already let or put word to the jurors that they can have lunch and we'll continue at 1 o'clock. Is there anything else before we break?
Nothing from Your Honor.
I hear some whispering to my right, Your Honor. 1 moment. No, Your Honor. Thank you.
Okay, see you after lunch.
Well, good afternoon. I'm Lauren Baker. If you're just joining us, we're wrapping up the first half of day 2 in the trial of former Grand Rapids police officer Christopher Schurr. So far today, we've heard from 2 experts brought by in the prosecution, one being a senior manager for the Taser company that the Taser used in this case was from, another being a police expert. We'll get to those testimonies in just a moment, but first, like yesterday, we want to remind you all watching that we are delivering the live stream of this trial on a court mandated 30-minute delay. So what does that mean? Well, 13 on Your Side was instructed by the judge to stream the trial on this delay so that any sensitive information that was not supposed to be broadcasted, like personal details, can be redacted before it's put on air. There are no other modifications to how we are delivering this trial, and we will remind you about this delay throughout the day. We're going to now jump to 13 on Your Side's Callie Lichter and Riley Mack. They're joining us now in the courthouse. They've been watching this court proceedings all day long. Ladies, tell us, what have you seen so far?
Yeah, absolutely. We just saw from the judge kind of some turbulence in the courtroom today. Just before the lunch break, they had a potential expert whose appearance alone in the trial caused kind of contention in the courtroom. We saw Seth Stoughton, who is a professor of law and criminal justice at the University of South Carolina. He's also a police officer and a lawyer. He's studied police tactics for years and written multiple books. The defense immediately argued that he should not be included as an expert witness in the case. The motions to deny him immediately, though, were not approved. They were going to hear him out and see if he should be an expert in the case. The prosecution jumped in to prove that he could be an expert. Stoughton said he's testified as a use of force expert around 22 times across the country. He says he has never been denied as an expert in the courtroom. Matt Borgula, who represents Christopher Schurr, cross-examines him. He brought up his report that he submitted to the court. He said Stoughton made opinions on Schurr pursuing Lyoya on foot and trying to use his taser. He said that's fine. You can make opinions on that and you can justify those actions. He has issues, though, with him making opinions on what he called the ultimate question, which is whether Schurr was justified in shooting Lyoya. Stoughton says he made no opinions. He would simply be making statements in the trial on Schurr's actions that April morning based on his knowledge of police tactics. Borgula asked him if he knows about any specific Michigan statutes on police use of force and how they would play into the case. And Stoughton says, I don't know. I don't claim to be an expert on Michigan law, but he reiterates that he would only comment on Schurr's actions in that video, not what should be done about them, not how he should be punished. Borgula argued that Stoughton's testimony would confuse the jury with opinions and even called it dangerous. He said this to the judge in arguing that he should not be included as an expert on the case. The prosecutor then read from a court manual why he should be accepted as an expert based on his experience, based on his reliability in testifying. The judge, though, is the one that makes that final call, and right before lunch, she said she brought up the officer-created jeopardy term, which you may have heard on that live stream. It was a term that Stoughton said was made in the 90s by someone else, not Stoughton, and is generally widely used in police training. She said that the validity of his skill and education were never in question for her. She was just concerned about his reliability in his testimony. She felt in the end it was reliable because this officer-created jeopardy term is a term that's widely used, and not just by Stoughton. She ruled that he ultimately can be an expert in the case, that his testimony could help the jury understand that evidence. But Callie, it just kind of goes to show that this was the first time that there was true turbulence in that courtroom contention between the two attorneys.
I think there's been turbulence a couple times during this trial. I mean, what we've been seeing and what I've been reiterating this whole entire time is that you have two clear, very distinct views on, how this is going to go. I mean, we even saw it earlier with Brian Childs, and just, over the taser. And you had some, he was examined by County Prosecutor Chris Becker, and then cross-examined by the defense, and then he was. It was just like this back and forth and back and forth. And so I think this was just a culmination of actually almost weeks of back and forth over this one witness. But it's going to be very, very interesting to see how he is then cross-examined by the defense when we come back from lunch and ultimately hear his testimony.
Absolutely, and earlier today we also had one of the longer, cross-examinations of a person on the stand, an expert. Mm-hmm. Do you want to talk about that?
Yeah, so I know, we talked earlier when I was on about the use of the taser and kind of the two framings of this, and like I alluded to in my last answer, we're definitely getting to the point, what I call kind of the crux of this trial, is the two opinions, the two views of the two sides. And like every trial, there's going to be differences and things like that, but this here especially, I mean, this isn't, a misdemeanor case. This is felony homicide. It's a very heavy case, a very heavy thing that the prosecution is trying to prove here. And it just goes to show, the fact that this expert was questioned on, how to be an expert, or, his experience as an expert for over an hour. We were talking, like we said, 2 hours is the longest that an expert has been examined and cross-examined in this trial so far. And so, Lauren, sending it back to you in the studio, it's going to be really interesting to see how long this next expert is going to be examined and cross-examined.
Yeah.
And I want to talk about just the weight that these two experts have, ladies. We have seen that the taser has been a main focus for this case. Now we have a police expert, and we're expecting more police and taser experts. Talk about the weight of having experts on these specific topics.
So, when it comes to trials, and like I said, this isn't, a low-level felony crime or a misdemeanor. We're talking about like felony second-degree murder. That is a very, very, very heavy charge. And it's one thing to hear from people who were on scene. Like yesterday, we heard from two of Leoya's friends. And those are more of your story witnesses, your character witnesses. But when it comes to the experts, these are people who have been doing their jobs for at least, a sizable amount of time. They know what they're talking about. They have degrees in these sort of things. These are the people who really know what they're doing. And if you've been paying attention during this trial, for the people back at home, you can notice for the first couple minutes, in this case, an hour, when a witness takes the stand, they're being asked about their qualifications. Where did they go to school? How long have they been in their position? What do they do in their position? Things along that lines. And that's just to prove that they know what they're talking about, they're knowledgeable. And it's really, really important to both sides that they call in experts who know what they're saying. So it's not like you're just taking someone's word for it. These are, again, like I've been saying, these are people who have been practicing this, who have gone to school for this, who have been doing this for a very, very long time.
Ladies, we spoke with an expert earlier today who talked about he felt like the steam was going to pick up today. Yesterday, we only heard from a couple of people, not too many experts, but today we're hearing from experts. Do you feel like the steam in the courtroom is starting to amp up in terms of both sides trying to make their arguments?
Absolutely. Just today, yesterday we had 8 witnesses, and it felt very quick. Callie and I were speaking about just how much longer today feels with just the 2 hours of questioning. I was surprised by, half an hour going over the cross-examination of the expert. asking their educational background, their skills, their experiences, where they've testified before, how many times they've been an expert, and even questioning like the people that they've worked with on their books that they've written and things like that. These little details are certainly coming into question in the courtroom. Like Kelly said, this is, I think everybody knows the high profile nature of this case and is taking it very seriously with that cross-examination.
And you know, one thing, I was able to speak with an expert yesterday who's been helping us throughout this trial, and I simply asked her, I'm like, you know, is it like the TV shows and the movies where there's one, you know, bam, witness who kind of solidifies the case? And she goes, you know, those are in movies, those are in TV shows. She said that the prosecution, because this is their witness list, the defense has a whole nother set of witnesses that we still have to hear from. When it comes to the prosecution's witness list, they're really calling them in, you know, in chronological order of this case. We started off with the friend whose house he spent the night at, friend in the car, the neighbors who went out, you know, the first neighbor on scene, second neighbor on scene, and then we started hearing from experts, the analysis, and we're getting into the kind of this post-analysis here when it comes to the taser and when it's going to come to, you know, the police expert and other witnesses that, you know, we're bound to hear in this case. So yesterday, yes, we got through those 8 witnesses, boom, bam, done. But now it's going to get into the analysis of it, which I think is at the most contention of this case. You know, those witnesses who were on scene, the friends, the neighbors, that's what they saw. And yes, they were questioned about what they saw, but these are experts who are going to get a little more pushback because, again, they are experts in the field. They know what they're saying, and they can push them a little bit more because, you know, it's a more in-depth issue and topic that they're talking about.
And that's one thing I wanted to actually bring up to both of you is that we have seen the prosecution defense really kind of hit hard on those really specific details, and we just saw Stoughton push back on some questions, especially with the defense saying, I'm not sure what you're asking, or can you be more specific? Talk about seeing the process of both the defense and the prosecution really trying to get down to the specific details on what they're questioning these experts.
Absolutely. It definitely feels at some points it's kind of difficult to watch. It's a lot of the same questions being asked over and over, maybe phrasing it differently. It almost feels like we're like probing, we're prodding at the person to get to the heart of what they're trying to say. A lot of times yesterday it was hard to watch. These are people who, you know, lost someone, and there was a lot of questions at them in cross-examination of their testimonies. And today we're definitely getting into that nitty-gritty of, you know, even just, like I said, their experience is coming into question. So yeah, definitely a lot of similar questions being asked, and then the cross-examination, and it kind of happens all over again. But we've broken down a system of, you know, highlighting the most important details, and we've got all that on our website, 13onyourside.com. We've got a main bar story where we're just giving you the highlights, you know, so you don't have to listen to 45 minutes of cross-examination to find the important details of what was just being asked. You can find that on the main bar of our website. That's our live article.
And when it comes to, you know, these questions, like Riley said, they are similar. They're going to be asking similar questions. But it kind of goes to the point, like, even though this is the prosecution's witness list, these are people that they are calling in, that they believe will help, you know, build their case. They're not going to be 100%. Obviously, when you take the stand, you have to be 100% truthful and honest. That's the oath you're taking, or else you can be charged, actually, with perjury, which is a crime. And so these people have to be 100% truthful in what they're saying. So they're not going to, you know, say 100% the things that the prosecutor probably wants them to say or wants to hear. So that's why you ask a lot of questions over. There's been some times that Becker has asked a question in one way, that the defense has asked another way, and they've gotten, you know, a little bit more deeper into the answer that's kind of like probed it and could possibly help their side. And again, both sides are going to keep on questioning these witnesses until they hear something that, you know, hopefully for them benefits their case. And that's why we're seeing today, you know, this 2-hour examination, cross-examination, and now 1 hour of just trying to, you know, see if this witness should be considered an expert and even allowed in the trial in the first place. It's just to get to that main point at the end of the day that, you know, these people are hopefully going to help either side of the case. And even though it's these people are not defense witnesses, the defense is going to try to get them to, again, help their case.
I think we saw a lot of that too this morning with the taser. The person from Axon Technologies was, speaking first to Kent County Prosecutor Chris Becker, and he was asking a lot of questions that kind of gave the response that a taser is not so much a fatal, dangerous weapon. And then the cross-examination happened where, a little bit different questions are asked, and we learned, a taser can be fatal. And it really depends on the questions that are being asked. You can see it just in that one testimony today, in that 2 hours, how much changed depending on the questions that are asked, and how much the case could change too.
Well, Riley and Callie, we appreciate your reporting. We think that proceedings for you all will start very soon, so we're going to let you go. Thank you so much for helping us out, ladies. And again, it's a reminder that while proceedings may be starting soon, we are still on that 30-minute delay. So as soon as proceedings start and that 30-minute delay has expired, we will bring you the most up-to-date on the proceedings. We now have a team of experts who have been watching this trial with us, and we'd like to bring them in. First, we'll introduce Tanya Kraus-Phelan. She's the Associate Dean of Academics at Cooley Law School here in Michigan and has been teaching at the college for 20 years. She's a Ferris State grad and has worked as both a criminal defense practitioner and assistant public defender. Also joining us is Andrew Rodenhouse of Rodenhouse Law Group. Andrew is a trial attorney and graduate of Hope College. Andrew received his Juris Doctorate degree from Cooley Law School and oversaw the appeals of case of People versus Ackley, which changed Michigan law as we know it. And finally, we have Sarissa Montague. She's a criminal defense attorney with much experience, a lot of experience in providing defense for those who are unable to afford their own. She is highly regarded as not only an exceptional litigator, but also an empathetic counselor. All three join me now. Thank you so much for joining me, everyone.
Good morning. Thank you, or good afternoon. Thank you for having us.
Good afternoon.
Thank you for joining us. So I want to just kind of start off with just the very basics. We saw a lot happen today with those two experts, the two really big experts we're supposed to be hearing from first. Tanya, you're on the screen right now. What's your initial reaction to what you're seeing?
Well, as a former criminal defense lawyer and a law professor, who, by the way, I have to give a shout out to Andy Rodenhouse. He was one of my most exceptional students. But having said that, the law geek in me comes out because listening to these two expert witnesses, one who was allowed to testify and one who we had to go through a voir dire process for, it was apparent to me that the prosecutor really selected two unicorns, right? And what I mean by that is the expert from Axon regarding the taser was very personable, very knowledgeable, down to earth, and related well to the jury. And to Kaylee's earlier point, he was calling balls and strikes, right? So he answered very directly the questions that the prosecutor asked. But on cross-examination, when probed deeper into very specific issues, especially the idea that that taser could still be a dangerous weapon even after deployed, he told it like it was. And so the jury really received a full picture from his perspective from the direct and cross-examinations. Now, as we listen to the voir dire of another legal expert unicorn, I mean, when you're talking about an expert witness, right, Professor, I forget his last name at the moment, but he was a police officer. He is a licensed attorney, non-practicing, and he's a law professor and has been considered in numerous situations to be an expert on police use of force. So from a qualification standpoint, that's pretty impressive. What they were arguing about during voir dire of an expert witness is where the lawyers are trying to determine whether, one, is this person legally qualified to be an expert witness, and two, will what they say actually help the jury in determining the issue they'll be asked to decide at the end of this case. And so that's where you saw the focus of most of the questions.
And Sarissa, I wanted to get your opinion as well. What have you found interesting so far today on day two?
So I actually appreciate what Tanya just was talking about. She was really detailed in kind of what happened this morning. It is fascinating as a practicing trial lawyer, but I think probably more for people who are watching this who don't do this day in and day out, how important it is to phrase questions in particular ways, because what they're doing is you're trying to get a witness to say what you want the witness to say, right? And so crafting the proper question, addressing the proper topic is crucial. You know, the witnesses aren't allowed to just share the information that they want to share. They are only allowed to respond to the questions that are given to them. And so if you're not careful in the way that you phrase something, in the way that you pose something, you very easily could miss the topic that you want, that you want someone testifying to, or the expert cannot have the opportunity to share the information that he or she has when they're not just asked the right questions. So I think that this morning was a very good example of what it is when you get into the nitty-gritty of questioning experts. And it gets boring. Honestly, it just does. People think that trials are, all this glorious, stuff that we do all the time, and it's not. And it is the nitty-gritty. And it's hard because jurors are regular people. And if an expert gets to the jury, if the jury has the opportunity to listen to the expert, it's kind of boring. And that's an issue too, because the points that are coming out are so important. And so that's something that the lawyers need to be aware of is how do you keep the jurors engaged when you're talking about, how something functions. It's just not that exciting, right? And so doing a good job of that is super important when you are in a situation such as this one.
And I wanted to let our viewers know we have just learned that Stoughton, the person we've been actually talking about, that last witness we saw, has retaken the stand. We'll be able to see that in about 30 minutes, but we wanted to let all you know. But I wanted to jump back to Andrew. You've been watching this case along with us. What are your thoughts on this second day so far?
Well, I have quite a bit of notes. I've been able to sit here and watch trial as I'm in my office doing work. And again, shout out to my favorite professor, Tanya Kraus-Phelan. My favorite class also was criminal procedure, and so it's good to see her here. First of all, I wanted to note that our Axon expert, I think he was a straight shooter. He just wanted to tell the truth about the Axon equipment. Both parties were able to get him to answer questions. He was pretty straightforward about it. I think that last question the judge asked was a jury question about the trigger on the taser and stun gun. I found it interesting that he testified that if you're not trained in their equipment and in the hands of a person who's not trained, that actually they don't consider it to be less lethal, they consider it to be lethal. And so I thought that was an interesting take. Mr. Dodd was able to get that out of him. I had my own thoughts on whether or not the professor should be allowed to testify when I was listening closely to Mr. Borgola question him. Under Michigan Rule of Evidence 702 is the rule that governs that, and it incorporates largely with the federal rules of evidence. And the judge is the gatekeeper over whether or not certain evidence can come into court and the jury's allowed to hear it. One thing I was surprised by was that they did it at this late in the game. Normally challenges to those experts are done well in advance of trial. Perhaps it was a cost issue or they had a hard time getting him in to court. I don't know what the strategic reason would be to do it during trial. In any event, it sounds to me like this officer created jeopardy. See, you have to understand an officer on trial for homicide needs to be treated the same as a layperson who's on trial for homicide. The instructions are going to be the same. And so what I'm concerned about is that if you have this officer created jeopardy, that somehow creates a higher burden for Mr. Schurr in front of the jury and for the jury to consider. And I don't know what he's going to testify to. We're about to find out. In about a half hour, we'll be able to listen to him. But my concern is that it creates a different standard for a police officer versus a normal person. And they're supposed to be the same in the eyes of the law, especially when it comes to homicide.
And I wanted to actually continue on that because I know that for people who are watching, when they hear experts, he's a professor, he has experience, some of us may think, oh, he knows what he's talking about. Can you better explain what Bergola was trying to argue, but then also explain to us a little bit more simpler in terms why the judge ultimately said, no, he can testify?
Well, I think that all right, so there's a lot to unpack when it comes to experts, and there's just a lot. And so to try to do it on something like this, we'll give it a broad brush, but when it comes right down to it, there's first of all, is what he does, is it reliably testable? Like, can you go out and can you test his hypothesis? Has he been published? Has he himself looked at the facts of this case and used whatever his expert knowledge is, or is he just bringing in just general expertise in an area? It sounds like there was a report that's been authored, and it sounds like the report is severable into several different parts. I don't know what that report says, and we're about to find out what is part of it's going to be admissible and what's not. So I don't know what that report says. Again, this is oftentimes why you bring this well in advance of trial. I know I've done a lot of these 702 challenges, and usually the judges are deciding these months, if not even a year in advance of trial, on whether or not the expert's going to be allowed to testify. Oftentimes you want to find out just so if you need to bring in your own counter expert. And again, does this shift this? The whole thing is this something that's even a thing? And apparently it is a thing. This officer created jeopardy, and Mr. Bergola asked, well, how many times have you actually testified in a criminal case? Because it seemed like all his testimony had been in civil cases where we have different standards than we do in criminal cases. And so, I don't know. If the judge is wrong, this gives Mr. Schurr an incredibly large appellate parachute if he is ultimately convicted. But is my simple takeaway on it.
And I wanted to bring back in Sarissa. Sarissa, something interesting that you mentioned is keeping the jurors entertained. You know, yesterday we saw 8 people and it seemed to go very fast. The testimony seemed to be on the shorter side. But today we've only seen 2 experts, one of those experts now coming back for the second time. In your experience, how do you keep the jurors engaged in the case, especially when you're talking about very specific things?
It's really hard because this testimony, it's for the jurors, but it's not really for the jurors. I mean, you need the jurors to understand the information so that I guess I'd say this, it's absolutely for the jurors, but as a trial lawyer, you need to recognize that they're not listening to every detail. They're just not. And so you try to get your big points out there to be supported then by the smaller points that make up, the testimony. You hope that the jurors recognize, even if it's not, really exciting testimony, that they're there to do a job, and it's their job at that point to listen to the information. And I think that by and large they do. I mean, sometimes you might see some people kind of zoning out or nodding off or whatnot, and I'd like to say that doesn't happen, but it definitely does. But you just hope that they do the job that they've been sworn in to do. And in my experience, jurors do take their job seriously. They recognize how serious, particularly this one that it's a homicide trial, right? They realize that this is a big deal, that it's super important, that people's futures are on the line, and that they do the job that they're supposed to do. And you also hope that the judge grants some breaks in there so that they can get up and move around. That is helpful.
And Tanya, I wanted to bring you back in because you mentioned something about these 2 experts being what looked like unicorns. And I want to specifically talk about the second gentleman we heard from. He seemed to give a lot of pushback, not necessarily pushing back against the questions, but saying, how do you want me to answer this? What are you specifically asking? What's your take on how that testimony, both for the defense and prosecution, how is that going for a trial like this?
Well, a couple of things to remember. That voir dire took place outside the presence of the jury. And I think the professor was trying to make sure he was answering specifically what was being asked. and you'll notice most of the time he pushed back, he was saying, and I don't even know if we can call it pushback, but he was saying, look, that's a legal issue beyond what I'm being brought here to testify about. And he also indicated that he's not an expert in Michigan law. So he was really trying to keep what he was testifying to focused in on his area of expertise. But I'd like to bridge that back to something Andy said. And as we watch his testimony unfold, and as we watch the cross-examination of this, it's really important to watch how the lawyers handle the questioning about Schurr's state of mind at the time these events happened. Because at the end of the day, the prosecutor has to prove, right, that Schurr caused Mr. Leola's death and that he intended to kill, but he also has to prove that it wasn't justified. And for it not to be justified, he has to show that Schurr did not have a reasonable fear of imminent death or great bodily harm. And we'll tie that back to Mr. Borgula's cross-examination during voir dire of the expert. He was trying to get to the point with the judge that, look, this, the officer created jeopardy doesn't have anything to do really with what was going on inside Mr. Schurr's mind at the time. And that was the argument he was trying to make, because the expert had 7 conclusions he reached in his report. And it doesn't seem like the defense was arguing against some of those in the context of officer-created jeopardy, but it was that last one, number 7, about what Schurr was thinking at the time. And that was the conclusion they were trying to prevent the jury from hearing. So that's crucial. What Mr. Schurr was thinking at the time he acted is crucial to whether the self-defense defense will work and prevent the prosecutor from obtaining a conviction. So to be curious to see how those all tie in.
Well, Tanya, I have to ask, we're not sure if Schurr will take the stand or not. And you're saying that they have to prove what Schurr was thinking. How does that come into play if he does take the stand and let's say he says, oh, I was thinking this or I was thinking that? Does that throw away all that we've heard? Or, to me, that just sounds so difficult to come back from if that does happen.
Well, and I think Sarissa and Andy will agree with me on this. There's a general rule in criminal defense that nothing good usually comes from a defendant taking the stand, right? Because jurors already come in with preconceived notions. But in a defense like self-defense, a defendant, although they have the right not to take the stand in a criminal trial, they also have the right to. And because what the officer was thinking at the time he acted is critical to that defense, it really leans a defendant toward taking the stand so that the jury can hear from the defendant's own mouth what he or she was thinking at the time. Now, I'm not trying to place any burden on the defendant to think he has to testify, and that's not my place. I'm not his lawyer. But it's very common, I think, in self-defense cases that the defendant does take the stand so the jury can hear what was in their mind at the time.
Andrew and Sarissa, I wanted to pose that same question to you, and I wanted to get your take. We'll start with Andrew. What are your thoughts on that?
Well, like I said before, it's very difficult in a case like this, particularly self-defense, to prevail without taking the stand to testify. I've never actually heard of it happening. I've never seen it happen in real life with myself. And oftentimes when I'm doing a case in self-defense, a significant amount of my prep time is with my client discussing what their testimony is going to be and how we're going to present different things. And so I would expect that Officer Schurr, who's a police officer, and so he had at least at some point in time has had some training in how to testify in court and what the role is. I would expect he was a young officer. I don't think he's had a lot of previous experience, and so I don't know how much testimony he's actually given in court before, but I can imagine that he's got an excellent legal team, and I'm sure they'll have coached him up if he's going to take the stand, because like the good professor said. It's very difficult in a case like this. While you have a right to remain silent, it's like almost impossible in a self-defense case because the jury has to know what were you thinking, what were you doing, how were you feeling, like all those things. A lot of that stuff is going to be emotional too, and so I would expect to see him testify. But again, he's not required to, and the law says If you don't, then the jury can't hold it against you.
And Sarissa, you were just talking deeply about keeping jurors engaged and trying to give them as much as possible to help their decision. What are your thoughts on that question?
So it's interesting. I've seen it go both ways. It is, you need the jury to understand what is going on in the, in the defendant's mind at the time, right? That's true in every case when you have self-defense. And then the question is, how do you get the jury to understand that the best way possible? As Tanya said when she started out, it's we usually advise against defendants testifying. However, you do need to be able to convey to a jury that a person honestly and reasonably believes that, they needed to use the extent of force that they did, right? And so there are times when you can get to that information in a different way, right? If you have, we just had a case where there were past experiences. Somebody had been threatened before. Somebody had been shot at before. So, at a previous, a previous incident, and so it's not so crazy for a jury to conclude if the person who has been shot at before by a particular person then encounters that person at night in a dark place that they could, that person had a gun, then you can kind of draw the conclusion under those very specific circumstances, right? But that's few and far between, right? But that's kind of an extreme circumstance. So I have seen it go both ways. And in both of the two incidents that I'm talking about, both people were charged with murder, and ultimately both people were convicted of manslaughter. So you got, the jury didn't believe in either case the full self-defense, but they also didn't believe that there was malice involved in the shooting, and so they convicted on the lesser of manslaughter. So, it's a hard question. It's ultimately up to Mr. Schurr. If he wants to testify, it is his right and only his right, and it's only up to him to give up that right should he choose to. So I'm sure it will be with the consultation of his attorneys, and they will make that decision together. But it is it's a hard decision.
Well, Sarissa, Andrew, and Tanya, I want to thank all of you for coming on and kind of breaking down some questions that I know a lot of viewers have. I know you will be continuing to watch this trial. We hope to tap into you all once again, maybe later today or tomorrow.
Thank you.
You want to now go to 13 on your sides, Josh Albertus, who's live outside the courthouse. Josh wanted to draw attention to a rally held outside the courthouse yesterday from a state rep. What was he there for, and what was he talking about, Josh?
Yeah, it's actually an interesting piece of it, Lauren, because as you probably remember, there had been some civil action as well from the Loyola family against former Officer Schurr as well on the civil side. This representative was here yesterday kind of calling that press conference. He's from the east side, but he was coming here around this trial to talk about what he says was a bill that would change the self-defense law here in Michigan when it comes to both the civil and criminal aspects of this, because what he was saying was that many times people may still have to prove their civil immunity in cases, even if in some of those instances they were already cleared criminally. So what he was saying, you have people on either side. We're hearing some people down on the ground right now, still demonstrating about this. You have many people, of course, saying, this was an unjustified incident, and what they see as justice is a potential guilty verdict. But, you have others saying, despite what they say is former Officer Schurr's innocence, they say his life is basically destroyed by the legal action here. So what you're having this Representative Jim DeSanta from over on the east side in Carlton saying yesterday was actually that this would have to do, his bill would have to do with changing the state self-defense law from about 2006 to assume civil innocence, he says, even after what he called a favorable criminal outcome. Take a listen to some of what he had to say to reporters yesterday to kind of bring that into context.
Currently, defendants must still prove in civil court that their use of force was justified, even if cleared criminally. House Bill 4404 fixes this by creating a presumption of civil immunity after a favorable criminal outcome, shifting the burden onto the plaintiffs to prove otherwise. It also explicitly covers the threatened use of force, people who might warn an attacker versus someone who just uses force without warning an attacker, which is not clearly protected under current law. This change to the law will offer the defender full recovery of legal costs. People found immune can recover attorney fees, court costs, and lost wages, easing the financial burden of defending themselves. While someone defending themselves has a moral responsibility to do what they possibly can before eliminating the threat, an ordered society must also defend those who, for the sake of their own life, for the sake of the lives of others, must act in a split second to use necessary force to stop their attackers. My father had 3 brothers and 3 sisters. One of his brothers was a fireman, and one of his brothers was a policeman. In 1967, riots broke out in Detroit, and my Uncle Jack was sent in to fight the fires. On the first night, my uncle and his fire engine crew were shot at by the rioters. The next night, my Uncle Phil was sent in with the truck, riding with a shotgun to defend the firemen. They were given orders to shoot to kill anyone who threatened them with a gun, knife, or a firebomb. It was an extremely unfortunate situation to be sent into, and my grandmother feared the loss of her 2 sons. We stand here today to defend life, not to take it. We stand here today with Officer Christopher Schurr. Thank you.
And so obviously, as you were kind of hearing there, you know, the legislative arms of Lansing, if you will, kind of reaching into this aspect as well. Obviously, we are going to remind, you know, obviously no verdict yet in this case, but people, you know, talking about changing the self-defense law for what they feel are cases akin to this going into the future, Lauren.
I have to ask, this is obviously a brand new bill. What is the status of it right now?
Yeah, so Representative DeSantis said that he introduced this last week. He was announcing it yesterday at this press conference, but basically the timeline that he gave for this, his estimation, his expectation was about a month, but it can vary from case to case because there is a process that, you know, after you announce your bill, there's got to be a long process for it to go through. After you announce it, after you introduce it on the House floor, it's got to go to committee, a smaller group of those lawmakers in a select committee who will kind of debate it further, hear testimony, pass it out with or without any, you know, recommendations or substitutions in some of the language of that. They'll send it back to the full chamber. That's when you'll hear it read a second and a third time. And then, you know, if it makes it through that process, if the committee approves of it, then you're going to see the full House take a vote on it. So his estimation for people yesterday was about a month, but we'll have to wait and see exactly how long that timeline actually ends up playing out. And if it does pass the House, he did, you know, kind of indicate, you know, he feels there is support for this, but if it does pass the House, then move over to the Senate and see where it ends up from there. But that all remains to be seen, whether or not that timeline actually does play out. But he seemed confident that there is support for this kind of idea in the legislature, Lauren.
Well, Josh, we appreciate you covering all angles of this case. We'll continue to check in as things progress. We wanted to bring your attention to our live blog. As we've mentioned plenty of times, we are on a 30-minute delay. Court proceedings have already restarted around 1 o'clock today, and Stoughton was brought back to the stand. Riley Mack says that the prosecution continued to ask Stoughton's about his education background, published work, and police. And the defense got one successful objection. Kent County Prosecutor Chris Becker had to rephrase one of his questions. So as you can see, there's going to be a lot more questions into this latest witness and maybe some of his background to be able to talk about things on this case. We're just about a couple minutes away from being able to show you those proceedings again. I'm hoping that maybe our producer Eric can bring up some sound from the previous witnesses. Eric, can you help us out with that? Okay, we're going to bring up some sound from the expert.
When you find the taser was deployed in that report, is that true?
That's correct.
And you had it after you take a look at those pages, and those are an accurate depiction of what the taser looked like, reflecting when the taser was deployed. Is that true?
Yes.
Don't know if I remember, just to make sure, Your Honor, I moved the admission of exhibits 26 and 27. I wasn't sure, so as long as we got them in. So this is exhibit 26. You're just talking about it a little bit. Can you tell what we're looking at here?
Yes, so this is page 19 of my report, and I include screenshots from the body-worn camera from Officer Schurr. And this shows the reason to screenshots is to kind of show the movement. But you can see this is right when the weapon is being deployed the first time, so cartridge 1 is being deployed. And the subject, you can see his hand pushing, so he pushed the weapon away right before it was deployed. So the probes did not hit his body.
So you can tell it didn't hit anything. How can you tell that? How does it register?
There's a few different ways. One is looking at the probes. The spears were bent. Typically, if they hit flesh, they don't bend. So they hit a hard surface. We don't know what that surface was, but they hit something hard. And the second way is the weapon records in a pulse log. Every pulse, I mentioned the 22 pulses per second, every single pulse that it tries to generate, it records the output charge that it delivered and the voltage across the capacitors when it was discharging. And those tell a story of what the weapon discharged into.
And we are possibly being able to go back to court proceedings. We, again, are on that 30-minute delay. I'm waiting to get some more information from our producer. And we're just going to chat here for a few more seconds, but proceedings are getting ready to start again. Again, what you're going to be seeing is you're going to be seeing the latest witness, Seth Stoughton, talking on the stand. There are some more questions that the defense and prosecution has for him. As soon as we're able to jump into that, we'll be sure to let you know. But once again, if you'd like up-to-minute updates, we have our Riley Mack, who is at the courthouse right now, able to watch this court proceedings live. She's been updating this blog all day long. As you can see, the judge has now gotten back into the courtroom. We're going to head to those proceedings right now.
Nothing, Your Honor. Your Honor, for purposes of Professor Stoughton's testimony, we continue to object to relevance. I won't object during his testimony. We want to preserve our right to argue that the testimony we just talked about is not relevant should there be an appeal of this issue.
Are you saying that generally accepted police practices and principles are not relevant?
No, Your Honor. I'm saying that Professor Stoughton's testimony is not relevant.
Okay, I think that's what he's testifying about. So
His opinions are not relevant.
okay. Okay. Maybe you've made your argument, so I appreciate it, or your objection. All right. And so, anything else, Mr. Bordula? Before the jurors come in?
No, Your Honor.
Okay. We'll have them come on back in. sorry for that extended break. Treasury may call your next witness. And I'll remind you that you're still under oath.
Yes, sir.
Still under oath, but just for the jury's benefit, since you weren't here for the first time, we kind of went through this, could you state your name and spell it for the record?
My name is Seth Stoughton, S-E-T-H-S-T-O-U-G-H-T-O-N.
Could you tell the jury what you do for a living?
I'm a professor of law at the University of South Carolina, Joseph F. Rice School of Law, and the faculty director of the Excellence in Policing and Public Safety program there.
Yes, I could split that up. Could you tell the jury how long you've been just purely a law professor at the University of South Carolina?
I'm just finishing my 11th year there.
And knew that, I didn't get the whole title, the policing aspect of it. What is that, and how long have you been the head of that?
The Excellence in Policing and Public Safety program is about 2 years old now. I've been the faculty director the entire time. It's a legislatively funded program in South Carolina to help provide training, professional development, and research and technical assistance to police agencies in South Carolina and beyond. We spent the last 2 years doing training of groups of police executives in South Carolina. In August, we will launch the country's first master's degree at a law school specific to public safety executive leadership.
Now, when you talk about training executive leadership for the police department, what is executive leadership defined as?
When we're talking about police executives, we're really talking about what's often referred to as command staff members. Exactly what that rank is will depend from agency to agency. At a very large agency, that might be captains or majors and deputy chiefs and a chief. At a much smaller agency, it might include sergeants or something like that. But if you think in terms of rank and file officers and sort of middle management, anything above middle management is really what we refer to as police executives or command staff.
Now, you're saying this is only 2 years old. Could you give a little bit of background? How did this get started? Why did it get started?
Sure. So I and some other folks that I work with at the University of South Carolina wanted to look for ways that we could bring academic resources at a top-tier research university to local policing. We already had pretty good relationships with local agencies on an individual basis. I do a lot of work with specific agencies, either assisting them with research needs or asking them to assist me with research needs. But we wanted to do something to sort of institutionalize and formalize that. In South Carolina, there is no executive level training, no professional development for police officers. We end up sending our police executives out of state to programs like the FBI's National Academy, and we wanted to develop some in-state capacity for that to help support the state and the community. So those discussions started about 4 years ago. We spent about 2 years putting together proposals and sort of refining what exactly we would be doing before getting the initial block of legislative funding in, I guess it was October of 22, and really launching in operations in January of 23.
And so you've been part of that process since the inception, working, who else are you working with? Is it just purely the university, or is it other entities in the state of South Carolina?
We have an advisory board that's made up of about 60 or 70% South Carolina law enforcement.
I'm going to object, Your Honor, at the relevance of his knowledge of South Carolina law.
It's nothing to do with South Carolina law. It's who this police training agency covers, not just South Carolina, but other places.
So you're just asking him for background information?
Correct.
At this time?
I'm not asking an opinion on anything. It's just background information on what this is all about.
Okay, you said what this is all about.
The police training facility that he's starting up.
Okay.
The relevance of him setting up a police training facility in South Carolina is not relevant to this matter.
Lays a foundation as an expert in this area if he's going to be talking about police practices.
Well, I mean, I would tend to agree as far as getting into detail about it, but the fact that he's setting something up is fine.
Okay.
So I guess I'm partially sustaining based on whatever the next question. You can answer that question.
The question I had, or the question?
What was the question that you just asked?
Just in terms of what was the purpose of setting this all up? What was the purpose of setting this up?
Oh, then I'll just sustain the objection.
Could you go a little bit of your educational background?
Sure. I, let's see, in chronological order, went to high school in South Florida, went to Florida State for undergrad. I'm a little slower than the average bear, so it took me 10 years to get a 4-year degree. I went from there to the University of Virginia for law school, and that's it for formal education.
Okay. Now, in terms of after graduating the University of Virginia Law School, did you become a law professor right away?
No, not right away. I spent a year clerking, working for a judge. I was set to go back to a law firm in Charlottesville, but had the opportunity to do what's called an academic fellowship. The academic fellowship is really designed to help prepare you for entry-level legal teaching, to learn to be a law professor. It's kind of like a postdoc, but for JDs, for lawyers. So I did that for 2 years and then went on the entry-level market and was hired at the University of South Carolina.
Now, at the University of South Carolina, specifically, what do you teach there?
Within the JD program for law students, I teach criminal law, which is our first year required criminal law course. I teach a course on criminal procedure, which is 4th and 5th and a little bit of the 6th Amendment. I teach a class called Police Law and Policy. I teach a class called Regulation of Vice, a seminar really. I have taught some other classes, but those are sort of my current teaching package.
Do you do something with the undergrad facility as well?
I have a courtesy appointment within the Department of Criminology, so I'll go over and lecture in coworkers or colleagues' classes. I have taught an undergrad version of my Regulation of Vice seminar with our honors college, but I have no real normal teaching responsibilities at the undergrad.
Now, in terms of your experience within teaching criminal law, criminal justice, and policing, have you done any sort of publications? Have you wrote any books, articles, anything along those lines in the field of criminal justice, criminal law, or policing?
Yes, that is the other half. I have about 4 different halves of my job. One of those halves is academic research and publication. Articles, essays, book chapters, 1 book so far, and the occasional other professional writings, editorials or amicus briefs and the like.
What is the 1 book so far that you've authored?
It's very creatively called Evaluating Police Uses of Force.
Now, in terms of, you say people ask you to write book chapters then for their own books, can you describe that a little bit more? What does that mean?
Sure. So there are academic books that are written by a single author that follow a sort of arguments or series of arguments. There are other academic books that are edited volumes of collected chapters where every chapter is written by a different author presenting something about whatever the overall topic is. So I've done book chapters on in a book about sort of law generally. My focus was on law relating to police misconduct around the world. I've done book chapters on evaluating police use of force incidents, on review and evaluation of police use of force incidents, on evidence-based policing and its applicability in modern policing, a range of topics.
And now, in terms of that, in terms of a lot on policing, do you have any experience in policing yourself, separate from your academic kind of credentials, any practical experience in policing?
I do, yes. I spent 5 years, just under 5 years, as a full-time officer with the Tallahassee Police Department in Florida, and then another 6 months or so as a reserve officer, a part-time officer at the same agency.
Do you do anything, I guess, currently, taken away from your new entity, do you do anything currently with any police agencies or police departments through your work in the law school or as a professor, or involved in that any way in any other police departments, if you will?
Not including through the policing program that I run. So not including through the policing program, I will occasionally be asked to come in and do training or to lecture on a particular topic. Once once I was asked to formally come in and investigate and review a use of force for, not actually by the agency, but by the city council of this city involving this agency. I'll be asked to come and speak in training that an agency offers not only to its own officers, but to other agencies. So the Washington, D.C. Metropolitan Police Department has a police leadership academy. It's a 3-week program, I think, and I come in and talk about use of force review for one afternoon in that course. In a couple of weeks, I'm going down to Charleston, South Carolina, where the Charleston Police Department has its own police leadership academy, both for its own officers and officers in the area. So I'm sort of guest lecturing as one of the talking heads in that program. None of which is formally through the policing program that I run.
So those are your people are asking you to do that, and then a lot out in South Carolina. Is that just in South Carolina, or do you go across the country doing that as well?
Sort of where asked, as long as my schedule works out. I've done it in DC twice, Kansas City, back to DC for a different agency, Charleston previous, and that's in South Carolina, kind of wherever time and schedule allow.
Do you belong to any groups, any outside organizations in terms of involved in policing and police review institutes, for example, the American Law Institute?
I do. I am a member of the American Law Institute. I was an advisor on a project of the American Law Institute called Principles of the Law Policing that actually just got released in final form after about 8 years of working on it. I am a member of the the American Society of Evidence-Based Policing, the International Association of Chiefs of Police, and the Legal Officers section. I think I still have an active membership in the Police Executive Research Forum. I think that might be it for police-specific organizations.
Now, in terms of your work, you're outside kind of law professor. Do you get brought in to review use of force incidents involving police officers in specific cases like this one?
Yes, I do.
Can you give the jury an idea how many times you've been asked to do a review similar to the one you did here?
I've been formally retained 130 or 140 times, somewhere around there. I can't even count. I do not keep a track of how many conversations that I have that may not lead to retention, so there are some number of other phone calls or emails or exchange beyond those where I do not end up getting retained for whatever reason. Most of those are litigation related, either civil or criminal litigation, a combination of plaintiff side or civil defense or prosecution or criminal defense. There are some non-litigation retentions where it's sort of strictly a consulting capacity, usually as a subject matter expert through a federal grant, a Bureau of Justice Assistance grant or something like that.
Have you testified then as an expert in any of those cases that you've been retained on?
Yes, I have.
How many times have you testified in a courtroom like this?
In court, in trial, somewhere in the area of 24, 20, 24, maybe a little bit more than that. Deposition testimony is even more than that. I don't know off the top of my head, probably twice as often.
And those instances you testified, you've been qualified as an expert in use of force and police practices?
Yes, I have.
I'd move for this time to have him introduce his testimony, introduced as an expert in use of force and police tactics, or police practices, excuse me. Not to those areas, Your Honor.
All right, so he shall be considered an expert in those fields.
Can you give the jury an idea of approximately when did you get involved in this case and what goes into getting involved? What did you review when asked to review a police use of force case like this one?
Yes, you're asking me the hard question, which is about timeline. I don't even remember the timeline that I got involved. I could try and look at my retention agreement. That would remind me, but it would be right around there. So I don't advertise as an expert. I don't have a website or business cards. I basically get emails or phone calls from other folks who have passed my name around. I forget if the initial contact here was an email or a phone call, but it was one of those things that asked to set up a conversation about whether I could be potentially useful in this case.
Now, in terms of when you decide to take on a case, what is your process? What do you do? What do you look at?
So the first and most important thing that I look at is whether I am an appropriate expert in the case. There's a lot in policing. There's a fair amount in policing where I wouldn't want to be testifying about technical expertise in an area that is not covered by my research or experience. With tactics and use of force, those cases are pretty sound. That's well within my wheelhouse. Sometimes with other cases, that's an easy way for me to weed out retentions. Probably the next thing is looking at my schedule and making sure that I can do the work that needs to be done in the timeline that it needs to be done on. Sometimes that will involve a preliminary review where I look at maybe 20 minutes of worth of material, a short video or something like that. We did not do that in this case, as I recall. I think we had a preliminary discussion and then engagement, and then I'd actually start the review. I'd get the body of material that is shared with me and start the review process.
Before we get into it a little bit more, you talk about tactics and use of force being kind of in your wheelhouse. Could you describe to the jury what you mean by, first off, what are tactics? What are tactics that are in your wheelhouse? What do you mean by that?
Sure. In the policing context, tactics are how officers navigate and mitigate potentially risky situations. It's the decisions, the procedures that officers use to help keep themselves safe, and because they are safer, the community members that they're interacting with are also safer. There are a couple of different definitions of tactics, but they all come down to making a decision to balance competing priorities in a way that allows officers to achieve whatever the police mission is in that individual interaction in the safest manner that the situation allows. There are a bunch of different kinds of tactics. I'm sure we can get into some of that, but sort of as an overview, tactics are just how officers manage risk and prevent risk from escalating to the point of being a threat, or a threat from becoming a full-blown actual injury or harm of some type.
And what about the use of force? You kind of separate that out. What does use of force mean to you in this aspect?
Yeah, in the way that I'm using that term, use of force is really about the application of coercive physical force. So the easy one is shooting someone, punching someone. Sometimes you'll get some different definitions where use of force might be just communication. When I'm talking about use of force, I'm talking about hands-on physical engagement with someone, either with weapons or without weapons, the use of coercive physical force.
Now, when you talk, then we start getting into, you take a look at all the materials when you're reviewing a case. Can you give the jury an idea of what materials you reviewed when looking at this case and what occurred here?
Sure. At a very high level, there were 3 videos. There was a dash cam, a body cam, and a bystander cell phone camera. There was an investigation and documents related to an investigation. There were some agency policies and procedures, some training documents. I can probably get more detailed if needed, but that's an overall summary.
And so you take a look at it, you get all that together. Now, in this instance, I also want to clarify, this was kind of a joint report with Nick Bloomfield, correct?
It was, yes.
How do you do a joint report? Is that different? Is that something you normally do?
It's not common, but it's not uncommon either. I've had a couple of cases now where I've done a joint report with another expert. The process does not really change at all. The only thing that changes is after we review the materials and develop opinions, is coming together and make sure that the report that we submit has opinions that we both agree to, and that we don't have any internal points of disagreement that would require an addendum or additional reporting indicating our points of disagreement.
So for the jury's benefit, you get a look at the body cams, you get all the materials, the investigative materials. Could you give them an idea, what do you look for? Okay, what is going through your mind in terms of reviewing a force? You know, what happened here? What criteria do you use, I guess?
Sure. So the first thing is I have to know what actually happened, right? So the first thing that I do is review the materials to get an understanding of the facts. It's a little simplistic to say I watch the videos and read the reports. It's a little bit more like I watch the videos, I read the reports, and I compare them to each other to identify points of consistency or inconsistency, to identify where there are still lingering questions that the body of evidence doesn't actually solve, to identify discrepancies or issues where two different witnesses might say two different things, right? As an expert, it's not my job to figure out who is telling the truth or figure out which discrepancy is accurate or which piece of evidence in a discrepancy is accurate or inaccurate. So normally what I do in cases like that is I just make note of this discrepancy and say, hey, there is, this person said X, this person said not X, right? Said something different. Once I have an understanding of the facts, then I try Gesundheit. Then I try and identify what the different decision points were. That is where an officer made a decision. And as you can imagine, there might be dozens of those decisions that an officer makes over the course of an encounter, right? With each decision, I'm looking at the decision to see whether the decision, and that might be a tactical decision, it might be an enforcement decision, like do I stop this person and chat with them or not? It might be a use of force decision. What I'm looking at is whether that decision was consistent or inconsistent with generally accepted principles and practices in policing. Does it meet that sort of professional degree of commonality that we expect professional officers to be able to meet?
Can you go into that a little bit more? What exactly is generally accepted police practices, and what does that mean to you and for the jury's benefit?
Sure. Again, this is a little colloquial, but when we're talking about generally accepted principles and practices, and I can define those two things separately, if you went to a reasonably well-trained officer at any agency, pretty much anywhere in the country, and you said, is this more or less the way you do things? If they say, yeah, that's more or less the way we do things, that's probably a generally accepted practice or generally accepted principle. This is a little bit tricky in policing because we don't have a single authoritative body in policing that sets out what generally accepted principles and practices are, right? In accounting, there's something called the generally accepted accounting principles, and all accountants have to use that. We don't have that in policing. We have about 18,000 different police agencies across the country, some very, very small, some very, very large. So when we're trying to identify generally accepted principles or practices, we're asking what has sort of bubbled up from below. What do all of these agencies, what do officers do? What is common and generally accepted as the standard for professional policing across agencies? You can find information about generally accepted practices reflected in an agency's policy manual. You can find it in statements or publications by police organizations like the International Association of Chiefs of Police or the Police Executive Research Forum or the National Police Foundation. But it's not authoritative because the International Association of Chiefs of Police said it. It's easier to flip that and say the reason that the International Association of Chiefs of Police is saying that in something like a national consensus policy or national consensus paper on use of force is because it is so common that it is generally accepted.
Now, can you get into a little bit in terms of what factors do you consider when you're looking at an incident? What are the factors as an expert you consider when reviewing tacticals or police use of force? What are some of the factors
Sure.
taking into account everything?
The ultimate question for tactics when I'm reviewing them is really what are the tactical risks of what the officer is doing, and what is the benefit of what the officer is doing, right? Officers, as one resource puts it, officers work in risk soup. They're constantly in situations that are dynamic and maybe uncertain. So they have to make this series of decisions without fully accurate information. So what risks do they take? And what risks do we say those are not professionally appropriate risks anymore? As that phrasing sounds like, it's very, very heavily fact dependent, right? There are situations that will absolutely justify officers putting themselves in grave harm, like an active shooter situation where we now train officers to run in and identify that active shooter to deal with the situation. There are other situations where that degree of risk-taking would be inappropriate or unjustified, right? Where we don't want officers to unnecessarily take risks. And the way we determine whether an officer is taking a risk appropriately, professionally, or unnecessarily is by basically looking at what's the tactical risk, what's the tactical benefit, putting those two things together, does it make sense? When I'm answering that question of does it make sense, that's not me as, Seth thinking, do I think this makes sense? That's where looking at generally accepted practices, looking at generally accepted principles across policing, applying that framework. Does policing as an industry, does policing as a profession think that this is a professionally appropriate risk or not a professionally appropriate risk?
Now you touched on it a little bit in terms of running into active shooters. What role does the threat against the officer play? What does that play a role in any of your analysis?
Yes, it plays a huge role, particularly as we shift from sort of the tactical question to a use of force analysis. So when we're analyzing use of force, we're again looking to see what the officer is trying to accomplish, but there's a slightly different framework for that. So officers can use force to deal with imminent threats, and I can define that term in a second. But when they have a situation that does not yet amount to a threat, but might still become dangerous, it's a potential threat, that's what we refer to as risk. So as sort of a rule of thumb, officers use tactics to navigate risk. They use force to address threats. And in policing, a threat exists when the individual that the officer is interacting with has the ability, the opportunity, and the apparent intention to cause some kind of harm to the officer or others. I can define those terms if it's useful.
I guess you could, because you talk about imminent threat. What you said imminent, is that the definition of imminent threat then, in terms of the ability and so forth?
In policing it is, yes. You will sometimes hear immediate instead of imminent. You will hear some commentators sort of distinguish between those two things. For my purposes and most experts, the important part is there an imminent threat? And an imminent threat exists, or if you like, a threat is imminent and thus justifies a use of force when the subject has the ability, opportunity, and intention to do something, right? At that point, there is a threat of something that may justify a use of force.
Can you go a little bit more detail? What is the difference between imminent, or what is an imminent threat and maybe something that's just concerning?
Sure, yeah. So really this focus on ability, opportunity, and intention. Again, I don't want to get too carried away with specific language because it's really the concepts more than the words. Sometimes you'll hear ability, opportunity, and jeopardy, or you'll hear ability, opportunity, and threat, or some combination, but it all kind of means the same thing. When we're talking about ability, we mean the physical capacity to cause whatever type of harm we're talking about, right? If an officer is interacting with someone who doesn't have anything in their hands, then that person might have the physical ability to hit an officer with a fist, but doesn't at that point have a physical ability to swing a weapon, as opposed to someone who's holding a tire iron. Now that person has the physical ability, the capacity to hit the officer with a tire iron. When we talk about opportunity, we're really talking about, is anyone vulnerable to that particular type of harm? If someone has that tire iron and they have the physical ability, but they're 60 feet away, they don't have any opportunity to hit anyone. They might if they get closer, but they don't yet. On the other hand, if they're within arm's reach of an officer, there is ability and there is opportunity to now use that tire iron as a weapon. The last prong is apparent intention. Does it look like the person is trying to do that thing, right? From the officer's perspective, does it look like the person is going to do that harmful act? So someone who has a tire iron that's within arm's reach of an officer, but they're chit-chatting on the side of the road while the guy changes a tire, might be a situation of risk. The officer could say, sir, why don't you put that tire iron down? Or the officer could back away and use distance as a tactical concept. Or the officer could interpose a vehicle between himself and the subject. But there's no threat because the subject doesn't look like they have the intention to use the tire iron as a weapon, as opposed to someone who is swinging the tire iron at the officer or cocking back as if to swing the tire iron at the officer. At that point, we have ability, opportunity, and intention, which means we have a threat that justifies the use of force.
And so that use of force, it covers the spectrum in terms of, could be throwing a punch all the way up to deadly force. It's kind of the same analysis then?
It's exactly the same analysis. We're still looking for an imminent threat of something. And that's really important because there's no such thing as a threat. It's always a threat of something, a threat of escape, a threat of being injured, a threat of being seriously injured or killed or something like that. What's different with different types of force is the next sort of question. If there is an imminent threat such that some use of force is justified, then we ask, okay, what kind of force would be justified here? If it's a very high-level threat, it tends to justify a higher-level force. If it's a very low-level threat, then it justifies a very low-level force. In my world, this is referred to as proportionality, right? The use of the use of force has to be proportional to the threat. So the way that we do this analysis is first asking, what is the nature and severity of the officer's use of force? Then asking, what is the nature and severity of the threat that the subject presented, if any? And then once we answer those two questions, we weigh them against each other and identify the relationship between them to determine whether, as a matter of generally accepted principles or practices, policing would define that as proportional or not.
And in terms of, there's a reasonableness figure into that. Is that proportional? Is reasonableness and proportional the same thing, or is reasonableness a little bit different? Do you use that differently?
It's effectively the same thing. Policing has adopted into its generally accepted principles the term reasonableness, which ultimately it sources from law, both Fourth Amendment law and state common law decisions. Incidentally, that's also where concepts of ability, opportunity, and intention come from. Those ultimately originate in common law doctrines related to assault. But policing as an industry has accepted those as the practices and principles within policing.
So when you look at using the term reasonableness, does reasonableness come into play? You talk about intent, motive, and opportunity with a person the force is used against. Does reasonableness pertain to the officer then more? Is that, do you use that distinction, if you will?
Yes, I am looking at applying this framework. That is a framework that we use to analyze an officer's decision making, right? Is the officer reasonable? Is the officer consistent or inconsistent with generally accepted practices? We have other frameworks to assess the other person, right? We might ask, did the other person commit a crime, for example, by doing whatever they did to the officer? But the frameworks that I'm talking about, in my role as an expert, I'm analyzing police actions, not subject actions.
So I guess getting kind of to the meat now in terms of looking at this incident specifically. Did you come to any conclusions in terms of different types of actions that were taken by the defendant during this interaction with Patrick?
Yes, I did.
I guess starting off the first thing, starting off with what happened at the beginning. What were your conclusions?
So again, I'm looking at all of the decisions that were made. The sort of initiating decision here, the first level decision is the decision to stop the car, to initiate a traffic stop. Generally accepted in policing that when officers have reason to believe that there is a traffic infraction, that you can stop a car. My understanding is that there was an improperly displayed license plate on the car. That's a traffic infraction. So stopping a car for that reason is consistent with generally accepted principles and practices in policing.
So a reasonable officer in that circumstance would have done the same thing?
Yes.
What about your next analysis?
I believe the next opinion related to Officer Schurr's attempt to grab Patrick after he got out of the car and began to walk away. That use of physical grabbing, it's a use of force it's a relatively low-level use of force, comparing, again, the nature and severity of the officer's use of force, which is relatively low risk. That is, when we're identifying nature and severity of force, we're really looking at what is foreseeably likely to happen, and just grabbing someone is not foreseeably likely to do very much, so it's a fairly low-level use of force. Nature and severity of the threat that Patrick's actions presented there. He's walking away, there's a threat of escape or evasion. So balancing those two things together, grabbing someone who's attempting to walk away, is perfectly consistent with generally accepted principles and practices in policing.
So a reasonable officer in the same circumstance would have done that?
Sure.
What about the decision to chase him around the car? What about that?
That's where we start to run into issues. So they run around the back of Patrick's vehicle and then past the front of the vehicle, sort of along the sidewalk into that driveway area. This creates some tactical concerns. And the reason it creates some tactical concerns is because there is another individual in that car. And in policing, the goal is not just catch whoever runs away. The goal is to do so safely and efficiently. And if you run past a car, you don't know what else is going on with that individual in the car, what else they may be doing with any evidence that might be in that car. So if one person goes hightailing off and you chase them, you may miss the fact that the other person is taking all of the evidence out of the car and walking away and dumping it somewhere. You also expose yourself to some unnecessary tactical risks. When you run past the car and now you have the other individual in the car at your back, you have no idea what they're doing because you're so focused on the individual that you're chasing. And that gives them an opportunity to, put it bluntly, get out of the car and attack you in a direction that you were not expecting. So going back to that sort of tactical framework, the tactical benefits of chasing someone are not nothing, right? There is some tactical benefit that I could chase someone and maybe grab them. But the tactical risks of doing so are substantial. And for that reason, there's generally accepted guidance in policing that says if there are more people in the car and someone goes running, you stay with the car. There's a pretty good chance that you're going to be able to identify whoever ran by talking to the people in the car. That gives you the opportunity to collect any evidence in the car. And if you can identify them and collect evidence by talking to the people in the car, you just get a warrant and catch them later. Doesn't mean they get away scot-free. You just may get them, later that day or tomorrow or something.
Now, when you say generally accepted police practice, specifically on foot pursuits, what is there anything, a background, if you will? What sort of things are you relying on to say that is a tactically bad decision?
Sure.
For an officer?
Yeah, so there's now a lot of guidance on foot pursuits, including from the International Association of Chiefs of Police, the Department of Justice, and others that have pointed out that foot pursuits are an indication not just that someone is trying to escape, but that someone is more likely to resist at the end of that foot pursuit. If they're already running, they may try and push you off of them. Or they may even be, direct violent or assaultive action toward the officer with their attempt to escape. So because of that reason, even ignoring someone else in the car, the general guidance in policing is that when you are chasing someone on your own, you do not actually want to catch them until you have another officer present, right? You want to keep them in sight until there are additional officers on scene so that, to put it bluntly, so it's not a fair fight, right? You don't want it to be a fair fight one-on-one. You want the officers to outnumber the person that they are attempting to take into custody. When you add other people in, and like the person sitting in the car, again, there are tactical considerations beyond just catch the person who is running, like the ones that we mentioned. So the International Association of Chiefs of Police, for example, reminds officers that they have to consider that totality of the circumstances, including other people who may be running or who may not be running, but may choose to involve themselves in the scuffle after that.
So then, look, kind of the next step, and I wanted, because Nick's going to testify tomorrow, or maybe later in the day, depending on how things go. I want to kind of go over skip over the taser, leave that for him.
Sure.
In terms of following up the next aspect. Did you have an opportunity to take a look at Gramble's police policies and procedures as part of your analysis of all this?
Yes, I did.
I'm going to show you what's been entered into evidence as Exhibit 32. You recognize that?
I do.
And in terms of that document, that's one of the documents you reviewed as part of your analysis of this case.
Yes.
I think maybe it's a second or third page on that. There's a policy changes, if you will, 2020 policy changes.
Yes.
Is that on page 3 or 4? I can't remember.
Policy changes is on page 4 here.
Okay, I don't mean to interject, but didn't we have everything to match what the professor is? Can I get a copy of Exhibit 32?
Would you like to look at it?
Yeah, just to clear confusion. There. Thank you. Thank you, I'm sorry.
Reach the right spot.
Thank you.
So the 2020, there are some changes, I guess, in terms of 2020 in regards to police, specifically Grand Rapids Police policies and procedures, correct?
Yes, that page says GRPD at the very top. GRPD use of force policy changes 2020.
Now, in terms of the policy changes, was there any direction in terms of giving a warning before using deadly force?
There is, this is number 3. Number 3 says require a warning before shooting, and then goes on MOP 9-1.64. Whenever reasonably possible, officers shall provide verbal directives before deadly force is used.
Now, in terms of, you knew that, did that factor into your analysis in terms of when you're trying to make a decision on the use of force, the ultimate use of force, which you're called in for in this case, did that play a role in your decision?
Sure, yeah. In sort of 2 ways, right? One, everything that I looked at factors in, right? Everything in the case file factors into the decision making, even if it ends up not being dispositive. In this particular case, one of the opinions that Nick and I developed after reviewing the materials is it would have been feasible in this case to give a specific warning about the use of deadly force prior to that use of force.
And why is that?
Why was it feasible, or why is that? Because there was time to do so. There are at least several seconds prior, even while Officer Schurr is reaching for and drawing his gun, that would have allowed for a specific warning about the use of deadly force.
Now, in terms of that, you've talked about generally acceptable police practices. Does that also, this policy also reflect that, if you will, in terms of, is that something that's required now, or at least across the country?
It does, yes. So it is certainly a generally accepted practice now that officers give a warning, and I want to emphasize when feasible, because the situation does not always allow for it, but that officers give a warning when a warning is feasible, when it is reasonably possible to give a warning. It's generally accepted in policing that they should give a warning prior to using deadly force. That actually got incorporated into generally accepted police practices after a Supreme Court decision in 1985 that sort of made the same point. Now, that was in a legal context, but police practices adopted it as a generally accepted principle or practice within policing.
Now going into a little bit further in terms of, I guess I'll go right here. Can I use the video? Some of the stuff that we're introducing are procedures by the GRPD. We don't want to put those on for the media. These are policies that are already out there in the open, so I'll refer directly to them. This is still part of Exhibit 32.
Sure.
We're looking at 9-1.1. Since you're here, looking at paragraph 3. Do you see paragraph 3?
I do, yes.
And this would be the use of force policy, if you will, for Grand Rapids Police?
Yes.
And you reviewed that?
I did.
What are your thoughts? As an expert, is this generally what's out there for other departments? Is this sufficient? Can you give an idea how this factored into your decision?
So this is a pretty casebook reflection of generally accepted practices in policing. Policing limits the use of deadly force to those situations where there's an imminent threat of death or great bodily harm. Policing typically says that there are two ways that can happen. One is immediate, one is through escape, and you see both of them sort of outlined in B3 there. Again, the wording might be ever so slightly different, reasonable threat instead of imminent threat, but the concept is certainly is reflective of generally accepted practices in policing.
Going down now to this is 9.14. I don't want to shrink it too much. You can see it just so you can look at the top. 9-1.4.
Okay.
You have another definition of deadly force under C.
I want to object to the record. The policy that the witnesses testified about is from 2017, and the policy that was in place may be very similar, but it has not been established that this policy was in place at the time of the incident. So he's testifying about something that's completely irrelevant.
I think this is the same policy that they were trained on. This is part of the training that was given to the officers at the time, so they can rely on it.
At which time?
This was back, I don't have the thing, this is 2020, that policy 2017 at the bottom, but this was also given in 2020. So this is still part of the same policy, and this is part of the training that was given to Officer Schurr through his career.
Yeah, there's clear policy from January 19, 2021 that came from GRPD. It may be very similar, but there may be differences.
But these are already admitted, Your Honor. These are already admitted, Your Honor.
Right, is that admitted as an exhibit?
It's already admitted as an exhibit, so
this one is admitted, the 2017 policy is admitted.
Okay. And so
It
your
is not-
objection
it's
is?
relevant. What does it matter?
Are you saying that the exhibit's not relevant?
Right.
But it's
Well, I'm
already
saying his
admitted.
testimony is not relevant. I didn't know the relevance.
So his testimony about an admitted exhibit, I would think would be relevant because it's already admitted. To the extent that it's different, then obviously that would be something you can admit. If there's a newer, different policy, you can certainly move to admit that, but because this was admitted without objections, it's
And
already
also,
in evidence, so.
if we could get some explanation for why this witness who is not an expert on the policy, if it provided the basis of his opinions, then I don't know if that's been established either. So that's more of a foundation.
that's what I just asked him. In terms of what,
That he's an expert on your policy?
no, what role did this play in his decision?
Okay, so I'll allow him to answer that question. Maybe it didn't play any role because then that would be a kind of a moot point. So I just can answer that question, but again, I can't say that the exhibit's not relevant or that this witness's testimony regarding an admitted exhibit is irrelevant because we can only use the facts that are in evidence and information that is in evidence and the exhibit is in evidence. So you may answer that question if you're interested.
Could you ask that question one more time?
Just to say,
Sorry.
this was one of the things you reviewed as part of your analysis of this entire case.
Yes.
And looking at 3C, they talk about objectively reasonable control of the situation. Is that a term you're familiar with? It's 3C under 1.4.
Yes.
What does objectively reasonable mean to you?
That is the phrase in policing that is the generally accepted standard for police uses of force. They must be objectively reasonable. That language, generally accepted in policing, after policing adopted it from a 1989 Supreme Court case.
And so that's part of the analysis, not only for jeopardy, but that's something that you're familiar with and used in your analysis of this case.
Yes.
Once again, looking at, now we're down to 9.15.
I'm sorry, what page are we on?
Then the page there is just policy 9-1.5.
Page 10 of the PDF, or of the.
So in terms of the totality, you talked about the totality of the circumstances. What does that mean to you? And I guess how is it reflected? Is this, what's reflected in their policy reflective of what the totality of the circumstances mean in generally accepted police practices?
Yes, so totality of the circumstances here when you're analyzing use of force, it means you look at all of the facts and circumstances that the reasonable officer on the scene would have been aware of, the facts and circumstances that were available for an officer to observe and draw conclusions from. We want to avoid artificially limiting that, because ultimately an officer should be basing their decision on the information that's available to them. And there's some information that is maybe potentially relevant, and there is other information that's far more likely to be relevant, right? So for example, like the phase of the moon is not particularly relevant to a use of force. It might be relevant if it happened at night and we're talking about ambient lighting conditions. Ambient light is part of the totality of the circumstances. What I see this list of 1 through, it goes down to 15, as is a summary of relevant or potentially relevant factors that can make up, don't necessarily, because they may not be present in every case, but they can make up the totality of the circumstances that we review in determining the threat that the subject presents and whether the officer's use of force is proportional to it.
And so this listing here for Grand Rapids policy is also what is used out in the generally accepted police practices as well.
Sure, you don't always see it as a list. In our book, my co-authors and I provide a similar list. We break it up into 3 different aspects: a list of officer characteristics, a list of subject characteristics, and a list of environmental or situational characteristics. But they're all basically the same, right? I'm not saying like this exact list is something that you can find in every agency. But again, if you talk to officers at every agency and said, could this matter in the use of force analysis, they'll say yeah. And there's probably stuff that's not on this list of 15 that could also factor in to the use of force analysis, like ambient light conditions, which are not actually on the list.
Why would ambient light conditions? That seems like kind of a random thing.
It depends on what an officer can see or can't see, right? How well an officer can actually see what's going on and what conclusions they draw from either good visibility or limited or bad visibility. That can definitely matter.
They did make that one thing, going back to the 2020 changes, going back to, I think, page 4.
Yes.
The things we can't put on.
Page 4, I'm there.
Was there anything about reasonable alternatives being exhausted before use of deadly force?
There is point 4 says require that all alternatives be exhausted before shooting, and the note is already in MOP 9-1 under escalation and de-escalation of force.
So all reasonable alternatives exhausted before shooting, is that a generally accepted police practice? This one gets a little bit tricky. In most contexts, yes, but we have to be careful in how we define reasonable alternatives, right? In the context of a shooting, officers are presumably using deadly force to address a threat, as mentioned elsewhere in that policy, to address an imminent threat of death or great bodily harm. So we don't
when we're talking about reasonable alternatives, we're not asking, is there something else that officers could have done? We're asking, is there something else that officers could have done that would have had a similar likelihood of addressing the imminent threat of death or great bodily harm? So as long as we sort of define what we mean by reasonable alternatives, yeah, that's fairly common.
So ultimately, this comes down to the decision to fire on the cell phone video that you watched, correct?
Yes.
Can you give your idea? Was the decision with a reasonable officer similarly situated made that decision? Objection, Your Honor? Let's see. Can we approach?
Yes. Outside of your presence, and so I'm going to ask that you please leave your notes upside down in your chairs. Remember that you're not to discuss the case with each other or with anyone else at this point, and also to avoid media and social media. All right, thank you. Thank you. You may be seated.
If I can just explain more my objection, or maybe it's an objection to lack of foundation.
So you want to
Can I-
make more of a foundation? That
Well,
was
I don't
that was
even
an
know.
easy objection.
And that's, I'm just confused, Your Honor. And the reason is, my understanding was that Opinion 7, Officer Schurr's use of deadly force against Mr. Leoy was unreasonable, excessive, and contrary to generally accepted police practices because he supposedly didn't know that there was a second, he did know the second discharge had been fired, and therefore he wasn't in fear of great bodily harm or death, and therefore was unreasonable. And he hasn't gone through that. He's just saying, well, do you think in general that this was excessive? But the report talks about why he thinks it's excessive.
I think the question was, would a similarly situated officer have made the same decision?
But he hasn't talked about what the situation is yet. I understand that Mr. Bloomfield's going to testify about this opinion.
So then you just wanted to talk more about the situation?
Or which expert are going to talk about this situation? because he suggested that Mr. Bloomfield is going to talk about the ones involving the taser, and this one does. And then Mr. Stoughton is going to talk about, I think, the foot chase and the failure to give a warning.
Sure. You know, we can't say Officer Schurr did this. We've talked this over and over, that a reasonable officer similarly situated, in his opinion, number 7, Officer Schurr.
Direct me to the page, so I can.
This is page 63, 63 of his report. Officer Schurr's use of deadly force against Mr. Loyola was unreasonable, excessive, and contrary to generally accepted police practices. So that's essentially what I asked him, except I didn't say, I can't say Officer Schurr, I have to say a reasonable officer similarly situated.
I agree with that.
And if he let me finish.
I'm sorry, Mr. Becker.
I can, just because I'm starting out with that, and then I can say, can you explain why that is? He won't let me do that because, you know, I don't have to do my direct based on what he'd like to hear first.
I agree, Your Honor. I'm sorry, but I thought Mr. Bloomfield was testifying about that.
Okay,
Because
so
this
we
is
can
based
have
on
the
tasers.
Right, but you
and
didn't ask him about a taser.
He's about to.
Well, you didn't, so you're objecting about something that hasn't happened. It's like, I don't know how I'm supposed to rule.
Well, because he's going to give his ultimate opinion about the taser before we've established that he's a taser expert.
Ask him anything about it.
It's still part of his opinion. I cannot go into the decision. It's one of the things, but I don't have to get into his details of a taser. That's part of the whole thing he's been testifying about, the totality of the circumstances.
But you're okay with that question? You can answer that. The
Assuming
question that
he-
you objected to.
Yeah, I assume he's going to go into the opinion number 7.
Is he going to go into opinion number?
That's part of his opinion. Now, I'm not going into details with him, but that's part of the thing, the basis. He did it jointly with Nick, and so they can say, okay, but Nick is going to testify to that.
Okay. So we don't have the jurors come back in. That was a short break for them.
Should I be able to voir dire Professor Stoughton on whether or not he's a taser expert? Because that's the basis of this opinion.
If he asks him a question that requires a response from a taser expert, then yes.
Okay.
But that question that he just asked, I don't believe does that.
Would a reasonable officer and a similarly situated reasonable officer made the decision to fire in the circumstance?
No.
Part of that, what is the basis for you? Is part of that going to the failure to warn?
No, failure to warn is a separate issue, right? A separate inconsistency with generally accepted practices.
So why do you mention that in your opinion in terms of this failure to warn?
I'm sorry?
Why do you mention that in this opinion in terms of your failure to warn?
As a separate opinion, there is like a tactical violation, right? There's some decision or action that is not in keeping with generally accepted police practices. Failure to warn prior to the use of deadly force is one aspect, but is separate and distinct from whether the use of deadly force was professionally appropriate. That is, you could have one without the other, right? You could have a warning where deadly force is inappropriate, or you could have no warning where deadly force is appropriate, or any combination.
What about the imminent threat aspect of it? The imminent threat in this situation, was there an imminent threat?
Not, in my opinion, one that justified a use of deadly force.
Why is that?
In order to justify a use of deadly force, it's generally accepted in policing that there has to be an imminent threat of death or great bodily harm. That is, the subject has to have, or to be entirely precise, reasonably appear based on the information available, have the ability, the opportunity, and the intention to cause serious bodily injury or death. In my opinion, that was lacking in this case.
So that leads to your conclusion in terms of the unreasonableness of the decision to fire. A reasonable officer would not have done the same thing.
That's correct.
One more, Your Honor. Thank you. I have nothing further.
Hello, Professor Stoughton.
Good afternoon.
Okay. I want to unpack a lot of what you said here.
Sure.
All right, so I want to, let's talk about your background a little bit. I believe you testified that you're a professor at the University of South Carolina.
Yes.
Okay. And you said you don't advertise?
As a consultant or anything like that, and that's correct.
Okay. But you do some marketing, right?
Not as an expert, no. I don't have a website or business cards or an email address or...
How about to sell your book?
Sure, I get the book was marketed, sure. I didn't actually engage in any marketing, but I know NYU Press did.
And in this case, you marketed your book based on the facts of this case in particular, correct?
I don't think I ever used any specific case to market my book.
Okay. Do you recall having an interview with Ken Coker from Channel 8 News?
Yes.
Okay, and that was shortly after this incident happened, right?
Yes.
And it was before you were hired by the county?
Yes, that's correct.
Okay. May I approach, Your Honor?
Yes, you
We show it's been marked for identification as Defense Exhibit W.
Oh, you got my best face.
I'm sorry, I actually did try to get something decent, but the reason that this is a picture of you.
Yes, it is.
And this is when you were giving an interview with Channel 8?
Sure looks like it, yes. That is not actually my name in the closed caption, but it's close.
Oh, I didn't notice that. Your name's not Self?
It is not Self.
Okay, well, closed captioning apparently got that wrong.
A little wrong.
Your name is Seth.
It is.
Okay. And this is a fair and accurate depiction, but maybe not the best likeness, but that is actually you in this picture?
Yes.
And Your Honor, we move Defense Exhibit W into evidence?
Is there an objection?
No objection.
Okay. And so shortly after the incident, you were asked by the news to go ahead and give some opinions of the video. Is that fair?
Yes.
And you did that?
Yes.
Okay, and in the background, you have a bunch of books, right?
I do.
Okay. And there's only one book that's forward-facing, right?
Yes.
Okay. And that's the book you've been talking about so far today, right?
Yes.
Evaluating Police Uses of Force?
Yes.
Okay, so it's fair to say you wanted people to notice that book.
Yeah, sure.
Okay. And I bought one of them.
You and 6 other people, so thank you.
We bought 2.
I get, and this is not a joke, I get about 3 cents per book.
I'm sorry to hear that.
Yeah, me
well,
too.
you know, you should probably charge more on Amazon.
That is out of my hands. It's not that kind of book.
All right, but it's fair to say you're trying to sell books, at least in part, by putting it out there on the news behind you when you give interviews.
Sure. In my email signature, I have a link to my list of articles and to the book, right? Yes, I want people to be aware of the work that I've done.
Okay, and you can put that down. All right, so can you tell the jury what confirmation bias is?
Sure. Confirmation bias is the tendency, the human brain tendency to weight more heavily information that confirms pre-existing worldview and to devalue or weight less heavily information that tends to challenge your pre-existing worldview.
All right, so it's kind of like jumping to conclusions, or that's more expectation bias. Confirmation bias, you've already made up your mind and you don't consider things that come after. Is that fair?
Yes, that's more or less right. Confirmation bias is without being aware of it, which is why it's an unconscious bias, you interpret new evidence in a way that gives you more support for your beliefs.
Okay. And in this case, you were actually asked to form opinions based just on the video that you had saw that had been released by GRPD at the time, right?
Yes, in the news interview, I was asked to look over the video and talk about I think it was specifically sort of the sort of criminal or potential criminal ramifications of the act. I forget exactly how it was phrased.
Well, in the video, you said that it was your opinion at the time, shortly after the incident, that if there's a car with multiple passengers and one jumps out, that you should wave goodbye. The officer should wave goodbye as he runs down the road.
To the individual who's running away, yeah, stay with the car. Stay with the individuals in the car, yes.
But should they actually wave goodbye?
I mean, that might be a little gratuitous. Should they, like, actually physically wave goodbye? No, but the idea is they should not go chasing that person. They should be staying with the vehicle to avoid putting themselves in a
That was just a little characteristic, uncharacteristic flair on, that's not a police tactic.
I don't know if I would say uncharacteristic, but yes, that was clearly exaggeration.
Okay. All right, but it's fair that you've already made up your mind about whether or not he should have stayed with the car based on that initial video way back when.
No, I think it would be better to say, as I pointed out in that interview, that the video is only one piece of many pieces of evidence. However, there is a tactical consideration here, and that tactical consideration does not change from having seen the video the first time to seeing the video and all of the other evidence.
Okay, so these tactical considerations, you just talked about how you considered the policy and everything like that, and you have since that initial opinion, it turns out you confirmed your initial opinion was correct, but you're telling us that you considered every aspect related to what could make this a bad tactical decision, right?
I'm sorry. So your question is, did I just confirm my initial opinions?
Well, yeah, I'm asking you about confirmation bias. Did you already make up your mind and you just found things that would confirm your initial opinion, or did you actually set aside your initial opinion and start afresh and look at all these things you just told us you looked at when you're making your decision?
Sure. So to the extent possible, I have to set aside any previous review and review the totality of the materials that I'm provided with. When I do an interview, and I do a fair number of interviews with the media, one of the things that I always tell them, and it very rarely ends up in the story, is what I'm talking to you about is limited to the evidence that you're presenting me with, right? It's this particular video. But video never tells the entire story. If there's additional video, if there's additional statements that help explain what happened on video, what I'm describing based on this video may change because there's new information and different information. And that has happened in cases where I have both been retained and where I have not been retained. and additional information comes out, and it changes an assessment of, or it changes my preliminary assessment based on some evidence. In this case, what I think you're asking is, the additional evidence did not call into question or lead me to draw a different conclusion about the specific tactical aspects that I talked about in that first interview.
Okay, except the part about waving goodbye.
Again, that is, I think, perfectly appropriate in a news interview and is not something that is, part of an expert review. The idea that I'm communicating to a popular audience in a news interview is in colloquial language, right? It's in popular language. So yeah, wave goodbye definitely means let him go. It does not, in no way am I suggesting, and there's a reason it's not in my report now, that I'm saying you should quite literally lift your arm and give a little Queen's wave.
Okay. I didn't think you meant that. So when we talk about best practices, I mean, you've been an expert witness before. Is it a good practice for an expert to go on the media and talk about the case they're later going to be an expert in?
One, I don't use the phrase best practices with policing because I think that is too high a bar. What I'm doing as an expert is applying generally accepted practices, not best practices. With regard to your question, I don't know what cases I will or will not be retained in. I don't know what phone calls I will or will not get. I don't know what cases I will or will not accept. I don't know what cases I will or will not be useful. So yeah, I think it's entirely normal to have a media interview and then later get retained in a case. I think it's much more problematic to get retained in a case and then do media about the case, right? That I think is much more problematic, especially because you may be privy to information that is not public at that point.
And you haven't done that?
No.
Okay. All right, now as you talked a lot about what you relied upon to form your opinion, you talked about these generally accepted police practices.
Yes.
Okay. And that you basically, it's a conglomeration of reputable sources, agencies, practices throughout the country. Is that fair?
Sure.
Okay. You also indicated that you looked at GRPD policy?
Yes.
And you looked at GRPD training?
Yes, what training documents were included in the file, yes.
Okay. Are you an expert on GRPD training policies and procedures?
No, I would say the folks at GRPD are the experts about GRPD.
Okay, so they know it better than you do?
Sure. God, I hope so.
I hope, yeah. So are you familiar with the foot pursuit policy at the GRPD?
Not offhand, I don't remember. I think that was in the material. I don't remember if that was in the materials or not. I'd have to look.
Okay, so you don't know one way or the other whether or not GRPD trains their officers on conducting solo foot pursuits?
I'm not aware of very many agencies that don't that tell officers they shouldn't conduct solo foot pursuits. Definitely, there's often training on not doing solo apprehensions during a foot pursuit. But no, offhand, I don't know.
So certainly GRPD doesn't say to its officers, you can never do a foot pursuit.
I would be very, very surprised if that was the case.
All right. All right, so let's talk about your opinion related to the foot pursuit.
Sure.
I think you indicated that no reasonable officer in that situation would have pursued Mr. Lyoya like he did.
Yeah, past the occupied subject vehicle. Yes.
Okay. And so you were calling him Patrick. You don't know the family or anything like that, correct?
No.
Okay.
Or rather, yes, I agree with you. I do not know the family.
All right. So I think your opinion was the decision to chase by himself and away from a vehicle that he knew was occupied was unreasonable, tactically unsound, and contrary to these generally accepted police practices.
Yes.
Do you know whether it was tactically unsound and contrary to GRPD policy?
Again, offhand, no, and I'm not applying I'm not applying GRPD policies. I'm not trying to figure out whether he violated agency policy. I'm looking at whether he violated generally accepted practices.
Because you're not an expert in GRPD policy.
Correct.
All right. And if we could Mr. McFarland, I'm going to show you some of the video.
Sure.
Professor Stoughton. If we could go to RFA 3100 and Exhibit 1, this thing without transcript, or A. Sorry.
What was the RFA again?
3100. And for the record, I'm having Mr. McFarland put on the screen RFN, or RFN, Exhibit A, at RFN 3100 to 3560, which is from the time of the chase, basically, that we're talking about right now. And if you could go ahead and play it and stop it at 3560 around there when it was made.
Stop. Put your hands up. Stop.
Okay. Stop there. So now we just saw an interaction between Mr. Loya and Officer Schurr that started with something that I believe you said was reasonable and turned into something that was unreasonable.
Yes.
The first part when he tried to arrest him, grab him, hold him, and not let him get away, was reasonable.
Sure.
It was a level of force that was commensurate with what he was seeing.
Yes, to the threat that Patrick or Mr. Loya presented, yes.
And the part that you're saying unreasonable is the decision to chase him.
Yes.
After Mr. Loya broke away from him.
Particularly the decision to chase him past the occupied vehicle. As we know, and I apologize, I would absolutely butcher his name, but the passenger in the car gets out and starts filming shortly after that. The reason that running past is tactically unreasonable because if he got out with a gun and shot the officer in the back of the head, the officer would not see it coming, right? So that is one of several reasons why you do not do exactly what we just saw.
Okay. So now you are basing this based on generally accepted police practices.
Yes.
Okay, and some of the things that you consider generally accepted, I want to ask you about those because it informs your decision here. So operational realities of policing require officers to manage an array of risks and threats.
Yes.
That's a generally accepted police practice.
Oh, sure.
Principle.
Sure.
An approach that may be entirely appropriate in one context may be entirely inappropriate in another.
Yes.
Different officers may perceive the same situation differently.
Sure.
Those officers may adopt different approaches, each aligning their approach with their perception of the situation.
Yes.
There may be a range of reasonable responses in any given situation.
Yes.
The question is not whether the officers involved adopted the best possible tactic, but whether their tactics fell within the spectrum of tactical options that could be considered reasonable under the circumstances as reasonably perceived.
Yes.
So basically, there is more ways to, more than one way to respond to the situation.
Depending on the situation, but very often, yes. Very often there is no one, thou shalt do this thing and only this thing, right? There are a number of different ways that an officer might approach a situation reasonably, depending on a whole range of factors, yes.
Okay, and you're not viewing this in hindsight, right?
No, that is another one of the biases that I try and avoid to the extent that it is possible, right, is hindsight bias.
You don't want people just sitting there watching the video, drawing an opinion in hindsight from the comfort of their chair, right?
So hindsight bias is specific and technical, like confirmation bias. It is the risk of interpreting the reasonableness of an action at one point based on the results of that action at a later point, right? So when I'm doing analysis, I try and be very careful to say I am reviewing the decision made at the time it is made without letting what happened later, whether it's good, bad, or indifferent, affect the reasonableness of that decision at the time. Excuse me, at the time.
So what you do is you try to, it's the reasonable officer on the scene, right?
Yes.
Okay, so you basically, what someone who had the knowledge and training of Officer Schurr, in this case, would have thought based on the situation that was in front of them at that moment.
Yes, the reasonable officer is sort of a construct, the reasonable officer in the actual officer's position.
Okay. Okay, so we have Patrick Lyoya, who is committed a felony by resisting and obstructing in Michigan. Do you disagree with that?
I'm not an expert in Michigan law or applying it, so I'm happy to accept your description of that, sure.
Okay. And are you familiar with the concept of resisting and obstructing in other states?
Yes.
Where were you a police officer?
Florida.
Florida? They have resisting and obstructing statutes?
Both a misdemeanor version and a felony version, depending on how it's performed, yes.
All right. And you saw, in this case, Mr. Lyoya break away from Officer Schurr?
Yes.
Okay. And that gives him the ability to run in the first place, right?
Sure. So you mean for like in the concept of threat, right? Like applying those three prongs of threat. Is that where you mean ability?
Sure.
Yeah. Yeah. I mean, not to be pithy about it, but right, he has legs and therefore has the physical ability to run. Yes, absolutely.
Okay. And you're saying the decision to chase him was unreasonable?
The decision to chase him in the context of this case, where you're chasing him past an occupied subject vehicle, where you have no idea who's sitting in that car, you have no idea what evidence is in that car, you have no idea what weapons are in that car. You are going away from sort of a, if not police controlled, at least police aware scenario, where you are standing at the car and looking at it, to now putting what may become an assailant at your back without even the ability to sort of keep visual contact. It's not the chase itself that's problematic, it's the context of the chase here and running past the occupied vehicle.
It's the continuing of the chase?
Yes.
Okay. So if we could look at RFN 3367.
What was that again?
RFN 3367. Okay. So this is not when the unreasonable decision was made, right?
No, I think, chasing him, it depends on where that chase goes. If the chase goes back behind the car, behind the police car, and keeps going down the street in the direction that Officer Schurr is facing there, you have the same problem. Don't chase someone away from an occupied vehicle.
Okay. So at this point, it's reasonable for Officer Schurr to make the decision to continue to try to apprehend Mr. Lyoya?
If he can do that in the context where he can keep visual contact on the car and not worry about an assailant approaching, especially undetected, sure, I think that falls within the zone of reasonableness. I also think it could fall within the zone of reasonableness to say, look, I'm not even going to scuffle with this guy, because if I do start to scuffle with him here and the passenger gets out and helps, I am immediately outnumbered, right? So again, I think the initial grabbing and this initial point is, I don't think there is one path of reasonableness there for the officer.
Okay. And he's not scuffling with him, he's arresting him, right?
Well, no, not at this point. He was scuffling with him in an attempt to arrest him, but he was earlier grabbing him and trying to keep him from fleeing. I forget the first time he says you're under arrest or something like that. But I think it's fair to say that he is trying to prevent him from evading or escaping.
Arrest?
Sure.
He's not holding him for questioning, right?
I don't know what he's going to do, and if you mean arrest in the context of is he going to book him and bring criminal charges. I have no idea, right? That's a sort of mindset of the officer thing. He's definitely using force just before this to try and prevent the escape, which is, again, fine.
Okay. And RFN 3367 is, at this point, he's still within contact of the car. We don't know which way Mr. Leolia is going to go. This is reasonable.
Sure, he's not chasing him, I don't believe yet.
All right, we're going to play it, and you tell us when it becomes unreasonable to chase him.
Right there for sure. As soon as it's clear that he's running past the car.
Well, his car is the gray one right there. You see that?
Yeah.
Do you think he's past the car?
I think he is running past the car, yes.
Okay. So
Because
is the critical point, if he gets beyond the car, then you have to let him go?
The critical point is don't create a tactically disadvantageous situation by putting a potential assailant who has access to the car and everything in it that hasn't been cleared yet, that might have evidence in it or weapons in it or whatever. Don't put that at your back. So at the point where it looks like that might be what happens, if I, the officer, continue down this course of action, yes, you should stop that course of action.
Okay, so he should have let him go at this point.
When you say let him go, he should have not continued to chase him on foot. He should have directed his attention to the passenger. That gives him a pretty high likelihood of identifying the guy who just ran away, assuming he hadn't identified him yet. And that means you can always go and get a warrant for him. So let him go. No, the law will catch up to him. It just may not be in this 5-minute period.
You're making some assumptions there, right?
Yes.
Like the passenger knows his last name, right?
Yes.
And that he has some ID, right? You're making that assumption that...
No, he doesn't have to have ID. If the passenger knows who he is, then you can start your investigation that way.
What if he doesn't know who he is?
It is possible that he gets away. But what is foreseeably likely to happen is you will probably identify him and catch him later. Now, might that not happen? Might he actually get away? Sure, that's possible. But letting someone flee from a traffic stop for an improper plate is certainly better than getting into a fight and losing, or getting shot in the back by an assailant that you couldn't keep an eye on because you were running away from an occupied suspect vehicle.
So officers should maintain visual or physical control over their operational space.
Yes.
Okay. And you would agree with me that Officer Schurr at this point does have visual control over the space?
Not for more than about half a second longer. So if he stopped there, I'd be fine.
Okay, so this is actually fine?
If he stopped there, I would be fine. The problem starts when he's running past the occupied suspect vehicle.
All right. And the concern is that the passenger is going to get out and jump on the officer, right?
That's one concern, right? There's also concerns about evidence that may be in the car that you may be losing because you're chasing the guy who doesn't have the evidence on them. There's concerns that the passenger may decide to slide over into the driver's seat and just leave with the vehicle, taking everything that's in the car away.
You're presuming that there's evidence in the car that would be interesting to...
We don't know.
Right.
Because he hasn't searched the car, we don't know what's in the car.
Right. And
Right? We don't know that the passenger in the car is an assailant. We just know it's a potential. We do know that when you run past the car, it creates a vulnerability that you cannot tactically address.
Okay, so foot pursuits are inherently dangerous.
Yes.
Okay, they're dangerous to Mr. Leolia because he's about to be tackled, right?
Sure.
They're dangerous to police officers, and they're dangerous to bystanders.
They can be, yes.
Well, and this is a neighborhood, right?
Yes.
8 a.m. Monday morning.
Yes, thereabouts, yes.
Okay, people that flee are generally don't just run down the sidewalk, right?
I don't think there's any good data on that. It's running down the sidewalk. It can be cutting through yards. It can be going all which ways.
People that run can do dangerous things, right?
It's possible, sure.
Because they're not trying to get caught.
They're certainly trying to not get caught, yes. That's the running.
Sometimes they jump into other cars, right?
It's possible.
So you would agree with me that when Officer Schurr called in that he had one running, that he had made the decision to chase him?
Yeah, I think he does that as they're coming around the back of the car.
But you're saying that we faulted him because he should have stopped the foot pursuit.
Yes, rather than enter a tactically disadvantageous position, rather than create unavoidable tactical risk. Yes.
Okay. And you're not worried about the risk of Mr. Lillar running into a house or a car?
Unless there is some specific and articulable fact to think that that's likely to happen, I balance that speculative risk against the speculative risk of getting attacked from behind by a passenger.
Well, keep playing the video, please. Yes, this is RFN 3480. And if you could play up to the tackle. Okay, if you could blow up yeah, not the one, thank you. This is RFN 3543. So where is Mr. Lioya and Officer Schurr at this point? Are they on the sidewalk?
Near the back of that car, oh, thank you. Yeah, right there.
Okay, and so is it fair to say that Mr. Lilloy was headed towards the left side of the car and towards that house?
I don't know where he was headed prior to being grabbed because he
I just meant directionally.
Yeah, he was heading down the sidewalk and then got grabbed, and I have no idea where he would have been going prior to that grab or not.
Okay, let's back it up and play it again.
So there's the grab. The grab happens right as they're entering that grass. So I have no idea if Mr. Loyola was going straight along the sidewalk absent that grab, or if the grab is what pulled him to the side into the tackle.
Okay. So with regard to what you're considering, are you considering what the situation includes as far as what the officer knew at that point, just from the video? I'm not asking you to, based on an interview or something with Officer Schurr. What was known to Officer Schurr at the time he made a decision to not stop the chase?
I'm not sure I understand your question. So what does the video tell us that the officer knows without
So
looking at anything
fleeing,
else?
right? Is there anything in the video that suggests that Officer Schurr knows who the driver is?
No, at that point I don't think so. I forget if Mr. Loyola had identified himself or not. He had said, he had said something. He had said he had his ID or driver's license in the car and asked the other gentleman in the car to get it or look for it or something like that. But I don't remember if he had identified himself by name at that point. I don't think he had, but I'd have to go back and look.
So the video does not reflect that Officer Schurr knew who the person was that was running?
Yeah, I think that's right.
And you would agree with me, people run in order to hide something or to evade arrest. Is that fair?
Sure, all kinds of reasons.
Was there any explanation for why Mr. Leolia shoved the officer to get away?
Any explanation from whom?
Mr. Leolia, the passenger, or anybody say, hey, what are you doing, or anything like that?
I'm not sure I understand the question, I'm sorry.
Did you hear Mr. Leolia say anything explaining his behavior?
No.
Okay, so the officer on the scene has no idea why this is happening?
Sure.
From that perspective?
Yeah.
And he doesn't know whether or not he's going to run into a house or not, right?
The officer does not know what is going to happen. Sure. But also has to base their actions on what specific and articulable facts they have to justify police action.
Now, you indicate that one of the things that could have happened by making this tactical error is the passenger could have got out and attacked Officer Schurr.
Could have, sure.
Okay, so that's one of the possibilities. That's one of the reasons you let someone go.
One of the reasons that you don't expose a vulnerable quarter, right? Turning your back to someone in the car, yes.
Okay. And so we saw some interaction between Mr. Leoya and the passenger's name is Mr. Tuyasheme, but we can call him the passenger, if that makes it easier.
It would make it much easier for me, I apologize.
Where Mr. Leoya asked for his ID, you see Mr. Tuyasheme open a glove box and say that he can't find one.
Yeah, something like that, yes.
Okay, and then Mr. Leoya is the one that shoves the officer and runs away.
Yes, certainly turns and pulls his arm. I don't know if it's like a shove push, but certainly turns and pulls away from the officer and flees, yes.
Okay, and so your concern there is not the person that just broke away from the officer, but the passenger?
The person who just broke away from the officer is not going to be in a position to threaten the officer. The person who is still in the car could be. So I am concerned as an officer with both of them, but I have a more immediate concern. So given the tactical risks and benefits of running past an occupied vehicle, I'm going to not do that. I'm going to stay with the vehicle, identify the passenger in the vehicle, and start an investigation to identify the person who just fled from my traffic stop.
Okay. So it's your opinion that no reasonable officer would have made the decision that Officer Schurr did, which was to not let Mr. Leoya run an extra 7-8 feet.
It's my opinion that pursuing Mr. Leoya on foot past the occupied subject vehicle is not tactically sound and is contrary to generally accepted police practices. It is not what I would expect a reasonably well-trained officer in that position, applying generally accepted police practices, to have done.
I just want to break that down a little bit, because I understand you're saying that you would not expect an officer to do that,
Yes.
but your opinion is that no reasonable officer would have done that.
No reasonable officer applying generally accepted practices relating to foot pursuits in this context would have done that.
Not a single one.
Not reasonably. If they did, it would be contrary to generally accepted police practices.
How about contrary to GRPD policy?
I am not an expert in GRPD policy, and that's not the standard that I'm applying.
Are you aware that Officer Schurr has been commendated for successful foot pursuits in the past by
Your
GRPD?
Honor, this was excluded before by the court, and now he just throws it out there.
I need to know what the basis of his opinion is.
Right, but he already stated what his basis was, so I'm gonna state that objection.
Okay. So now in your, you have these 7 opinions. Is that fair in your report?
Yes, with some subparts for some of them, yes.
And I believe you opined on the foot chase,
Yes.
right? And you think no reasonable officer could have arrested Mr. Leoya in that situation by continuing to pursue him, right?
Again, that's not exactly the way that I would put it, but I think no reasonable officer applying generally accepted practices would have chased Mr. Leoya and put the occupied subject vehicle behind them, yes.
And then you also talked about that Officer Schurr failed to provide a feasible verbal warning.
Yes.
But it wasn't your opinion that that failure to give a warning meant that he couldn't use deadly force, right?
No, those are separate.
That's a totally separate thing.
Yes.
Okay. And you just said that when feasible, an officer should provide a verbal warning prior to using force, including deadly force.
Yes.
And the normal context is, right, sort of a Tennessee v. Garner, police officers chasing someone down the road, and they're ahead of them, and police, stop or I'll shoot, right?
I mean, you probably don't want to shoot someone just for fleeing, but,
Well.
you know, drop the taser or I'll shoot, or So, you know, it doesn't even have to be or I'll shoot, right? Drop it or you're going to get shot, something indicating this is the clear command, this is the threat, right? This is what will happen. This is the use of force that is about to occur as a warning, yes.
Okay. And the International Association of Chiefs of Police indicate that a sufficient warning is you demand that the subject stop.
Sure, identify exactly what you want them to do.
Does it say stop running, or is it stop running or I'm going to shoot you? Because according to the International Association of Chiefs of Police, which you hold in high regard, it's just that they demand that they stop.
I do hold them in high regard, and it is going to depend, but for someone who's just running away, stop running is fine, because you're probably not going to shoot them, right? Because someone who's running away is unlikely to just create an imminent threat of death or great bodily harm. When we're talking about deadly force, identifying, or any use of force, it is typically helpful for officers to identify this is the force that I'm going to use. That way you are informing the person, 1, this is what I want you to do. 2, this is what will happen if you don't do what I want you to do. Put that down or you're going to get tased, for example. Very straightforward.
Okay, and so you're talking about, you believe it's generally accepted police practices that the officer has to give a warning, in other words, a condition of what happens if he doesn't comply with the directive.
Well, that's what a warning is, right? Telling someone stop is not a warning. Telling someone stop or this will happen is warning them of the consequence.
Telling someone to stop is a command or a directive, correct?
Sure, that's
Right.
a command, yes.
Okay, and do you recall what GRPD policy is on a suitable command before?
I think I still happen to have it in front of me. I can look it up if you want. I don't remember it offhand, but I can.
You have to give a directive before using deadly force. Doesn't say warning.
Sure, so that's not a warning, right? That's a directive or command.
Right, and so drop the taser is a directive.
Yes, definitely a directive,
So
sure.
you agree that Officer Schurr complied with GRPD policy when saying drop the taser?
Again, I don't want to hold myself out as an expert on GRPD policy, but if GRPD policy says directives are all you need to give, then sure, I suppose that is in compliance with policy. It is not in compliance with generally accepted practices relating to what a warning actually means.
Sure. Well, a warning, I would agree. There's some contingency that happens if you don't follow the directive.
Right.
GRPD policy says, and you just talked about it, whenever reasonably possible, officers shall provide verbal directives before deadly force is used. So you would agree with me that drop the taser is a verbal directive?
Sure. I have no idea how GRPD defines that directive. If they read into the word directive what I would consider to be a warning, I'm not sure, but that's why I'm not holding myself out as an expert in GRPD policies. But as a matter of generally accepted practices, if you're going to warn someone, what you're doing is you are threatening force, right? The warning is condition, threat.
Sure. That's your view of generally accepted police practices?
Yes, that is generally accepted police practice.
Do you have any idea whether Officer Schurr ascribes to your generally accepted police practices?
Well, I know he didn't in this case, but I'm not sure if he does generally.
Okay, but does he even know what they are?
I have no idea. I'm not in a position to identify what he knows or does not know, just whether his actions are consistent or inconsistent with them.
You don't expect him to know every agency's policy in the whole country?
No, certainly not.
Okay. You indicated that the reason a warning was feasible or reasonably available and should have been given, a warning, is that Officer Schurr was in a position of tactical advantage.
Yes.
Okay, can we see RFN 7460? Mr. McFarland, when we're in our office, you hit right on the number every time, and we're here.
It's the big game.
Okay. And so you indicate that Officer Schurr is behind and on top of Mr. Leoya, and therefore he's in a tactically advantageous position?
Sure. Now, I wasn't looking specifically at RFN 7460, but prior to him drawing the firearm, which I believe is already out in his hand at this point, yes, he is behind, over, partially upon Patrick, upon Mr. Leoya.
Yes, Your Honor. So as far as the tactically advantaged position though, if you don't have any feet or hands on the ground, and the person that you're on top of has both knees and both arms on the ground, do you believe that the officer is in a tactically advantageous position right here?
Again, I'm not looking at this particular frame.
No, I'm asking you about this one.
Right. If you're asking me about this particular frame, but my opinion that he was in a position of tactical advantage is not this frame specific, right? It is the events leading up to this frame. Is he in a position of tactical advantage? In this particular frame, he is off balance with his body weight, at least partially on, it looks like largely on Mr. Leoya. In that way, he is not tactically advantaged. On the other hand, he is behind Mr. Leoya, which makes it very difficult in this position for Mr. Leoya to punch, strike, or otherwise direct an attack at him. In that sense, he is in the position of tactical advantage.
And
so
you-
it's not
I'm
perfect.
sorry. I didn't mean to cut
It's
you
not
off.
perfect advantage. But even here, and certainly prior to here, he's not in that immediate position of being in physical danger.
Okay, and so you saw the video, and you saw Mr. Leoya get up 3 times when Officer Schurr was behind him or on his back, right?
Yes, earlier when they were standing kind of behind where the passenger is now out
Sure.
and filming. Yes.
And you saw Mr. Leoya bring Officer Schurr across the yard, right?
Yes, at one point on his back, there were some knee strikes thrown in as Officer Schurr followed him across the yard, yes.
Now, and since we're talking about that, one of your opinions is that the intermediate use of force, when he was hitting the knee strikes and trying to punch him, those
Yeah.
were appropriate but ineffective.
They were, yes. There was an open-handed strike. There were 3, I think, knee strikes. The tackle itself, of course, is a use of force. Divorced from the tactical point that we already discussed at some length, I thought all of those as intermediate uses of force were perfectly appropriate and reasonable and proportional and consistent with generally accepted police practices.
Okay. All right, so you also gave the opinion that Officer Schurr's use of deadly force was unreasonable, excessive, and contrary to generally accepted police practices.
Yes.
And you didn't get a chance to explain why you felt that. And am I correct that the basis of that opinion is in the absence of any physical ability to incapacitate Officer Schurr or otherwise render him unable to protect himself, no reasonable officer in Officer Schurr's position could have concluded that Mr. Leoya presented an imminent threat of death or great bodily harm?
Yes. Again, those 3 components of threat are ability, opportunity, intention. If you lack one of those, then there is no threat. There might be a risk situation, but there is no threat.
Okay, and you believe that the officer can use deadly force if the suspect reasonably appears to have the intent, opportunity, ability to cause a particular type of harm, in this case.
Can use deadly force, specifically ability, opportunity, and intention to inflict serious bodily injury or death. Absolutely.
Okay, and you consider the intent of the suspect when determining whether or not Officer Schurr acted reasonably?
It's more like I consider the perspective of the reasonable officer in Officer Schurr's position as to what the subject is trying to do. So it's not their actual intent. Who knows what their actual intent is? It's what does their behavior suggest to the reasonable officer they are trying to do.
So an officer who was incapacitated, and this goes to your opinion that deadly force was unreasonable, has lost the ability to protect themselves, including by preventing a subject from disarming them of their firearm and using it against them, right?
Sure. If an officer is incapacitated and stays incapacitated, they are incapacitated.
And here, you're worried about incapacitation because Mr. Leoya has a taser, right?
I mean, I am not particularly worried about incapacitation, but that would be one way that you could establish an imminent threat if there was
ability, opportunity, and intention.
Well, the opportunity here is a taser, right? That's what we're talking about in this opinion.
If, yes, I'm not entirely sure I follow, but yes, maybe.
Well, the basis of your opinion, that deadly force was unreasonable, is that in the absence of any physical ability to incapacitate Officer Schurr. When you're talking about incapacitation, are you talking about the fact that it's a taser?
I'm talking about the fact that there was no ability, there was no physical capacity for Mr. Loyola to incapacitate the officer with anything.
Okay, so that includes a rock or anything else?
Sure, there are no rocks that I am aware of that he grabbed or had access to or had as a matter of physical ability, let alone intention or opportunity.
So would it be reasonable, therefore, that Officer Schurr, for Officer Schurr to use deadly force if he in fact held a reasonable belief that he was in risk of being incapacitated or tased?
Okay, so what I think I understand your question. What you're asking is the threat of being tased, does that create an imminent threat of death or great bodily harm, such that the use of deadly force is then justified? For that to be plausible, the threat would have to be the subject has the taser, which is in a condition to actually incapacitate. The subject, there is at least some reason to believe the subject knows how to use the taser, like disarming the safety and using it. That the taser, which is a weapon with a less than 50% effective rate, will be effective in incapacitating the officer. That the officer will remain incapacitated long enough for the subject to access a retention holster, and that the subject will know how to remove a firearm from a police retention holster, and that the subject will do all of that in the period of incapacitation, which is either 5 seconds with a taser pull or an unlimited amount of time, I suppose, until the battery goes dead if you're holding the trigger of the taser down, which means you're doing all of this one-handed. While I think it is at least theoretically plausible that that could happen, it seems unlikely, which might be why, going back to the history of the introduction of taser use, that has never happened in American policing or internationally that I'm aware of. So I think it is theoretically possible.
I'm sorry, did you say it's never happened that an officer's been tased?
No, an officer has never been tased, incapacitated, had their weapon removed, and killed with it.
Then why do you say in your report, it is well known and generally accepted in policing that an officer who is incapacitated has lost the ability to protect themselves, including by preventing the subject from disarming them and using the weapon against them?
That's still true. That is yes, that is absolutely a risk.
All right, so the concern here is that no reasonable officer thought they could be incapacitated, right?
Yes, in my view, that's correct.
Okay, and you're saying that a taser couldn't incapacitate the officer given the situation he was in?
Yes.
Okay. Were you here for Brian Child's testimony?
No.
Okay. If he said something completely opposite, would he be right or are you right?
Well,
That's an improper question, Your Honor. A witness can't comment on the truthfulness or rightness of another witness, especially when they haven't heard anything, so it's an improper question.
I can rephrase it, Your Honor.
Right, so I'll sustain, but you can rephrase.
Okay. So you're an expert. You're not an expert on tasers, right?
I'm certainly a use of force expert, and
Sure.
Within the world of use of force, taser is one of many weapons that are used. To that extent, sure. If you mean I don't know, electrical engineer who can explain the magic that goes on inside a taser, no, in the same way that I really can't explain the magic that goes on inside a bullet to project it. I don't know what the chemical reaction is. I just know that it comes out of the muzzle of a gun, and I can, as an expert, talk about when it's appropriate to send it that way.
Are you in a position to tell when someone can be incapacitated by a taser? Are you an expert in that field?
As a use of force expert, sure, that's what tasers do, right? They are both pain compliance and motor disruption or physical disruption tools.
Okay. And in your opinion, when you believe that deadly force wasn't appropriate, you said the available evidence establishes that any reasonable officer in Officer Schurr's position would have been aware that Mr. Loyola did not have the ability to incapacitate Officer Schurr because both cartridges of Officer Schurr's taser had been discharged.
Yes.
Okay. So it's your testimony that if both cartridges are discharged, he cannot be incapacitated.
It makes it exceedingly unlikely, especially with insulated wires. Yes. And there are a number of easy tactical alternatives. If you are worried about being subject to a drive stun, that is having the taser pushed against you, you just back up, and that deprives the subject of opportunity.
Okay. So you're not, you're saying he can't be incapacitated because the probes no longer are effective?
Well, the probes might be effective, but they're also laying on the ground, having been fired at the end of the wires that they're on.
Okay, and if somebody touches a probe, and then a drive stun hits them, they can be incapacitated, correct?
If someone grabs a probe and a drive stun is applied, assuming that the subject somehow knows how to do that, and assuming that the officer grabs a probe, sure, that can result in some type of incapacitation. Again, the response is don't grab the probe or back away from the drive stun to deprive of ability or an opportunity.
If I said grab, touch, the probes are laying on the ground in this case, right?
There are probes from where they initially fired, from where Officer Schurr initially fired the taser. There are probes somewhere by where they were scuffling on the ground. So there are probes out in that front yard, sure.
Okay, and you don't think that Officer Schurr should have done a probe check before in that situation, right?
Before shooting someone? I mean, if he's going to be worried about being incapacitated, yeah, I would certainly want him to know, is there a realistic threat of being incapacitated?
Okay, so if Brian Childs, and I'm going to represent to you that Brian Childs testified, that if you come in contact with a probe and someone drive stuns you, you will suffer NMI.
You can, sure. But there are two giant ifs there, both of which are addressable without the use of deadly force and addressable entirely with tactics, right? Again, assuming that either of those ifs actually apply.
And you talked about the drive stun.
Yeah.
You're aware that the drive stun can cause serious bodily harm, correct?
It is substantially unlikely to, but it can, I suppose, when used in particular ways, in the same way that a thumb can be used to cause serious bodily harm when used in particular ways. But it is certainly not designed to and is unlikely to when used in any normal capacity.
Well, in a normal capacity is by a trained officer, right?
Usually, sure.
Okay. And you're aware that officers are trained never to hit anything in the face, right?
That unless deadly force is justified, yes, sure.
How about if someone takes your taser? They haven't been trained, right?
Sure. That is correct. So again, one, there's some likelihood that they won't know how to use it. Two, there's some likelihood that even if they want to know how to use it, they aren't going to know to drive stun you, right, to push it into you. Three, if someone does know that somehow, you just build distance, which is a pretty core tactical concept, as a way to deprive them of the opportunity to use that taser in a drive stun mode. Any of those are sort of barriers to jumping straight from someone has a taser to deadly force.
Oh, and we're talking about whether it was reasonable to be in fear of incapacitation, right? And you're saying that it's unreasonable for Officer Schurr to think that he could be blinded by a taser in that situation.
You could be blinded with a finger or a thumb. It doesn't mean every time you get into a scuffle.
Is a taser a finger or a thumb?
To the effect when it damages the eye, I don't think there's a substantial difference. If you're talking about being blinded with something, then grinding a pen or dirt or a rock or your finger into someone's eye presents the same type of threat. It's a physical contact threat, right? So if that's, the drive stun has to make physical contact. The thumb has to make physical contact.
So a thumb and a taser have the same level of threat?
I'm not sure how you got that out of what I said. When you're talking about driving stuff into the eye,
tasers present really no particularly elevated threat than jamming anything else into someone's eyeball. And it's certainly
You're
not
aware that a drive stun includes it's a tactical maneuver, but when you squeeze a trigger, an electrical charge comes out, right? You understand
Yes.
how a taser works?
Yes.
And I'll represent to you that Brian Childs said that Officer Schurr was reasonably in fear of being harmed in that situation.
Yes, I'm going to have to object. That is not at all what Mr. Childs says. He didn't give an opinion on.
He did give an opinion.
Complete misstatement of his testimony.
Well, the record will say what it says.
Right, it will, and I'll sustain that objection. Next question.
And so it's your opinion a taser could not blind you more than a thumb?
I don't understand the question. Like, you're equally blinded whether you're blinded by a thumb or a taser.
Well, the issue here is incapacitation of a taser, because that's what you based your opinion on.
So are we talking about incapacitation, or are we talking about being blinded? 'Cause
Well, you
those
said
are
pain
separate.
compliance is not enough to incapacitate, right?
Yeah, that's correct.
So if he had been drive stunned and not in the eye, then it's your opinion that that wouldn't cause sufficient pain to incapacitate the officer?
I mean, look, I drive stun myself every time I teach police law and policy when I teach a case on tasers. No, it's not incapacitating.
Well, it's not NMI, right?
That's correct. NMI is neuromuscular incapacitation.
You talked about the wires, and you said there's no reasonable fear of incapacitation because the wires are insulated in a way that even if he made contact with the wire, there's no risk of the taser causing any incapacitation.
So unlike some previous versions of the taser where the wires were uninsulated, if you got wrapped in the wires, you were going to go take a ride on the taser, right? With this version, they were insulated wires, and that is not a concern. If you need probe contact, not just wire contact.
So if the insulation had been scraped, or when it came out of the taser, had been ripped off in any way, that wouldn't cause a reasonable concern?
Sure, if there was any reason to believe that had happened, sure.
And it does happen with tasers a lot, right?
I wouldn't say a lot, but what happened in other cases is not what happened in this case that an officer would have been aware of. Again, we're limiting ourselves to the facts reasonably known or available to the officer, the reasonable officer on the scene. And I don't see anything in the evidence that suggests any reason to believe that the taser insulation had broken, cracked, or stripped in some way.
Not the fact that they're being dragged on the ground?
No.
Do you know who Brian Childs is?
In vague terms, yes.
Okay. Do you consider him to be an expert in tasers?
I've never had to make that determination, so I don't consider him anything.
And you didn't consider any of his opinions about the taser before you rendered your opinions?
I don't remember when I got his report. I don't remember when I got his report. I don't want to be unduly offensive there, sorry. It's not that I neither consider nor not consider him, if that makes sense. Like, I'm not saying he's not an expert, I'm not saying he is an expert, I'm not saying anything about him.
Well, he was the prosecution's expert on tasers. Are you aware, do you know who he is?
Again, in vague terms, but.
Do you know where he works?
No, not offhand.
He works for Axon.
Okay.
What does Axon do?
Axon makes, among other things, tasers.
Right. And he's worked there for decades.
Okay.
Would you agree with me that someone that's worked for Taser and Axon for decades would know more about tasers than you?
I think it depends on what they're testifying as. If he's testifying as a use of force expert, maybe not. If he's testifying as a mechanical expert on the taser, sure, he knows more than I do.
Right. Insulation on the wires, that sort of thing?
Sure, I suppose he could probably talk about the tensile strength of the insulation on the wires in a way that I can't.
And the ability to incapacitate an officer, right?
I don't see why he would know any more about that than I would.
Are you a master taser instructor?
No, I'm a use of force expert.
Okay. And so you think you know more about the ability?
He's arguing now. I don't know what the point is.
I want to explore what he thinks he knows and why he thinks his opinion is based on something other than his use of force. I mean, he keeps testifying that he knows about the mechanics of a taser.
Right, but you're asking him about a taser, but he's not a taser expert.
Right.
And he's a use of force expert. And so at this point, delving more into what one expert said versus what this expert is here to testify about, I do believe to be hard.
Okay, Your Honor, I understand that. I just want to, as long as the court has acknowledged that Professor Stoughton's not an expert on tasers.
I consider him an expert in the field that he is considered an expert in.
Okay. Thank you, Your Honor.
I do, Your Honor. You guys, you covered a lot of ground there. Just in terms of tactics is one of the things you talked about. Can you switch to our computer, please? And you talked about tactile advantage, and they showed up the cell phone video. This is that's theirs. Dim the lights too, please. You had an opportunity to take a look at the sequential images as well.
And this is?
Exhibit 6.
Thank you.
Yes, I did.
Okay, starting at frame 3286. Can you give the jury a little bit of background? What do you mean by tactical advantage here when you're talking, I guess, in this specific instance?
Really, in this type of context, we're talking about does the officer have more control of the individual than the individual has over the officer? In this case, the officer has a number of weapons, both bodily and other, available. It's fairly difficult for someone in the position of Mr. Loya to attack the officer in this position. So, officer has more control over him than he has of the officer. That's tactical advantage.
Now, in terms of tactical advantage, does that go into your imminent threat analysis then in terms of when you're trying to determine if a shooting was appropriate or inappropriate?
Yes.
And how does that factor in terms of imminence here?
So again, when we're talking about imminent threat, even if someone has the ability to cause some type of harm, if they do not have the opportunity to do so, then there is no imminent threat of that particular harm. So if we go back to my hypothetical about someone with the tire iron, if someone has their hand on the tire iron, but the officer is, I don't know, standing on the tire iron in a position where the person can't use it, they might have the ability, but they lack the opportunity. There's no one vulnerable to that harm. Similar concept with something like this.
I'm just going to go through these frames here. Now they talk about at this point in time, clearly the officer's feet are off the ground, correct?
They are, yes. It looks like he's swinging his right foot over from the position where it was to the other side.
How does that change tactical advantage? Does that change it at all? Does it make it more or less?
I mean, the officer is not in what I would consider to be a particularly stable position. You don't want your weight to just ride on another person because it means that they can take you in a direction you might not want to be taken. But in terms of attack, there's very, very little that Mr. Loya could do to threaten the officer in this position. They would have to get out of this position to create a position of opportunity for serious bodily injury or death.
Now, I guess we're moving along. You can see the defendant's accessing his firearm at 3356. Has the tactical position changed at all at this point in time?
The officer is in a position of greater stability. Both feet, one knee are on the ground. At least one shoulder or chest area on the left side appears to be on Mr. Loya. So there's a less risk of unbalancing here.
Has anything changed in terms of the imminent threat aspect then?
No.
Okay, we're at the 3342. Has anything changed in either part? Are you trying to speed ahead? Is there any changes between either of them in terms of the tactical advantage or disadvantage?
I mean,
That's 3442.
Again, there's clearly some potential disruption for balance, but in terms of basic positioning, no, not really.
What about now?
No, and no real change.
It's still the same tactical advantage or disadvantage you were talking about.
Yes.
Yeah, I guess I'm not gonna go through the whole video. Did you ever see the defendant in any sort of tactical disadvantage through the entire, I guess, cell phone video?
No.
You can turn on the lights, thank you. You talked about, they asked you some questions about committing a felony. He committed resisting opposing, he may have committed a felony. You weren't sure about a Michigan law, but resisting opposing is a felony in Michigan. Does committing a felony allow an officer to use deadly force?
No. No, in fact, there's a fairly famous line that's often taught in police training. It is not better for all felons to die than to escape.
So no matter how many felonies somebody commits, it doesn't mean that an officer is justified in using deadly force.
That's correct.
What about disobeying commands?
Again, absent an imminent threat of death or great bodily harm, no, merely disobeying does not establish a justification for deadly force.
So you heard him, you didn't hear him today, but you heard him in the video. Patrick disobeyed, dropped the taser, stopped resisting, disobeyed numerous commands, correct?
Yes, he did.
Does that in any way change your analysis of the ability of an officer to use deadly force?
It's certainly part of the analysis, but no, it does not change the opinion.
Just because he commands them a bunch of times doesn't mean, okay, I can shoot him.
Correct.
They talked about getting into the taser again. You said it's theoretically possible it could be disabled, but you said that it's never happened. The officer's never been killed after being disarmed with his taser in the history of the taser.
That's correct.
All right, thank you. You're out of taser.
It depends on what you mean. If you mean taser as a use of force option and weapon, yes. If you mean taser in terms of am I an electrical engineer, no, obviously no.
Now you talked about whether the officer has the right to use deadly force after a subject uses or commits a felony, correct?
I don't know that I talked about rights at all.
I think you just answered that question. Does someone have a right to use deadly force simply because they committed a felony?
I would not frame that in terms of rights. I don't think the question had anything to do with does the officer have the right to. As a matter of generally accepted practices, that is not a justification for deadly force.
All right.
But right sounds legal to me, and I'm not testifying on the stand as a legal expert here.
Okay. And you saw the videos. Did Officer Schurr pull his firearm after Mr. Leoya committed the first felony?
I'm sorry, did he?
Did Officer Schurr pull his firearm by the side of the car?
Very early on. No. I don't think, no.
Okay. And he didn't pull his firearm when Mr. Leoya refused to obey lawful commands, right?
Yes, at least not initially, yes.
Right, just the last one.
Yes.
And your final opinion about the use of deadly force is based on whether or not it was reasonable for the officer to be in fear based on the fact that whether or not he could be incapacitated. Is that fair?
I wouldn't put it that way. I would say my final opinion is about whether there was an imminent threat of death or great bodily harm.
Okay, and the threat in this case, according to your report, is that he was going to use the taser on him and potentially incapacitate him.
I think that's the argument, right? That's the argument that there was a threat, an imminent threat of death or great bodily harm because of the taser. Again, my opinion is there is no imminent threat, so I'm not sure that fully answers your question.
No, I think that I'm trying to figure out, we're talking about deadly force, and the prosecutor asked you a bunch of questions that don't really have any application here about using deadly force to arrest, or justified to arrest or in a lawful command. What we're talking about here is whether or not he was in fear of being incapacitated by the taser, right?
Whether there was an imminent threat of death or great bodily harm via the taser, sure.
Okay, thank you.
Mr. Becker, anything else?
No, Your Honor.
I don't see any hands raised on the jury. May this witness be excused?
You may, Your Honor.
Any objection?
No, Your Honor.
Thank you very much, sir, for excused.
Thank you, Your Honor.
Thanks for joining us. If you're just tuning in, we are continuing day 2 coverage of the Christopher Schurr trial. They're getting ready to take a break, and today has been a very intense day in the courtroom with Kent County Prosecutor Chris Becker and Schurr's defense team getting into 2 verbal disagreements about the legitimacy of a witness, Seth Stoughton. Now, Stoughton has made a career of studying police conduct, including misconduct. He has reviewed the case and has come to the conclusion that Schurr violated general police practices in chasing and shooting Patrick Lyoya. Take a look at this argument between Becker and Schurr's team, who preemptively tried to discredit the witness.
I'm just confused, Your Honor. And the reason is, my understanding was that Opinion 7, Officer Schurr's use of deadly force against Mr. Lyoya was unreasonable, excessive, and contrary to generally accepted police practices because he supposedly didn't know that there was a second, he did know the second discharge had been fired, and therefore he wasn't in fear of great bodily harm or death, and therefore was unreasonable. And he hasn't gone through that. He's just saying, well, do you think in general that this was excessive? But the report talks about why he thinks it's excessive.
I think the question was, would a similarly situated officer have made the same decision?
But he hasn't talked about what the situation is yet. I understand that Mr. Bloomfield's going to testify about this opinion.
So then you just want him to talk more about the situation?
Well, or which expert is going to talk about this situation? Because he suggested that Mr. Bloomfield is going to talk about the ones involving the taser, and this one does. And then Mr. Stoughton is going to talk about, I think, the foot chase and the failure to give a warning.
Mr. Becker?
Sure. You know, we can't say Officer Schurr did this. We've talked this over and over that a reasonable officer similarly situated, in his opinion, number 7, Officer Schurr.
Direct me to the page so I can.
This is page 63. 63 of this report. Officer Schurr's use of deadly force against Mr. Lyoya was unreasonable, excessive, and contrary to generally accepted police practices. So that's essentially what I asked him, except I didn't say, I can't say Officer Schurr, I have to say a reasonable officer similarly situated.
I agree with that.
And if he let me finish.
I'm sorry, Mr. Becker.
I can, just because I'm starting out with that, and then I can say, can you explain why that is? He won't let me do that because, you know, I don't have to do my direct based on what he'd like to hear first.
I agree, Your Honor.
Okay.
I'm sorry, but I thought Mr. Bloomfield was testifying about that.
Okay,
Because
so
this is
we can
based on
have-
tasers.
Right, but you
And-
didn't ask him about a taser.
He's about to.
Well, you didn't, so you're objecting about something that hasn't happened. It's like, I don't know how I'm supposed to rule on.
Well, because he's gonna give his ultimate opinion about the taser before he could establish that he's a taser
You
expert.
hasn't asked him anything about it.
It's still part of his opinion. I could not go into the decision. It's one of the things, but I don't have to get into his details of the taser. That's part of the whole thing. He's been testifying about the totality of the circumstances.
But you're okay with that question? You can answer that. The
Assuming-
question that you objected to.
Yeah, I assume he's gonna go into the opinion number 7.
Is he going to go into opinion number?
That's part of his opinion. Now, I'm not going into details with it, but that's part of the things, the basis. He did it jointly with Nick, and so they can say, okay, Nick is gonna testify to that.
Okay. So we'll have the jurors come back in. That was a short break for me.
What can, should I be able to voir dire Professor Stoughton on whether or not he's a taser expert, because that's the basis of this.
And if he asks him a question that requires a response from a taser expert, then yes.
Okay.
But that question that he just asked, I don't believe does that.
And this was just one of many tense moments in court today. Let's bring in 13 on your side, Callie Lichter, who's been at the courthouse all day long. Callie, a lot of tense moments we saw here today during the second day of the trial.
Oh, Lauren, I think tense is definitely, the best way to put this. We knew that Stoughton was going to be a controversial witness for the defense. I mean, it was a prosecution witness, but the defense was going to find him controversial since even before the trial. There was motions at hearings before the trial to try to not get him as a witness, along with Nick Bloomfield, who on our end, since we are 30 minutes ahead of the delayed stream, is currently testifying at last check before we left the media briefing room. So we already knew it might be a point of contention, but earlier today, before when Riley and I were on 13 Plus, we were talking about how, it was just the first hour of his questioning going over, can he be an expert witness? You could definitely see the defense still trying to ask that question for their line of questioning during cross-examination. They were asking him, about his previous times on local media, and if his opinion then was the same as his opinion now, if his opinion has changed, if he's still firm in the fact that this was an unreasonable, unjustified shooting. And they kept on asking him, especially towards the end there in his line of questioning, about the taser. Again, everything comes back to this taser, and Stoughton would repeatedly say, I'm not an expert on a taser when it comes to, the inner workings of the taser, the actual launch of the probes and things like that, the mechanical engineering aspect of it. But he says when it comes to the use of force, then he can confidently talk about this taser. And then you had the defense bring in some of the words from Childs earlier, who was the expert on the Axon tasers and body camera, to try to almost in a way disprove some of the things that Stoughton was saying. It was trying to say, well, this is what the taser expert says, which you go against the taser expert and what he said, something that Becker objected to, saying he can't bring in, Borgula, the defense attorney, he can't bring in the other witnesses and what they were saying. So there was controversy over that. And again, it's just everything that I'm saying and everything that you guys have watched in the past couple of hours, it's just been, a fight almost between the two sides there in the courtroom, Lauren.
It seems that the defense especially has been trying to really stick to the fine details of this case. You see them often asking questions and Stoughton repeating and saying, I'm not sure what you're asking. Can you talk about that? What are some of the questions that had that back and forth discussion with the defense and the witness?
To be honest, sometimes I even had trouble following some of those questions that were happening there. There's a lot when you're not in the courtroom and you're looking on a screen to try to follow. But it just went back to some of those questions, especially about GRPD policy. I know there was some controversy around that because one of the pieces of evidence that the prosecution was using and the defense didn't object to when they were putting it into evidence was the use of that 2017 GRPD policy that Schurr would have most likely and probably was trained under. And so there was a lot of questions that revolved around this policy, especially around foot pursuits. I mean, this is what started the whole entire incident after that traffic stop. It was a foot pursuit between Schurr and Leoya. He was pursuing Leoya on foot as Leoya was running away from the situation. And so a lot of the questions were, are you an expert on GRPD policy? Most likely, to get Stoughton to say, no, I am not an expert on GRPD policy, which he kept on reiterating throughout the hours that, he was being examined and cross-examined. He said that he was just an expert on general police policy. And that's the whole entire thing. He can't comment directly onto how Schurr was feeling, what Schurr did, because that falls into, putting themselves in the mind of the officer, and that's something I'm more than likely sure that they ruled that they couldn't do, speculate on his state of being at that time. So what Stoughton was saying was more in these generalities. When it comes to code of policy, code of conduct for police across the country, he is an expert on that. He can talk to that, but he can't talk specifically on that GRPD policy, and that was something, again, a question that we saw a lot of times when he was being cross-examined by the defense, Lauren.
And I want to ask you, Callie, about the pace of the trial now. Yesterday, we went through 8 different witnesses. At this point, for the people who are watching the stream, they've only seen 2 people for the whole entire day.
That's something that, I touched on earlier and I kind of was alluding to, but I know some people might be tuning into the stream now for the very first time. But yesterday we saw a lot of witnesses that weren't necessarily character witnesses. That's the best relation I can give right now. These were people who were there on the scene. They were Leoya's friends. They were neighbors whose yards, this incident happened in. They were giving more of like the storytelling aspect of this. What was leading up to this? What was it like in the moment, because they were actually there. And then we got to some witnesses at the end there who were kind of the aftermath. What was happening in the direct aftermath, but still, at the time that this happened, you had the GRPD, I'm pretty sure she was doing something where she had to, photograph Schurr after the incident happened. You had the MSP detective sergeant who was in charge of the case, who was looking over evidence, collecting things. But today really focused on the analysis of what happened afterwards. And I think that's why the pace has slowed down dramatically after getting through these 8 witnesses and only seeing 2 and probably a half. I could assume that Nick Bloomfield, who I'm more than likely is being questioned right now, it's probably going to go into tomorrow. It's because, again, these are the more analytical witnesses. We're going into what is happening after the fact, and they're analyzing that. So, of course, it's going to take a little more time, Lauren.
And my last question for you is, did I hear you correctly that there is now someone new on the stand, or is it still Stoughton?
Correct. At the time that we left the media room where we are in, because we can't be on the same floor as the courtroom, we have our own room with screens where we can listen to the trial, and also use electronics because there's no electronics to be used in the courtroom upstairs. There was another witness who was being called to take the stand, Nicholas Bloomfield, and he was actually working, if I also got this correct from our listening, he worked on a report with Stoughton, so they were almost like a partnership duo of sorts. And again, I'm not in there listening to the direct connection there, but that was just mentioned briefly that they had worked on this report together and that he was going to be the next witness called, Lauren.
Okay, Callie, let's get you back into the media room. We appreciate your reporting thus far. We want to go back to some of the sound we heard today. Stoughton got a chance to explain his opinion on the situation during the testimony to Kent County Prosecutor Chris Becker. Let's take a listen.
Part of that, what is the basis for you? Is part of that going to the failure to warn?
No, failure to warn is a separate issue, right? A separate inconsistency with generally accepted practices.
So why do you mention that in your opinion in terms of this failure to warn?
I'm sorry?
Why do you mention that in this opinion in terms of your failure to warn?
As a separate opinion, there is like a tactical violation, right? There's some decision or action that is not in keeping with generally accepted police practices. Failure to warn prior to the use of deadly force is one aspect, but is separate and distinct from whether the use of deadly force was professionally appropriate. That is, you could have one without the other, right? You could have a warning where deadly force is inappropriate, or you could have no warning where deadly force is appropriate, or any combination.
What about the imminent threat aspect of it? The imminent threat in this situation, was there an imminent threat?
Not, in my opinion, one that justified a use of deadly force.
Why is that?
In order to justify a use of deadly force, it's generally accepted in policing that there has to be an imminent threat of death or great bodily harm. That is, the subject has to have, or to be entirely precise, reasonably appear based on the information available, have the ability, the opportunity, and the intention to cause serious bodily injury or death. In my opinion, that was lacking in this case.
And Schurr's defense team, specifically Matt Borgula, questioned Stoughton on his position that made Schurr made a tactical mistake by chasing Lyoya. Take a listen to what he had to say in response.
And you saw, in this case, Mr. Lyoya break away from Officer Schurr.
Yes.
Okay. And that gives him the ability to run in the first place, right?
Sure. So you mean for like in the concept of threat, right? Like applying those three prongs of threat. Is that where you mean ability?
Sure.
Yeah. I mean, not to be pithy about it, but right, he has legs and therefore has the physical ability to run. Yes, absolutely.
Okay. And you're saying the decision to chase him was unreasonable?
The decision to chase him in the context of this case, where you're chasing him past an occupied subject vehicle, where you have no idea who's sitting in that car, you have no idea what evidence is in that car, you have no idea what weapons are in that car, you are going away from sort of a, if not police controlled, at least police aware scenario where you were standing at the car and looking at it, to now putting what may become an assailant at your back without even the ability to sort of keep visual contact. It's not the chase itself that's problematic, it's the context of the chase here and running past the occupied vehicle.
It's the continuing of the chase?
Yes.
Okay. So if we could look at RFN 3367.
What was that again?
RFN 3367. Okay. So this is not when the unreasonable decision was made, right?
No, I think, chasing him, it depends on where that chase goes. If the chase goes back behind the car, behind the police car, and keeps going down the street in the direction that Officer Schurr is facing there, you have the same problem. Don't chase someone away from an occupied vehicle.
Okay. So at this point, it's reasonable for Officer Schurr to make the decision to continue to try to apprehend Mr. Lyoya.
If he can do that in the context where he can keep visual contact on the car and not worry about an assailant approaching, especially undetected, sure, I think that falls within the zone of reasonableness. I also think it could fall within the zone of reasonableness to say, look, I'm not even going to scuffle with this guy, because if I do start to scuffle with him here and the passenger gets out and helps, I am immediately outnumbered, right? So again, I think the initial grabbing and this initial point is, I don't think there is one path of reasonableness there for the officer.
Afterwards, Borgula attempted to have Stoughton walk through the video and make the determination as when Officer Schurr had given up his tactical advantage. You'll be surprised to hear the moment Stoughton believes that happened.
At this point, he's still within contact of the car. We don't know which way Mr. Lyoya is going to go. This is reasonable.
Sure, he's not chasing him, I don't believe yet.
All right, we're going to play it, and you tell us when it becomes unreasonable to chase him.
Right there for sure. As soon as it's clear that he's running past the car.
Well, his car is the gray one right there. You see that?
Yeah.
Do you think he's past the car?
I think he is running past the car, yes.
Okay. So is the critical point, if he gets beyond the car, then you have to let him go?
The critical point is don't create a tactically disadvantageous situation by putting a potential assailant who has access to the car and everything in it that hasn't been cleared yet, that might have evidence in it or weapons in it or whatever. Don't put that at your back. So at the point where it looks like that might be what happens, if I, the officer, continue down this course of action, yes, you should stop that course of action.
Okay, so he should have let him go at this point.
When you say let him go, he should have not continued to chase him on foot. He should have directed his attention to the passenger That gives him a pretty high likelihood of identifying the guy who just ran away, assuming he hadn't identified him yet. And that means you can always go and get a warrant for him. So let him go. No, the law will catch up to him. It just may not be in this 5-minute period.
You're making some assumptions there, right?
Yes.
Like the passenger knows his last name, right?
Yes.
And that he has some ID, right? You're making that assumption that...
No, he doesn't have to have ID. If the passenger knows who he is, then you can start your investigation that way.
What if he doesn't know who he is?
It is possible that he gets away. But what is foreseeably likely to happen is you will probably identify him and catch him later. Now, might that not happen? Might he actually get away? Sure, that's possible. But letting someone flee from a traffic stop for an improper plate is certainly better than getting into a fight and losing, or getting shot in the back by an assailant that you couldn't keep an eye on because you were running away from an occupied suspect vehicle.
There was plenty more said today in court. We're going to be breaking that all down as court continues. Court is right now in recess. We're going to be showing that feed at this time.
Not, still not here.
Right, is there anything we need to address before the witness is here?
Not here, Honor.
For defense?
This time, right?
So, do we have ETA?
I told it 10 minutes, which was about 10, it should be pretty soon. Yeah.
Okay. So, I guess we can just continue or start back a break, because obviously there's nothing else to do other than have that witness come in, and if they're not here yet, I'll just wait here. So we'll just go off the take your seat, if you please raise your right hand, my clerk will serve you.
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may be seated.
Whenever you're ready, Mr. Becker.
Sir, could you state your name and spell it for the record, please?
Nicholas G. Bloomfield. First name spelling is Nicholas. Middle initial is G. Last name spelling is Bloomfield, Bloomfield.
Could you tell the jury a little bit what you do for a living?
So presently I'm, where I reside is in Farmington, New Mexico. There is a nonprofit, community-owned hospital where I reside, and presently I am employed there as a regulatory manager, which means I'm responsible for making sure that the organization is in compliance with all federal and state regulations.
Was that your job years prior to that?
It was not.
Okay. What did you do before that?
Prior to that, I did a 20-year career in law enforcement in the state of New Mexico, was a certified officer. I retired in February of 2023.
And in terms of what roles did you have, what departments did you work for in the state of New Mexico?
So I worked for 2 separate agencies. I began working with the local sheriff's office. After completing the academy, I was assigned to the patrol division where I worked as a patrol officer. After a couple of years, I became a field training officer where I was responsible for training new officers and making sure that they were within compliance of both organizational policy as well as their training so that they could begin practicing on their own. Following that time, I made a transfer to the narcotics division. I did 3 years working as an undercover narcotics agent, where our primary responsibilities were to identify, infiltrate, and dismantle drug trafficking organizations. Following that assignment, I promoted to the rank of corporal. Short time later, I promoted to the rank of sergeant. I was assigned to the patrol division for both of those assignments, where I supervised officers who were working on a standard patrol shift. In addition to that, during my tenure at the sheriff's office, I was a SWAT team member. I did that for a number of years, approximately 6 years or so, and then I became a team leader once I was promoted. I worked at the sheriff's office for approximately 10 years, and then I transferred to our local municipal police department, Farmington Police Department. Went back to patrol there. After being on patrol for a short period of time, I assessed for the SWAT team, was selected to be an operator on the SWAT team. In addition to that, I also went into our training and recruiting division where I was responsible for basic and advanced training. After that assignment, I promoted again to the rank of corporal and then to the rank of sergeant. As a sergeant, I was assigned to stand up a use of force investigation division within the organization. So myself and another supervisor were responsible for investigating all police uses of force within the organization. During my tenure, I reviewed approximately 200 cases. In connection with that assignment, I was also responsible for developing use of force policies and practices, as well as training related to the use of force. And following that assignment, I was assigned to a special task by the Chief of Police to reach out to and to work with academics in the field of criminal justice. Specifically, we were interested in conducting research related to a phenomenon known as contagious fire within the policing industry. Essentially, that's a situation where the question is when groups of officers are in a situation where they're applying deadly force through the use of their firearms. The question is that do officers fire rounds because they are viewing subjectively what they determine to be deadly force criteria, or are they shooting because other officers are shooting? And so again, the term that is used within the industry presently is known as bunt shooting or contagious fire. And so I was able to reach out to some academics and partner with them from the University of New Haven and conducted research. And so I kind of finished up my time working that assignment as well as a patrol sergeant before I ended up retiring in February of 2023.
Take a little breath there and grab some water.
Thank you.
You just landed from New Mexico too, didn't you?
I did. And I'm tired. No.
So I guess in terms of the use of force, primarily what you're here for, the use of force, how long exactly were you part of the training, training unit, if you will, for use of force with your department?
So assigned specifically to that role, I again did a number of iterations within the training division, both as just a training officer as well as supervising that division. Throughout that time, there was there's 3 periods of time during my career where I was specifically involved in training officers related to the application of force, and that ranges through all force options that officers generally have within the industry. Officers have a variety of force options which are available, and so they exist on a spectrum ranging from low-level applications of force all the way up to what we term deadly force. And so you have essentially empty hand techniques at a lower level of force, which is essentially things to overcome low levels of resistance that an individual may be demonstrating, like resisting being placed in the handcuffs, resisting an officer's attempts to stop their freedom of movement, things of that nature. And in addition, going forward from that, there's another type of empty hands, which is kind of classified as like a hard hands, which would be like hard strikes. And those things are used, again, more for higher levels of force, where a subject may be demonstrating combativeness or aggressiveness towards an officer. All those things together fall into a category of what is commonly termed in the industry as defensive tactics. And so the defensive tactics, once you get out of defensive tactics, then you start getting into officers' actual tools that they have available. Generally speaking, the most common tools employed by policing within the United States are OC spray, commonly sometimes referred to as pepper spray. Then from there, you have a baton. There's different types and makes of batons, but essentially batons kind of fall under the same category. From there, you have electronic control weapons. The most common one within the industry is the Taser, which is a proprietary electronic control weapon made by Axon. You also have canine deployments as well, where officers sometimes will use canines that are trained specifically to be used in force applications. And then in addition to that, you have deadly force, which is the most common form of, or the most common way that officers are taught to employ deadly force is through the use of their firearms. So again, these exist on a spectrum. And so in each one of these areas, I was responsible during my tenure as a use of force trainer and investigator to develop policies related to these things that are consistent with current industry practices and standards, as well as to develop a training curriculum for officers so that they could develop core skill competencies in these areas.
Now, in terms of training, did you only train officers in your New Mexico department, or have you been involved in training other officers as well outside of your department?
So since approximately 2007, I have in addition to practicing in law enforcement, I am a full partner in a training and consulting company, Progressive Combat Solutions. My partner is Kenneth Good. He's a former Navy SEAL. And we have trained thousands of officers, both at the state, local, federal level, all across the country, related to these areas, use of force. Primarily what we're known for is training officers in the area of tactics, related primarily to generally what a SWAT team or a specialized unit would do within law enforcement. In addition to that, I've been retained by other agencies to assist them in use of force policy development, as well as teaching administrators how to review force applications within their agencies to make a determination of whether or not the actions of their officers were consistent or inconsistent with their organizational policies. And so my work has, again, taken me beyond just my local police agency that I work for.
Okay. And now in terms of when you talk about doing the different trainings, can you give an idea how many times, I mean, with your department, outside of that, how many different trainings can be done for various officers across the country? Ballpark.
I don't know if I could even ballpark it. Numerous, like I said, since 2007. You know, thousands of officers. I would say less than 50, somewhere between 30 to 50 agencies. And again, when we conduct trainings on my specific CV, you won't see that many trainings outlined, but at these trainings, they're typically regional. So we'll have officers that will come from, up to a dozen different agencies that will send participants there.
Okay. Just in terms of, you talked also about doing use of force, like 200 use of force reviews. Were those use of force reviews simply for your department, or those other use of force reviews?
The 200 use of force reviews that I conducted were for the department, approximately 200. Outside of that, since 2020, I began having attorneys and police organizations reach out to me and ask me to review cases involving police officer force applications. To date, I've been involved in I've been retained in, I believe it's somewhere around 24 cases that I testified in all across the country. And so, again, these are outside or beyond just my work that I did.
So, just so I understand, because the 200 were just within your department originally, and then there's 24 on top of that?
Yes, 24 where I was actually retained as an expert witness.
Gotcha. In terms of the 200, when you're looking at your department, what were you looking at for specifically when that was part of your job? What were you looking for in those instances?
So when you're conducting force reviews, I think it's important to understand that there's different types of reviews that are being conducted. When you are looking at an agency, you're essentially conducting a review to determine whether or not the officer's actions were consistent or inconsistent with organizational policy. And so that was my primary focus while conducting reviews for the Farmington Police Department. That's also what I trained other agencies to do as well. Beyond that, when you start getting beyond that, again, there's different standards that you could review a case. In my work as an expert witness, that review is essentially to determine whether or not the actions of an officer were consistent or inconsistent with generally accepted police practices.
Okay. And could you go into that? We've heard a little bit, but what are your definition of generally accepted police practices? How would you define that, and where does it come from?
So if you look across the country, there's approximately 18,000 police agencies within the United States, nearly 1 million officers. And so within the industry, there are generally accepted practices where essentially anywhere that you go in the country, you will see similar practices in the way that officers are taught to apply force, as well as the training that officers go through. One of the most common examples I could probably give you would be something like a traffic stop. It doesn't matter where you go in the country. If you see an officer conducting a traffic stop, the techniques, the tactics that officers employ are essentially going to be similar anywhere you go in the country. The way that this information gets disseminated across the country traditionally within the United States, this was done through just sharing trade knowledge. And so officers would essentially, through experience, begin to share trade knowledge with one another. Eventually you had more legitimate trade publications that would come along within the industry that would share essentially this type of information. From there, you started to have expert bodies that began to opine on generally accepted police practices. For example, the most well-known and prolific entity within the United States is the International Association of the Chiefs of Police. They're over 100 years old. They're well respected within the industry, not just nationally, but internationally as well. They provide things such as model policies, as well as a number of recommendations related to training and standards that law enforcement agencies can adopt and utilize to make sure that they're operating, again, in compliance with generally accepted police practices. From there, you have other entities, including the Department of Justice. So the Department of Justice has an enforcement arm where they essentially are able to investigate police organizations where there have been complaints of essentially patterns and practices of unconstitutional policing conduct. And so the DOJ can go into these agencies, essentially conduct an investigation. If they determine that there are deficiencies by that agency, that again, they're not meeting generally accepted police practice, that would legitimize them as conducting constitutional policing, they will essentially sue them and can place them under consent decree. They always keep this stuff very transparent. You can go online and you can look up any of the consent decrees that agencies have been placed under. Where I did my law enforcement career in the state of New Mexico, Albuquerque Police Department was placed under consent decree in 2012. The interesting thing about the Albuquerque Police Department consent decree was, unlike other consent decrees in the past, this was the first time that the DOJ heavily cited use of force issues in policing, and essentially what they held Albuquerque PD accountable to was a signal to the whole industry that those standards are essentially what the DOJ considers the industry standard for constitutional policing as it relates to the use of force.
Okay. Now, I guess in terms of, does that, because you retired, you said you retired, and you were retired for a few years, and now you're doing compliance things with a hospital or a nonprofit hospital.
Mm-hmm.
Do you keep up to date then? Is that how you keep up to date, is right where you do consent decrees, or are there other ways you keep up to date in the use of force area, since you kind of retired from the police officer as a police officer?
So I continue to stay up to date. I'm presently still practicing in law enforcement. There's a small agency within the area where I reside. It's named after me. It's the Bloomfield Police Department. It's not, but
They didn't name it after you joined it.
No. But I am a reserve officer. And so through that, I still continue to practice. I volunteer my time and assist agencies, but also through doing work like this. I keep up to date again with the generally accepted practices through continuous review of trade publications. Like I said, there are trade publications that are used heavily in the industry. One example is Police One. They've been prevalent in the industry for many years. And again, that's a place where a lot of trade knowledge is shared. In addition to that, I continue to follow IACP as well as my colleagues that are also expert witnesses. We have essentially a large group communication where anytime there's new research or things that is coming out involving police standards or police use of force, we typically start a dialogue and see if that information impacts the way that we do this work. So.
And this time I move for his admission as an expert in generally accepted police practices and use of force tactics. An expert in generally accepted police practices, right? Maybe just police practices. I probably kind of got in my head. Police practices in defensive use of tactics.
I'm sorry. First you said use of force in police practices, but you meant.
Sorry?
You said you moved for his admission as an expert in use of force in generally accepted police practices.
Police practices.
And then you said police practices and tactical something.
In a long day. So just police practices and use of force.
Okay. Any objections?
Limited to that, Your Honor. Can I ask a few questions? identify the witness? Yeah, so just before I. Good afternoon. I understand you had a heck of a time getting here, so I appreciate. We were all wondering if you're going to show up with a suit and tie on. So we would have forgiven if you had showed up in jeans and tennis shoes.
Thank you.
So police practices. You're an expert in police practices, not GRPD police practices, right? GRPD is Grand Rapids Police Department.
Say that one more time. I am an expert, I think I'm tracking, I am an expert in generally accepted police practices, yes. Specifically GRPD, I would say no.
Okay. And same question for use of force policies. You're an expert on the use of force in relation to generally accepted police practices, but not necessarily specific to Grand Rapids Police Department?
That is correct. What I will state, just to add a qualifier there, is that during my review of the materials in this case, I was provided the policies of Grand Rapids Police Department related to use of force, and I determined that the policies of the Grand Rapids Police Department are consistent with generally accepted police practices.
Oh, all of them?
The ones that I reviewed, yes.
So you didn't review every single policy?
I can't recall right offhand every single policy I reviewed, but the ones that were provided to me.
Okay. All right, Your Honor, with that caveat, you may proceed, we don't object.
All right, then he shall be considered an expert in those fields of use of force and police practices.
All right, you were hired specifically to review this case, correct?
That is correct.
Do you recall approximately when that was, when that took place?
I don't recall it after
It's been a few years.
It has been a few years, yes.
What do you do when you get hired in to take a look at a case? What transpires? How do you start that review?
So generally speaking, all these cases involve some type of preliminary discussion where I'm essentially provided a brief synopsis of the case. There may be a discussion as far as where I provide my CV and what type of expertise I can offer. If an entity decides to retain me through a formal retainer, at that point I'm provided materials. Materials varies based upon the organization. I've had some cases, and again, sometimes this is just due to the nature of the incident itself. Some incidents simply consist of just reports by officers of witnesses, where there's no video, there's no additional information. Others, there's extensive multimedia in the form of video, audio recordings, things that can assist in the review. So it varies from case to case. But essentially, I rely on whichever entity is retaining me to provide me with the materials. I take those materials and I conduct an extensive review. My purpose in the review is to try to essentially determine what the facts are within the case. Once I have the facts laid out, I typically go back and to those who have retained me and essentially just go through to make sure that my understanding of the facts is consistent with their understanding of the facts, so that we're all on the same page. And then from there, I'll begin to formulate opinions based upon the actions of either a solo officer, or sometimes these incidents involve multiple officers. And as I work through these opinions, what I'm doing is I'm comparing again the actions of the officers to generally accepted police practice. And what I'm basically stating is whether or not the actions of the officers are consistent or inconsistent with generally accepted practice.
Now, you talked about some of the things you reviewed for this case. Some of the things that you did review would be the videos.
And that is correct.
What videos do you recall that you specifically reviewed?
There was a couple of videos. There was a video that was captured by the officers in-car camera. There was body-worn camera footage that was also captured by the officer's body-worn camera. And then there was cell phone footage that was captured by a bystander.
Okay. I'm going to go to maybe start out. We can switch it to our side. Try exhibit 2, please. Exhibit 2. You did one, please. There should be a laser pointer right there. Right. Now, in terms of, do you recall viewing this with the People's Exhibit 2 at right about 2:02 of the time frame? Do you recall viewing this video?
I do.
This would be the in-car video.
It appears to be the in-car video, yes.
Now, in terms of use of force, you talked about some uses of force. I'm going to play this for you a little bit. Stop right there. Yeah, you talked about techniques. Now, the techniques here, what techniques did you see that were being used specifically in this instance?
So a couple of things here. When it comes to officers applying force, there's essentially two kind of categories. There are improvised techniques, which are essentially untrained techniques or techniques that an officer, where it doesn't mean that those techniques are not reasonable to be used, but at the same time, they're not necessarily formally trained, like in a defensive tactics setting. And then there are techniques that officers are generally trained in. So I see a combination of those two things. So let me give you an example of an improvised technique. If an officer is engaged in a foot pursuit, in order to terminate that pursuit, they may choose to essentially tackle the individual that's fleeing from them. I don't know of any law enforcement agency that trains officers to tackle formally because, again, the likelihood of injury would be too high in most cases. However, when you look at proportionality as far as the level of resistance that an officer is witnessing, that could be absolutely reasonable. It's just not formally trained. As far as what I see as being formally trained here, is the officer in this particular instance is applying some knee strikes. Knee strikes are a commonly taught defensive tactics technique within the policing industry. Knee strikes can be used defensively, so they can be used by an officer to essentially protect themselves if they are being attacked, but they can also be used to overcome levels of resistance. And so in this particular case, the officer appears to be in a position where he is essentially on top of Mr. Lioya. In this particular instance, attempting to keep Mr. Lioya down on the ground. Mr. Lioya is clearly being successful in being able to rise to his feet. And so the officer is electing to use knee strikes in this particular case. It's difficult to see where those knee strikes are being applied. Generally, in order to overcome a level of resistance, knee strikes are generally taught to be used by officers to target essentially the lower extremities, like the thighs and those areas. Again, because it's not being used necessarily in self-defense in an instance similar to this one, it's being used to overcome that resistance. And so I see the application of a couple of knee strikes here, which appears to be targeted to the lower extremities.
And so that would be typical. There's nothing untoward about it. There's nothing wrong with that. That would be a typical thing that you would teach as a use of force.
Yes, based upon this video and based upon, again, the way that officers are taught this technique and how to deploy it, I would say that an officer in this situation, that this application of force would be reasonable and consistent with generally accepted police practice.
Maybe focus on a little bit more. I'm going to stop it here, Your Honor. Yep, this is Exhibit 3. I'm going to start at right about 2 minutes, I think. I can't read. 2 minutes. Now here, a little bit more focus on the hands. You can see the hands. Can you describe for the jury what they're seeing here?
So in this instance, the video appears to show that, again, Mr. Lioya is down on the ground. He's attempting to get to his feet. The officer is on top, attempting to control him. So it's common within the industry that officers are taught defensive tactics related specifically to working with individuals on the ground who are demonstrating resistance. again, you have two different areas on the spectrum. One is to overcome resistance, the other may be defensive. So recently, within the last, since I've been in law enforcement over the last 20 years, grappling, jiu-jitsu, those techniques have been heavily adopted within the policing industry all across the United States. The comprehensiveness of an officer's training in that area may vary, but at the same time, officers are taught grounded techniques of how to control subjects who are resisting, as well as how to actually defend themselves if they find themselves under attack, well grounded. Here in this particular instance, everything that you see in terms of hands being placed to attempt to keep Mr. Luoya on the ground, I would classify this as essentially, again, just techniques that officers are generally taught. A little bit of improvisation also appears to be occurring here, but the positioning and everything that the officer is attempting to do, again, I would state that an officer in this instance, that all of these applications of force in an attempt to keep Mr. Luoya on the ground would be reasonable and consistent with generally accepted practice.
Now, we're going to move along a little bit. At some point down there's a taser introduced. Is that a fair statement?
Yes.
I think we're still in Exhibit 3, right? Okay, there's a taser introduced. Could you give the jury a little bit in general, in training and generalized general police practices? When do you introduce a weapon? When is there any criteria? Can you give a jury an idea of what goes through that?
So, as I briefly talked about during my initial questioning, officer use of force exists on a spectrum, and so officers have many force options that are available to them to overcome resistance. I need to talk just a little bit and lay a little bit of a foundation in terms of how an application of force, what essentially allows an officer to make a decision from going from a lower level of force to a higher level of force. So the first thing is proportionality. And proportionality, we primarily first want to talk about levels of resistance or aggression that may be exhibited by an individual. So when an officer has essentially a valid legal reason to detain an individual, whether that is to detain them to investigate a crime or to detain them, essentially taking them into formal custody, if an individual resists the officer's actions, the degree of resistance that they exhibit is what opens up the options related to an officer's use of force selections. And so at the lower end, if an individual is displaying a low level of resistance, maybe they're passively, or they're walking away from the officer after the officer's told them that they're not free to leave, or they attempt to lay hands on an individual, tenses their arms, flexes, pulls away, things of that nature. That would be low level resistance. And the thing is, again, I think it's important to understand that the term resistance is key. Resistance does not suggest that an individual is trying to harm the officer, but they are simply, trying to resist an officer conducting a lawful objective. And so from there, we get into what would be constituted as aggression, where somebody is actually physically trying to harm an officer. Harm can come in all different ways. Physical assaults, an individual could attempt to use a weapon on an officer, things of that nature. So then when you get into that area, now we're looking at much higher levels of force that would be appropriate to be used. And then eventually we'll get to the application of deadly force. In this particular instance, so when electronic control weapons, and this is a Taser 7, this is the same model of Taser that I carried towards the end of my career. The Taser, when it initially arrived and became prolific, it was in the early 2000s roughly, and it became more and more common within the policing industry. The Taser has a couple of different options available with it. So first and foremost is the proprietary nature of the Taser that Axon developed was the Taser was capable of achieving what is known as neuromuscular incapacitation, or NMI. Essentially, NMI, if you've ever seen somebody actually be tased with a Taser, it manifests that NMI has been achieved by watching somebody essentially lock up, where essentially they've lost motor control for the period of time when they are under a cycle of the Taser. And again, this is going to get a little detailed, but it's important I have to again lay this foundation so we can understand when the Taser would be appropriate to be used and where it kind of lies as a force option.
Objection, Your Honor. This is all about expertise in tasers, and I don't believe you've been qualified as an expert in tasers.
It's not about tasers, it's about what he just said, when the tasers are appropriate as a use of force option. So he's trying to talk about when a taser can be introduced. He's not talking about the specific instances of taser, it's just when it should be introduced in the spectrum of what an officer has.
Okay, so I'll overrule the objection because I do believe he's testifying about it in the use of force context. You may answer that question.
So yeah, just going into it in terms of, trying to get into how is it determined appropriate when you have other options, you have baton, OC spray, Taser.
So going back to the Taser, so the Taser is capable of achieving neuromuscular incapacitation, or NMI. In addition to that, it also has the ability to not create NMI, but essentially operate off of the principle of pain compliance in what is commonly referred to as drive-stun mode. So if you essentially remove the cartridge or the multi-cartridge from a Taser, this particular model of Taser has multiple cartridges. There are essentially probes that are on the end of the Taser, where essentially you can contact somebody with that, pull the trigger of the Taser, and it'll cycle. This is not achieving neuromuscular incapacitation. This is just achieving pain sensation, and so it's known as pain compliance. OC spray also operates off of the principle of pain compliance. And so when an officer applies OC spray, it's essentially you're relying on how susceptible the individual is to that burning sensation in terms of how effective it's going to be. So you may have individuals that are sprayed with OC spray where it's highly effective. You may have individuals where it's as if nothing happened. And so just wanted to clarify that those are kind of the two different ways that this tool can be used. There's kind of a third one, which I won't get into. But essentially, at the lower level, because drive stuns operate off of the principle of pain compliance, that is considered a lower level application of force than a full probe deployment. So when an officer actually has a cartridge attached, there's two probes that fire out of the end of the cartridge. Those probes, if there is a successful spread in those probes, that's the highest likelihood that NMI may be achieved. And again, it's not always a guarantee. There's a variety of things that could happen that could impede NMI from actually occurring. But when you see an officer deploy the Taser in probe mode, the goal or the intent is that NMI is going to be achieved through that. And the other thing is that what probe mode allows you to do versus drive stun mode is you can actually attempt to energize a subject from a distance. Okay, depending, these cartridges come in different lengths, and so you have 21-foot cartridges. You can get longer cartridges, which are sometimes used for specialty situations. So again, going back to when it is appropriate. So an individual that is demonstrating active resistance towards an officer. Now, here's where I'm going to talk a little bit about differences in industry standard. There are officers throughout the country which train officers, and it is also within their organizational policy that a drive stun can be used to overcome lower levels of resistance, again, operating off the principle of pain compliance. When it comes to the actual application of the taser in probe mode, again, that can be used for higher levels of resistance. And in this particular case, what makes this decision of the officer to deploy the taser appropriate is the fact that the taser, or that the officer, excuse me, has already used other lower levels of force in the form of what we've already seen, empty hand techniques, trying to keep Mr. Loya on the ground, knee strikes, things of that nature, and those things have failed. And so there is a principle in policing where if a lower level of force, and this is generally going to be within the spectrum of all levels of force that are less than deadly force, that if those levels of force fail and the individual is continuing to display resistance, the officer can escalate their application of force, which appears what is happening in this particular instance. And so again, an officer in this case choosing to deploy a taser in probe mode, although I would say that the method of deploying it is tactically unsound, but the decision to actually utilize a taser would be consistent with generally accepted police practice.
In terms of, you talk, are OC spray and taser, you talk about the same thing, are they on the same level, I guess, of force?
They're not. They are not, but again, let me clarify that when you talk about the taser being utilized in drive stun mode, not in probe mode, the drive stun mode, because it operates off the principle of pain compliance, could be categorized essentially alongside OC spray in that sense. Generally speaking, tasers are considered a higher level of force application because the intent of the manufacturer, as well as the opinion of expert bodies within policing, a probe mode deployment is considered a higher level of force on the spectrum than OC spray would be.
Okay. Now you mentioned though the decision made to use the taser is appropriate within the spectrum, but tactically there's an issue here. What do you mean by that?
So when it comes to the application of force, but also when it comes to police activity in general, police throughout the nation are essentially taught tactics. Tactics fall under what we generally categorize as officer safety. And so essentially officers are taught in the basic academy, and this is consistent all across the industry, where officers are provided common tactics of how to safely go about accomplishing their lawful objectives. I mentioned traffic stops earlier. Everything that an officer does, from the positioning of their vehicle to where they choose to make a stop, if it's within their power to do so, to the way they approach a vehicle, that is all done with purpose and intent. And it's done so to not just protect the officer, but also to protect the individuals that they're contacting, as well as other bystanders that may be in the area. Essentially what we talk about when it comes to police working and accomplishing their objectives, there's always risk involved, right? There's always risk involved in this type of work. However, through sound tactics, if officers rely upon sound tactical principles in the way they go about conducting their work, they can prevent risks from manifesting as threats, and from threats, if there is a threat present, potentially manifesting as harms to the officer or others. And so again, tactics are very key in this whole conversation about the application of force. So in this particular instance, The issue as far as, well, the selection of the taser was an appropriate selection and an appropriate option at this point to overcome the level of resistance that was being demonstrated by Mr. Loyola. Officers are taught within the tactical arena as well as in defensive tactics something that we term weapon retention. So weapon retention is a key principle where essentially if you're going to employ a tool on an individual, part of your calculus in choosing to deploy that is you also want to make sure that that tool cannot be taken from you and potentially used against you or others. This is really prevalent when it comes to police firearms. There are many case studies out there where officers have been killed with their own firearms, have been successfully disarmed. This also applies to every other force option that an officer has at their disposal: OC spray, baton, taser, etc. And so officers are taught techniques and tactics to essentially retain and keep their weapons. In this particular instance, there's two things about the taser deployment here. If the taser is going to be deployed in probe mode, the manufacturer, and this is common in, because the training that officers receive as far as as taser goes is consistent throughout the industry, because taser actually provides the training to police agencies. And so according to taser themselves, in order to have the greatest likelihood that when the probes are deployed that you're going to get a far enough spread apart and get what they essentially term splitting the hemispheres, which is where you have a probe, the belt line, you view the waistline as the hemisphere. Having a probe, one probe above and one probe below in large muscle masses is going to give an officer the highest likelihood of achieving neuromuscular incapacitation. In order to get that spread, you have to have distance between you and the target. And so generally speaking, that distance, again, needs to be, what Taser recommends, roughly 7 yards to get that accomplished. So two issues here is deploying a taser this close when the environment does not force an officer to have to deploy the taser this close, meaning that in a confined space where the environment precludes an officer from being able to create space to do this, that's one thing, but that's not this particular instance. The officer has the ability to create distance and
Let me stop you right there real quick.
Yes.
And I just want to get into that distance aspect. Is distance only with the taser, or are there other things in police, defensive tactics where distance is important too?
So distance is always important. It is one of the largest factors when it comes to these type of confrontations. Time and distance are the two biggest factors. So we talk in policing, it's not always about creating distance, it's about creating the right distance. Sometimes the appropriate answer is to close distance. Sometimes the appropriate answer is to create distance. Depends on what the force option is, it depends on what the situation is. Officers are also taught that if they are in a situation where they're applying force, and generally this happens solo, if they are unsuccessful in overcoming an individual's resistance, and they are essentially failing to overcome that resistance, sometimes the best option is what we refer to as a tactical retreat, where we create more distance, we keep eyes on, we summon more resources. That could be an option. The other thing is if an officer is being attacked, if they have the ability to create distance, they can do so. And so again, it's multifaceted in terms of what may determine that.
So going specifically to this instance, so it's distance not only for the taser, but there's also distance just in general for police practices.
Correct. And so in this case, by creating distance, that would allow two things to happen. One would be there'd be a higher likelihood that neuromuscular incapacitation is going to be achieved, because now we're at a appropriate standoff distance recommended by the manufacturer that's going to give us the greatest likelihood of achieving NMI. Number two is I'm also, by creating distance, I am preventing anybody from grabbing a hold of the taser, so that's also the best option because it's the most tactically sound option. And so that's why the failure to create distance in this particular case is tactically unsound, although the decision to employ the taser was reasonable.
So disengagement is part of police training. Is that part of police training and generally accepted police practices?
Yes, it is.
It's not a matter of you being a coward or running away or, you know.
No, what we find statistically speaking, again, is when an officer essentially is in a situation, and again, it depends on the circumstances, right? So let me qualify this by making the statement that the highest priority that American law enforcement has is the protection of life. That is the highest priority. So if you have a situation such as an active shooter, an active killing event, officers are taught to close the distance immediately with haste to essentially locate pressure and stop the action of the shooter or whatever it is that's preventing imminent threat of harm to life being lost. That just doesn't fall on the part, that just doesn't mean officers, that also means bystanders. In addition to that, officers are also concerned about preserving the life of the individuals that are resisting them, that they're attempting to take into custody, or that are involved in some type of law enforcement action. And so what we find is that, again, because we have enough data points within the industry and enough experience within the industry, we know that sometimes a tactical retreat is actually the safest option for the officer. It's also the safest option for the suspect. It's also the safest option for bystanders. And again, sometimes you get into a situation where, you know, for lack of a better term, you may be in over your head where you don't have the resources to safely do this alone. Foot pursuits are a big example. It used to be in the industry that you know, foot pursuits were very commonplace. Officers would take off solo, and we had a lot of instances of officers being seriously injured or killed, as well as suspects. Now, the generally accepted practice, and again, this has been recommended by all kinds of expert bodies, it's very common within the industry. The officers need to make a good tactical decision as far as when to pursue and engage in a foot pursuit, particularly solo. That would depend on the nature and severity of the crime. Sometimes it's just not worth it for low-level crimes to initiate in a pursuit, especially where officers may be placed in greater jeopardy by initiating in that pursuit. Officers are taught as another option to essentially keep eyes on, continue to follow from a distance, but to summon other resources and essentially close in and wait till other resources arrive. And again, what we find in those cases is a reason why that direction has changed in the industry is because we find that officers, suspects, and bystanders are safer as a result of that type of disciplined decision making.
Can I ask, I see it's 1:45, I can see the clock, so.
Yeah, so we're gonna stop here and resume to trial morning at 9 a.m. And so meanwhile, jurors, please again leave your notes upside down in your seats and remember to not discuss the case with each other or with anyone else. And also avoiding media reports about this case and
And that concludes the second day of the trial of Christopher Schurr, a very tense day in court today. Unlike the first day, instead of seeing 8 people, we only saw 3 witnesses, but plenty of questioning information in those witnesses. The coverage does not stop here. We will continue to break down what we saw in court today, not only in our evening shows, but on Evening Plus. Please tune in for more.